ಸಾಹೇಬ್ರು ಬಂದ್ಮೇಲೆ ಕೊಡಿ. ಇದು ಕಟ್ಟಿ ಹಾಕಿದ್ದಾರೆ. ಪೇಜ್ ಬರೆದ್ರೆ ಆ ತಪ್ಪಿಗೆ ಹಿಂಗೆ ರೈಸ್ ಆಗುತ್ತೆ.
Stream ಆಯ್ತು. ಆಯ್ತು ಕೊಡಿ, ಮೆಮೋಸ್ ಕೊಡಿ. ಬರ್ತಾ ಇದೆಯಲ್ಲ, ಪೋಸ್ಟಿಂಗ್ ಆಗ್ತಾ ಇದೆಯಲ್ಲ. 15/7 ಯಾವ್ದ್ರಿ? ಪೋಸ್ಟ್ ಆಗ್ಬೇಕಾ ಏನು? ಮೆಮೋ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ, ಆಯ್ತು ಬರುತ್ತೆ. ಮುಂಚೆನೆ ಹಾಕ್ಸಿ, ಪರವಾಗಿಲ್ಲ. ನನ್ನ ನಂಬರ್ ಇದ್ರೆ 15/7 ಬರ್ಕೊಬಿಡಿ ಮೇಡಮ್. ನಂಬರ್ ಗೊತ್ತಾಯ್ತಾ ನೋಡಿ. ನಂಬರ್ ವೇಟ್ ಮಾಡಿ ಕರ್ಸ್ತೀವಿ. ಪೇಜ್ ವೈಸ್ ಮೆನ್ಷನ್ ಮಾಡಿ.
ನಂಬರ್ 70, 69,
69,
70 to 75,
68 ಏನಕ್ಕಿದೆ? ಅದಾಗಲೇ ನೆನ್ನೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿಲ್ಲ. RP ಸೋಮಶೇಖರ ಯಾವ್ದಾ? ಅದರ್ ಸೈಡ್ ಯಾರು? ಅಭಿನಯ್ಗೆ ಹೇಳಿದಿರಾ? ನೋಡಿ, ಅಪನೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 times and also submits that already intimated the other side counsel. Is this matter on? ಯಾವ ಫಸ್ಟ್ ವೀಕ್? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಯಾವ್ದಾರು ಒಂದು ಡೇಟ್ ಕೊಡಿ. 11/7. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ? ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್. 75 ಹೇಳಿ ಏನು? ಹೇಳಿ. ಏಕೆ ವೈ ವಾಂಟ್ ಟೈಮ್? ನೋ ಡೇಟ್ ಮೇಡಮ್. ಅದರ್ ಸೈಡ್ಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿದೀರಾ? ಮಾಡಿಲ್ಲ, ಮಾಡಿ ಫಸ್ಟ್, ಆಮೇಲೆ ದೆನ್ ವಿಲ್ ಕನ್ಸಿಡರ್ ಯುವರ್ ರಿಕ್ವೆಸ್ಟ್. ಇರ್ರಿ, ಕರೀತಾರೆ, ಒಂದ್ ನಿಮಿಷ. 70 to 75 ಕರೆದಿದ್ದಾರೆ.
76 to 80,
77 ಹೇಳ್ರಿ. ಏನ್ ಜನಾರ್ದನ್ ಜಿ ಎನ್ ಹೇಳಿ, ಏನಾಗಬೇಕು? ನಾನ್ ಕಂಪ್ಲೇನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಆಫ್ಟರ್ ರಿಕಾಲಿಂಗ್ ಆಗಿಲ್ಲ ಅಂತ ಬಂದಿದೆ. ನೋಡಿ, ಫಸ್ಟ್ ವೆರಿಫೈ ಮಾಡಿ, ಆಮೇಲೆ ನೋಡೋಣ. ಅಲ್ಲ ರೀ, 2018 ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಸ್ಟಿಲ್ ಯು ಆರ್ ಸೀಕಿಂಗ್ ಟೈಮ್. ಅಡ್ಮಿಷನ್ ಬಂದ್ರು, ಡಿಸ್ಮಿಸ್ ಆದ್ಮೇಲೂ, ರಿಕಾಲ್ ಆದ್ಮೇಲೂ ಮತ್ ಟೈಮ್. ಫಸ್ಟ್ ಕಂಪ್ಲೈ ಮಾಡಿ, ಆಮೇಲೆ ನೋಡಿ ವಿಲ್ ಸಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 80. ಹೇಳಿ. ಕುಮಾರ್ KR. ಹೇಳಿ, ಏನಾಗಬೇಕು? ಮುರಳಿ BS ಅವ್ರಿಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿದೀರಾ? ಮಾಡಿದಿರಿ. Appellant counsel seeks time and also counsel submits that already intimated counsel Murli BS KVAR. And hence this matter on
22/7.
22/7 78 ಹೇಳ್ರಿ ಲಾರ್ಡ್ ಏನೋ ಲೋಡ್ ಮರಿಯಪ್ಪ ಹೇಳಿ ಏನಕ್ಕೆ ವೈ ಯು ಒನ್ ಟೈಮ್ ಅದರ್ ಸೈಡ್ ಶಂಕರ್ ನಾರಾಯಣ್ ಭಟ್ರಿಗೆ ಹೇಳಿದಿರಾ ಮಾಡಿದಾರೇನ್ರಿ ಕರೆಕ್ಟ್ ಗೊತ್ತಾ ನಿಮ್ ಪ್ರೆಸೆನ್ಸ್ ಅಲ್ಲಿ ಮಾಡಿದಾರಾ ಅಪ್ಲೈಂಟ್ ಕೌನ್ಸಿಲ್ ಸಿಕ್ಸ್ ಟೈಮ್ ಅಂಡ್ ಆಲ್ಸೋ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ಸ್ ಅವ್ರು ಬಂದು ಇಲ್ಲ ನನಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಐ ವಿಲ್ ಟೇಕ್ ಅಪ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆಯ್ತಾ ಅಂಡ್ ಆಲ್ಸೋ ಸಬ್ಮಿಟ್ ದಟ್ ಆಲ್ರೆಡಿ ಇನ್ಫಾರ್ಮ್ಡ್ ಕೌನ್ಸಿಲ್ ಎನ್ ಶಂಕರ್ ನಾರಾಯಣ ಭಟ್ and Lohit R for R1 and R2. And hence list this matter on 22/7. 76. Yes, madam. Appellant counsel idara? Ilwala ನೀವು ರಾಹುಲ್ ರೆಡ್ಡಿ ಅಂತ ಇದೆಯಲ್ರಿ ಈ ಕೇಸ್ ಈಗ ಲಿಸ್ಟ್ ಆಗಿರೋ ಕೇಸ್ ಅಲ್ಲಿ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹೌದಾ ಅದರ್ ಸೈಡ್ ಇದಾರಾ ಇಲ್ಲ ಅವ್ರು ಬಂದಾಗ ಸಬ್ಮಿಷನ್ ಮಾಡಿ 77 ನೀಡ್ಫುಲ್ ಡನ್ ಅಂತ ಯಾರು ಹೇಳಿರೋದು ಇದೆ ರೀ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ನೋಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ಸುಮ್ಮನೆ ಯಾಕೆ ಹಾಕ್ತಾರ 81 to 90 82 ಹೇಳಿ 29 Appellant counsel submits that appellant passed away on 2/9/23 and seeks 2 weeks time to bring the LRs and hence list this matter on 22/7. Serial number 84 ಹೇಳಿ ಏನು ಅದರ್ ಸೈಡ್ ಯಾರು ಇಲ್ರಿ ಸುಮ್ಮನೆ ಏನೇನ ಹೇಳ್ಬೇಡಿ ಡೋಂಟ್ ಟೆಲ್ ಲೈ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ಅವ್ರೇನ್ ಹೇಳ್ತಾರೆ ಅದರ್ ಸೈಡ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಕ್ ಅದರ್ ಸೈಡ್ ಇದ್ರು ತಾನೆ ನೀವು ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ submits that the appellant counsel who is on record not in stations he went to attend ಏನು ಯಾರು ತೀರ್ಕೊಂಡವ್ರಂತ cremation and hence list this matter on 22/7. 85 ನಾನು ಎದೋಗ್ಬಿಡ್ತೀನಿ ಬಿಡಿ ಬೇಗ ಎಲ್ಲರೂ ಹಿಂಗ್ ಬರೀ ಎಲ್ಲ ಡೇಟ್ ಕೇಳೋದಾಗ್ಬಿಟ್ರೆ ಮತ್ತೆ ಅಲ್ಲ ನಿಮ್ದೇನೆ ಇದು ಡಿಸ್ಮಿಸ್ಡ್ 85 ಮುಗಿಸ್ಕೊ ಬನ್ನಿ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ ನಿಮ್ಗೆ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ ಐ ವಿಲ್ ಅಕಾಮಡೇಟ್ ಯು ಗೋಲ್ಡ್ ಆಮೇಲೆ ನೋಡೋಣ ಅದಲ್ಲ ಅದ್ 4:15 ನೋಡೋಣ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಇಫ್ ಇಟ್ ಇಸ್ ನಾಟ್ 90 ಆಯ್ತು ಬನ್ನಿ ಪರವಾಗಿಲ್ಲ ಬನ್ನಿ ಎರಡು ಇಟ್ಟಿರ್ತೀನಿ ಬನ್ನಿ ಪುಂಡಿಕಾಯಿ ನೋಟೆಡ್ ಇನ್ ದಿ ಮೈಂಡ್ ಆಯ್ತು 86 ಏನ್ರಿ ಎಲ್ಲಾರು ಬರೀ ಟೈಮ್ ಕೇಳದ್ರಿ ನಾನೇನು ಕೂತ್ಕೊ ಬರ್ಬೇಕು ನೀವ್ ಯಾಕೆಲ್ಲ ನಾವ್ ಲಿಸ್ಟ್ ಹಾಕಿ ಮಾಡಿಸ್ಕೋಬೇಕು ಏನ್ ಸೀನಿಯರ್ ನನ್ ಕೋಟಿಗೆ ಏನ್ ಸೀನಿಯರ್ ಬೇಡ ಜೂನಿಯರೇ ಸಾಕು ಓದ್ಕೊ ಬನ್ನಿ ಅಸಿಸ್ಟ್ ಮಾಡಿ ಸೀನಿಯರ್ ಬಂದ್ರೆ ಏನ್ ಕಾನೂನು ಏನ್ ಚೇಂಜ್ ಆಗಲ್ಲ ನೋ ಕೌನ್ಸಲ್ ಎಫೆಕ್ಟಿವ್ ಸಬ್ಮಿಷನ್ ಬೇಕಷ್ಟೇ ಓದಿರ್ ಮಾತ್ರ ಅದಾಗೋದು ಇಲ್ದವ್ರು ಆಗಲ್ಲ ಏನ್ ನೋಡಿ ಎಲ್ಲಾರು ಕೇಳ್ತಾ ಇದ್ರು ಕೊಡೋದೇ ಇಲ್ಲ ಡೇಟ್ ಯಾರು ಆಯ್ತು ನೆಕ್ಸ್ಟ್ ಬನ್ನಿ ಅಸಿಸ್ಟ್ ಮಾಡಿ ಬರೀ 1/4 ಗಂಟೆ ಬರೀ ಡೇಟ್ ಕೊಡೋದು ರಿಪೇರಿ ಕೆಲಸ ಬೇರೆ 1.5 ಗಂಟೆ
91 to
97
98
ಜಿನೈನ್ ರೀಜನ್ಸ್ ಏನಾರು ಇದ್ರೆ ಕೇಳಿ ಕೊಡ್ತೀನಿ
98 100 101 102 to 106
ಸೀರಿಯಲ್ ನಂಬರ್ 105 ಏನಾಗ್ಬೇಕು ಹೇಳಿ ಯು ಆರ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ಹೂಮ್ R1 did you bring to the notice of the other side Satish ke intimate ಮಾಡಿದಿರಾ ತಗೊಳ್ಳಿ R1 counsel seeks time and also counsel submits that already intimated appellant counsel Satish K and hence list this matter on 22/7.
107 to 109 orders matter serial number 1 K Ravi Shankar
Non-compliance of office objection raised on IA 1/22 for CD of 254 days recalling application. ಏನೇ ಸ್ವೇರ್ ಮಾಡಿಲ್ಲ ಅಂತಲ್ಲ ಅಫಿಡವಿಟ್ ಸ್ವೇರ್ ಮಾಡಿಲ್ಲ ಅಲ್ಲ ರೀ 22 ನಲ್ಲಿ ಹಾಕಿರೋ ಅಪ್ಲಿಕೇಶನ್ ಅದು ಏನ್ ರಿಕಾಲಿಂಗ್ ಆರ್ಡರ್ ಏನ್ ಡಿಸ್ಮಿಸ್ ಆದಂಗಿದೆ ಡಿಸ್ಮಿಸ್ ಆಗಿರೋ ಕೇಸಲ್ಲೂ ಇಷ್ಟೊಂದು ನೆಗ್ಲಿಜೆನ್ಸ್ ತಗೊಳ್ಳಿ ಕೌನ್ಸಿಲ್ ಎಷ್ಟರಲ್ಲಿ ಎಷ್ಟಾಗಿದೆ ಮೇಡಮ್ ಇದು ಕಂಪ್ಲೇಂಟ್ಸ್ಗೆ ಅಂತಾನೆ ನೋಡಿ ಹಾಕಿದ್ಮೇಲೆ 2019 ಆರ್ಡರ್ ಅಪ್ಲಿಕೇಶನ್ ಆಗಿರೋ 22
ಒಂದ್ಸತಿ ಬಂದಿದೆ
ಯಾವಾಗ
22 ನಲ್ಲಿ ಬಂದಿದೆ.
ಬಂದಿದೆ?
Office objection raised on applications.
ಹಾ, ಮತ್ತೆ the council seeks time to comply with office objections, and though matter was listed and time was given in 22 till date not complied with office objections, and hence on cost of rupees 500 another 2 weeks time granted. If office objections are not complied, applications which have been filed IA number 1 of 22 and 2 of 22 are rejected. Next, Srinivas V.
Srinivas V. Sorry,
Shara
refused.
refused. Sorry, notice issued against R2 was returned with an endorsement. He has refused and hence held sufficient against R2. The counsel appearing to the appellant would submit that PF is paid in the office and hence issue notice to R3, R4, R5, R8, R8 to 11, R14, R17 and R20. 2018 date kodi. List this matter up to 1 month admel kodi, 4 weeks admel.
5-8.
5-8. ಇಲ್ಲಾಂದ್ರೆ ಕೋರ್ಟ್ ಮುಂದೆ ಫೈಲೇ ಬರಲ್ಲ ಮತ್ತೆ.
3. Rajshekhar S.
Sufficiency of service of notice in respect of R9 and 10 and 11 ಏನಾಗಿದೆ ನೋಡಿ ಎಲ್ಲಾರು ನೋಡಿ. Notice issued against R9, R10 and R11 are returned with an endorsement of refused held sufficient against them. Non-filing of acknowledgement for having served hand summons ಇಲ್ವಾ appellant counsel refuse ಮಾಡಿದಾರಲ್ಲ ಬಿಡಿ. ಆಯ್ತು, next.
4.
Non-furnishing of acknowledgement for having served copy to IA 1 of 21 to learned counsel for respondent by counsel for appellant as per order dated 13/8/21. ಯಾವಾಗ? Yesterday night. ಯಾರು ಅದರ್ ಸೈಡ್ ಯಾರು ನೀವೇನ್ರಿ? ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬೇಕು ಅಂತ ಇದ್ದಿದ್ದು. ಕೊಟ್ಟಿದ್ದಾರೆ. The counsel for the respondent submits that he has received the copy of IA 1 of 21. ಏನದು IA 1 of 21?
Stays.
Next, steps to be taken in respect of deceased R7. ಏನ್ ತಗೊಂಡಿದ್ದೀರಿ?
ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ.
R7 ಗೆ R7 ಸತ್ತೋಗವ್ನ್ರಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ತಗೊಳ್ಳಿ. Counsel submits that he has paid the PF to issue notice to R8, R9 and R10 and hence issue notice against them. Counsel is given 2 weeks time to take steps against deceased R7 for bringing LRs. 2 weeks.
5. N. Suresh. ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂತ ಬಂದಿದೆ.
R4 is dead. The appellant counsel is given 2 weeks time to bring the LRs of R4. ಅಷ್ಟೇನಾ? ಇನ್ನೇನ್ ಬೇರೆ ಏನಿಲ್ವಾ?
ಇಲ್ಲ ಸರ್, ಅದು
list this matter on date ಕೊಡಿ 2 ವಾರ ಆದ್ಮೇಲೆ.
22/7.
22/7.
6. N. ರಾಜಣ್ಣ ಸರ್ 1/6 ಡಿಸ್ಪ್ಯಾಚ್ ಆಗಿರೋದು.
1/6 ಆಯ್ತು. 1/8 1/6 1/6 ಆದ್ರೆ ಆಗೋಯ್ತಲ್ಲ. 1/7 1/6
1/6
1/6 ಬರ್ಬೇಕಿತ್ತಲ್ಲ. ಬಂದಿಲ್ಲ. PF ಕೊಡ್ಬೇಕು R2 ಗೆ. Counsel is directed to give 1 week PF within 1 week. If PF paid, issue notice to R2. Await notice of R3 and R4. ಒಂದು ಡೇಟ್ ಕೊಟ್ಟಿರಿ, 3 ವಾರ ಆದ್ಮೇಲೆ ಕೊಡಿ ನೋಡಿ.
12/8.
3 ವಾರ ಅಂದ್ರೆ 12/8 ಹೆಂಗಾಗುತ್ತೆ?
22/7.
22/7 3 ವಾರ ಆಗಲ್ಲ. ಎಂಡಲ್ಲಿ ಕೊಡ್ರಿ. 29th ಆತರ ಇದೆ. 29/7. ಅವೈಟು ಇದೆ. ಇನ್ನೊಬ್ರು ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ ಅದಕ್ಕೆ.
7.
ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ಡ್ ಆನ್ IA 1 of 20. ಏನ್ರಿ ಇದು IA 1 of 20 ಹಾಕಿರೋದು ಯಾರ್ರಿ? ನೀವಾ? ಮತ್ತೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈಂಟ್ ಮಾಡಿಲ್ಲ. AGA 6 2 weeks time to comply with office objections on IA 1 of 20. ಏನ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತಾನೆ ಏನೋ ಇರ್ಬೇಕು ನೋಡಿ. ಅದನ್ನ ಮಾಡ್ಲಿಕ್ಕೆ ಇನ್ನೆಷ್ಟು ವರ್ಷ ಬೇಕು? ಇರ್ಲಿ, ಡಿಲೇ ಬೇರೆ ಇದೆಯಲ್ಲ. 1371 days in filing. ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಹಿಂದೆನೆ. ಮತ್ತೆ ಫಸ್ಟ್ ಡಿಲೇ ಮೇಲೆ ಹೇಳ್ಬೇಕಲ್ಲ ನೀವು. ಆಮೇಲೆ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನೋಡೋಣ. ನೆಕ್ಸ್ಟ್ ಲಕ್ಷ್ಮೀಕಾಂತ್ ಆಯ್ತು. ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. ಅದು 2 ವಾರ ಕೊಟ್ಟವಲ್ಲ, ಡೇಟ್ ಕೊಡಿ. 22/7. ಯಾವ್ದ್ರಲ್ಲಿ ಹೇಳಿ? 1697 ಅಲ್ಲ? ಫಾರ್ ರಿಕಾಲಿಂಗ್ ದಿ ಆರ್ಡರ್ ಆಲ್ರೆಡಿ ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ? Appellant counsel submits that he will not press the IA number 1 of 22 and hence IA is dismissed as not pressed. ಅಷ್ಟೇ ಅದು ಇನ್ನೇನು ಸೆಟ್ಲ್ ಆಗಿದ್ರೆ ಮುಗಿದೋಯ್ತು.
ಡಿಸ್ಮಿಸ್ ಆಗೋಗಿದೆ.
ಅದೇನೆ ಅದೇ ಮತ್ತಿನ್ನೇನು ಬರೋದಿಲ್ಲ ಫರ್ದರ್ ಆರ್ಡರ್ಸ್. ಹಾ,
9,
ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು R4 to R7. PF ಕೊಡ್ಬೇಕು. ಯಾವಾಗ ಕೊಡ್ತೀರಿ PF? The council submits that he is going to pay the PF today itself, and hence if PF paid, issue notice to R4 to 7. What about objections to IA? Huh? Complaints of office objections raised on IA 1 of 21 ಅಂತಿದೆ. ಹಾ,
ಸೈನ್ ಮಾಡಿಲ್ಲ, ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ ಅಂತ. ನೇಮ್ ಅಂಡ್ ಸಿಗ್ನೇಚರ್ ಆಫ್
ಅದಲ್ಲ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್.
ಅದೇ ಕಂಪ್ಲೇಂಟ್ ಸೆಕೆಂಡ್ ಇದೆಯಲ್ಲ ಸರ್ ಅದರಲ್ಲಿ.
Sorry, the council submits that senior counsel is designated as senior counsel, and hence he is going to file fresh wakalat and going to comply with office objections, and hence 2 weeks time granted. List this matter on 22/7.
ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲೂ PF ಕೊಡ್ಬೇಕು.
ಅದು ಎರಡು ಸೇಮ್ ಕನೆಕ್ಟೆಡ್ ಎಲ್ಲದರಲ್ಲೂ ಒಂದೇ.
10 PM ಸಿಗ್ನಲ್ಲಪ್ಪ.
ಆರ್ಡರ್ ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ issue notice in both appeals ಅಂತ ಬೇಕಾದ್ರೆ ಹಾಕ್ಬಿಡಿ. Shown as deceased R2. 2 weeks time granted to bring the LRs of R2. ಮತ್ತೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು. ಯಾವಾಗ ಕೊಡ್ತೀರಾ? Council submits that within 2 days he is going to pay PF. If PF paid, issue notice to R1.
11
Perusal of unserved cover postals and
Deceased,
addressed
sir.
deceased. R1 and R2 and R4 ಎಲ್ಲರನ್ನ appellant counsel is directed to bring LRs on R1, R2 and R4 within 2 weeks. List this matter on 22/7. ಎಕ್ಸ್ಪರ್ಟ್ ಏನ ಯಾರು? ಅದೇನ್ ಮಾಡ್ತೀರಾ? ಬೆಸ್ಟ್ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಬೇಕೋ ಬೇಡವೋ? 2 ವಾರ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಮುಂದಿನ ಸರಿ ಸಬ್ಮಿಟ್ ಮಾಡಿ ಅಷ್ಟೇ.
12 ಹರೀಶ್ ಕುಮಾರ್
ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್ ಟೈಟಲ್, ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಮೆಂಡೆಡ್ ಟೈಟಲ್. ಯಾವಾಗ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಲೋ ಆಗಿದ್ದೆ ಯಾವಾಗ ಹೇಳ್ರಿ?
ಇದಾಗಿರೋದು
2019. ಎಷ್ಟು ದಿವಸದೊಳಗೆ ಅಮೆಂಡ್ ಮಾಡ್ಬೇಕು? 30 days. 5 ವರ್ಷ ಆಯ್ತಲ್ರಿ ಅಮೆಂಡ್ಮೆಂಟೇ ಮಾಡಿಲ್ಲ. ತೋಳಿ ಅಲೋ ಆಗಿರೋದು ಯಾವಾಗ ಮೇಡಮ್ ಅಮೆಂಡ್ಮೆಂಟ್?
19 ಅಲ್ಲಿ ಆಗಿರೋದು. April 19.
ಅಮೆಂಡ್ಮೆಂಟ್ ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಮಾಡ್ಬೇಕು ಅನ್ನೋದು ಓದಿ ಹೋಗಿ, ಆಯ್ತಾ? ನೀವು ತಪ್ಪು ಹೇಳಿದಿರಿ, ಅದಕ್ಕೆ ನಾನು ನಿಮ್ಗೆ ಹೇಳಿಲ್ಲ. ಓದ್ಲಿನ ಉದ್ದೇಶಕ್ಕೆ ನಿಮ್ಗೆ ಹೇಳಿಲ್ಲ ಎಷ್ಟು ದಿವಸ ಅಂತ. ಹೋಗಿ ಓದಿ ಫಸ್ಟ್. ಯಾವಾಗ? 19 ಅಲ್ಲಿ. Amendment was allowed in 2019 and till date not amended. On cost of ₹1,000 allowed to amend the cost title within 2 weeks and also to file amended cost title. List this matter on 22/7.
30 Ravi
Kumar MC. Non-furnishing of PF ಹೇಳಿ. Appellant as per order dated 13/6/24. ಏನು ವಾಪಸ್ ಬಂದಿದೆ? ಲೆಟರ್ ಕಳ್ಸಿದ್ರಾ? ಈಗೇನ್ ಮಾಡ್ತೀರಿ? ಈಗ ನಾವೇನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? Council seeks another 2 weeks time to issue fresh notice to the appellant to retire from the case, and hence another 2 weeks time granted. List this matter on 22/7. Immediate ಆಗಿ ಕೊಡಿ ಲೆಟರ್ ಮತ್ತೊಂದು ಅಸರ್ಟೈನ್ ಮಾಡಿ ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್. Non-filing of application by the council for appellant to bring LRs of deceased appellant on record. ಯಾವಾಗ ತೀರ್ಕೊಂಡವ್ರದ್ದು? ಯಾವಾಗ? Council seeks weeks time to report the settlement, and hence list this matter on ಒಂದು ವಾರ ಬಿಟ್ಟು ಕೊಡಿ. 11/7. ಅಷ್ಟೊಳಗೆ ಏನಾಗಿದೆ ನೋಡಿ ಹೇಳಿ.
15
H.N. Basuraju, non taking steps by the council for appellant in respect of deceased R1. ಕೊಡಿ ಅದು ಮೆಮೊ ಕೊಟ್ಬಿಡಿ ಸಾಕು. Council for the appellant would submit that R2 and R3 are the LRs of R1. ಏನ್ರಿ ಕರೆಕ್ಟಾ? R2 and R3 are LRs of R1 and hence and copy of the memo is furnished to the other side, and council for the respondent seeks time to verify and submit. List this matter on 11/7. Appeal memo copy nu ಕೊಟ್ಟಿಲ್ವಾ? And counsel for the appellant is also directed to furnish the copy of the appeal memo also. To forthwith ಅವ್ರಿಗೆ ನೆಕ್ಸ್ಟ್ 11/7 ಅವ್ರು ಸಬ್ಮಿಟ್ ಮಾಡ್ಬೇಕು. ನೆಕ್ಸ್ಟ್
60
ಯಾವ್ದು ಹೇಳಿ?
11/7
ಸೀರಿಯಲ್ ನಂಬರ್ 9 ನಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡರ್ ಇದ್ರೆ ನೋಡಿ ಅದನ್ನ ಎಕ್ಸ್ಟೆಂಡೆಡ್.
15 case,
If it is
11,
in force, it is extended.
60.
Council 6 2 days time to comply with office objections on I1 of 22. ಒಂದೇ ಅಲ್ಲ?
Calling, recalling. the
ಆಯ್ತು. List this matter on ಯಾವಾಗ ನೋಡಿ
11.
2 ದಿವಸ ಆದ್ರೆ 11/7.
70.
2 days ಅಲ್ಲಿ ಅವರೆಲ್ಲ ಮಾಡಿರಲ್ಲ 1 week ಅಂದ್ಬಿಡಿ 11/7 ಅಲ್ಲಿ ಹೋಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಫೈಲ್ ಕೊಡಲ್ಲ ಅವರು 2 days ಅಲ್ಲಿ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ 17 perusal of unserved cover R12 and 14 Shara deceased ante appellant counsel given 2 weeks time to bring the LRs of R12 and R14 ಅಷ್ಟೇನಾ? Next
80.
date ಕೊಡಿ 22/7 non taking necessary steps in respect of deceased appellant ಅವ್ರು ಸತ್ತೋಗಿರೋದು ಯಾವಾಗ ರಿಪೋರ್ಟ್ ಮಾಡಿರೋದ್ರಿ? ಲಾಸ್ಟ್ ವೀಕ್ ತೊಗೊಳ್ಳಿ ಆಯ್ತು. appellant counsel 6 2 weeks time and finally 2 weeks time granted. List this matter on 22/7.
90. Sanat Kumar Shetty.
Furnishing of PF correct address to issue notice to R3 and R4. Weeks time. Council 6 weeks time and if PF paid weeks within week, issue notice to R3 and R4.
20. Rajana L.
Dispensation. Third, the counsel for the appellant submits that R2 was placed ex parte before the trial court and also the first appellate court and hence prays for dispensation of notice. And hence notice is dispensed against R2 at the risk of the appellant. Next. Post the matter for admission on 22/7.
21.
A week time may be granted.
21.
Ma'am.
Furnishing of cover to issue notice to
Tomorrow we will come.
pay the PF. If PF not paid, list the matter for dismissal on 11/7.
22.
Non-compliance of office objection for the time. Non-engaging of counsel by appellant. ಏನಾಗಿದೆ ನೋಡಿ ಇದು?
20.
Serial number 22.
22.
Abdul Sattar. Appellant appear ಆದಂಗಿದ್ರು last time ಅಲ್ಲ? Has filed a memo for retirement and the appellant has signed on the said memo dated 25/3/24. Hence the counsel is permitted to retire from the case. The papers were taken by the appellant on 25/3/24 till date not engage the counsel appearance only. Hence time of 2 weeks time is granted to engage the counsel, failing which the appeal will be dismissed for not state of authority. The appellant is absent and this court, even though noticed that papers were taken by the appellant on 25/3/24. Given 2 weeks time to engage the counsel and also made it clear that if fails to engage the counsel, appeal will be dismissed. And in spite of it, not engage the counsel, and hence appeal is dismissed for not engaging the counsel and also did not choose to appear before the court.
23. A Prasanna Shetty.
Non-filing of necessary application in respect of deceased appellant as per order 26/24. Proper party? ಏನ್ ಮಾಡ್ಬೇಕು? ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕಾ ಅಥವಾ ಏನು? ಮತ್ತೆ ಕೇಳ್ತೀರಿ 2 weeks ಆಯ್ತು. Appellant counsel 6 further time and hence finally 2 weeks time granted and hence list this matter on 22/4.
24.
22/7. not 24.
24.
Belagalat. Discrepancy in the name of appellant number 7 in cost title of RA, RSA and earlier wakalat with that of NOC wakalat. Ilva? ಅವ್ರ ಹೆಸರು ತೋರಿಸಿದಲ್ವಾ? Appellant counsel is absent. Finally, another 2 weeks time granted. List this matter 22/7 to comply with office objection. If failed to appear and comply the same, appeal will be dismissed in the next state of hearing.
25.
Balraj
Balraj
Kane.
Kane.
Non-compliance of office objection third time after recalling.
Village correspondent number 7 to be stated in the constituted court fee amount to be equals with RA and OS decree. The provision of court fee paid before the court to be stated in the valuation.
ನೀವ್ ಏನೇನ್ ಹೇಳಿದ್ರೆ ಅದ್ರ ಬಿಟ್ಟು ಸುಮಾರು ಎಲ್ಲ ಇದೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಕೇಳ್ತಾರೆ. ಸರಿ ರೀ, ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದು ಯಾವಾಗ? ಇದು ರೆಕಾಲ್ ಆಗಿರೋದು ಯಾವಾಗ? ರಿಕಾಲ್ ಆದ್ಮೇಲೆ 3 ಸರಿ ಚಾನ್ಸ್ ಕೊಟ್ಟಿದೆ, ಇನ್ ಎಷ್ಟು ಸರಿ ಕೊಡ್ಬೇಕು? ಫ್ರೆಶ್ ಆಗಿ ಯಾವ್ದು ಹಾಕಿಲ್ಲ, ಹಳೇದೇ ಇರೋದು. ಹಳೆ ಫ್ರೆಶ್ ಯಾವ್ದಾರು ಇದೆಯಾ ಮೇಡಮ್? ಇವೆಲ್ಲ ರಿಕಾಲಿಂಗ್ ಆಫ್ಟರ್ ಇದ ನೋಡಿ ಡಿಸ್ಮಿಸಲ್ ಗಿಂತ ಮುಂಚೆ.
Partially ಅಂತ ಹೇಳಿದ್ದಾರೆ. These objections are complied partially.
ಹಾ.
It to comply the following objections ಅಂತ ಹೇಳ್ತಾರೆ. During the complaints of office objection, ಇವೆರಡು ಮಾತ್ರ ಹೊಸದಾಗಿ ತೆಗೆದಿದೆ. ಸರಿ,
ಹಾ.
ನಾಲ್ಕು ಹಳೆಯದು.
ಆಯ್ತು, another 2 weeks time granted to comply with office objections. Finally list this matter on 22/7. ಹೊಸದ್ ಎರಡಿದೆ, ಹಳೇದ್ 4 ಇದೆ, ಹೋಗ್ ಮಾಡಿ.
26.
ನಟರಾಜ್ ಬಲ್ಲಾಳ್,
ಬಲ್ಲಾಳ್.
non-compliance of office objection, 6th time. Non-filing of authority. The council has not paid the cost and also not complied with office objection in spite of matter listed for 6th time, and hence is dismissed for non-compliance and non-payment of cost.
27.
H. Mohan Kumar, non taking steps in respect of deceased sole respondent. ಯಾವಾಗ ನೋಡಿ ಸ್ಟೆಪ್ಸ್ ತಗೋಬೇಕು ಅಂತ ಅಂದಿರೋದು?
26 ಅಲ್ಲಿ 26-24
26.
ಅವಾಗ
ಆಯ್ತು, ಇನ್ನೂ ಟೈಮ್ ಇದೆ ನೋಡೋಣ. another 2 weeks time granted finally to bring the LRs of sole respondent. This matter on 22/7.
28.
Non-compliance of office objections for sixth time. Appellant counsel is absent, matter is listed for 6th time for non-compliance and hence ಹಿಂದೆ ಏನಾರು ಆರ್ಡರ್ ಆಗಿದೆಯಾ? ಕಾಸ್ಟ್ ಅಥವಾ ಕಾಸ್ಟ್ ಕಟ್ಟಿರ್ಬೋದೇನೋ ನೋಡಿ.
ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ದಾರೆ ಸರ್. ಇನ್ನ 4 ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ.
ಮತ್ತೊಂದು and cost is paid but not complied and hence on further cost of rupees 500 another 2 weeks time granted. If cost not paid and not complied, appeal is dismissed without reference to the bench.
29.
Second time. ಆಯ್ತು, ಈಗ ಇದೆಯಾ ಕಂಪ್ಲೇಂಟ್ಸ್ ಇದೆಯಾ, ಟೈಮ್ ಬೇಕಾ? ಆಯ್ತು, 2 weeks time granted to comply with office objections. List this matter on 22/7.
30. K. Srihari.
Non-compliance of sixth time ಏನ್ ಮೇಡಮ್ ಇದು? ಕಾಸ್ಟ್ ಕಟ್ಟಿಲ್ವ ಇನ್ನು? ಪಾಸ್ ಓವರ್ ಏನಾರ ಇದ್ರೆ ಕಂಪ್ಲೈ ಮಾಡೋದು ಇಲ್ಲೇ ಮಾಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಫರ್ದರ್ ಕಾಸ್ಟ್ ಆಗುತ್ತೆ. ನೆಕ್ಸ್ಟ್
31.
non-compliance of office objection 7th time. Non-payment of cost ತಗೊಳ್ಳಿ. Appellant counsel has not paid the cost of rupees 1,000 in spite of time granted to comply with cost. And also matter is listed for 8th time ಅಲ್ಲ ಇದು, 7th time. And hence ಅದೊಂದೇನಾ ಕಾಸ್ಟ್ ಕಟ್ಟಾರ? ಕಾಪಿ ಒಂದು ಸರ್ವ್ ಮಾಡ್ಬೇಕಷ್ಟೇ. ಆಯ್ತು, ಬರೋದಿಲ್ವಲ್ಲ ಕೋರ್ಟ್, ಕಾಸ್ಟ್ ಕೊಟ್ಟಲ್ವಾ? ನೋಡೋಣ, ಇಟ್ಟಿರಿ, ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ. ಒಂದೇ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇರೋದ್ರಿಂದ ಪಾಸ್ ಓವರ್. ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ 6th time. ಬಾಲಕೃಷ್ಣ ಶಾಸ್ತ್ರಿ, ಹೇಳ್ರಿ ಅಂತ. ಹಿಂದೆ ಕಾಸ್ಟ್ ಹಾಕಿದೀವ, ಕಾಸ್ಟ್ ಕಟ್ಟಿದಾರ ನೋಡಿ. ಏನ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಏನ್ ಇಲ್ವಲ್ಲ? ಕಾಸ್ಟ್ ಹಾಕಿ ಅಲ್ವಾ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇರೋದು ಒಂದೇನಾ?
Number 8 to 13 not made party in RA. Necessary application to be filed to bring the LRs on record in RSC. ಅಂತ ಇದೆ.
ಏನ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಹೇಳ್ಬಿಡಿ ಅದನ್ನ. ಅದ್ರೇನ ಬರ್ದವ್ರಂತ ನೋಡಿ. ಹೋಗ್ಲಿ, ಅಪೀಲ್ ಎಲ್ಲಾರು ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಕೆಳಗಡೆ ನೋಟ್ ಹಾಕಿದೀರಾ? ಮತ್ತೆ ಇಲ್ಲ, ಅದನ್ನ ವೈ ಯು ಆರ್ ನಾಟ್ ಮೇಡ್ ದಮ್ ಆಸ್ ಪಾರ್ಟಿ ಅನ್ನೋದನ್ನ ಅಟ್ಲೀಸ್ಟ್ ಹೇಳ್ಬೇಕಲ್ಲಿ. ಅಲ್ಲಿ ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಾನು ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಬೇಕು. ಏನಾದ್ರು ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಇದೆಯಾ ಮೇಡಮ್? ಇಲ್ಲ.
Respondent number 8 to 11. That is plaintiff 5A to D seems to have been omitted in RA by mistake. And
ಅದೇ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಇವ್ರು ಕೊಟ್ಟಿರೋದಾ?
so R12 and 13 that is D3 and D4 have suffered the judgment. They were not interested in prosecuting the evidence. They were not made party in RSA. RA ಗೆ ಏನಕ್ಕಾಗಿ
ಅಲ್ಲ, ಬಟ್ RA ಹಾಕ್ದವ್ರು ಯಾರು? ನಿಮ್ಮ ಅಪೀಲ್ ಅಲ್ವಾ ಅದು? RA ನಿಮ್ದೇನೆ. ಮತ್ತೆ ಅಲ್ಲಿ ಬಿಟ್ಮೇಲೆ ಇಲ್ಲೇ ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ನೀವು ಅವ್ರನ್ನ? ಅಲ್ಲಿ ಬಿಟ್ಟಿದ್ದೀರಿ, ಅಲ್ಲೂ ಬಿಟ್ಟಿದ್ದೀರಾ, ಇಲ್ಲೂ ಬಿಟ್ಟಿದ್ದೀರಾ? ಈಗೇನ್ ಈಗ ಬೇಕಾಗಿಲ್ವ? ಈಗ ಅವ್ರು ಬೇಕಾಗಿಲ್ವಾ?
ಇಲ್ಲಿ ಮಾಡಿಲ್ಲ.
8 to 11 ಇದಾರಲ್ರಿ.
ಮಾಡಿದ್ದೀನಿ.
8 to 11 ಯಾರು ಅಂದ್ರೆ plaintiff 5A to 5D. Seems to have been omitted in RA by mistake ಅಂತ ಬರೀತೀರಿ ನೀವು. ಮತ್ತೆ ಅಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಆದ್ರೆ ಮತ್ತೆ ಇಲ್ಲ ಕರೆ ಮಾಡ್ಲಿಲ್ಲ? ಮಾಡಿದಾರ ಈಗ
ಮಾಡಿ ನಾವು.
ಸರಿ, ಅಲ್ಲಿ ಮಾಡ್ದಲ್ಲ ನೀವ್ ಇಲ್ಲಂಗ್ ಅಜಿಟೇಟ್ ಮಾಡ್ತೀರಾ ಅವ್ರ ಮೇಲೆ? ಯಾರು? ಹಾ ಆಯ್ತು. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕನ್ಫರ್ಮ್ ಆಗಿದೆಯಾ? ಕನ್ಫರ್ಮ್ ಆಗಿದೆ. ಏನ್ ಅಗೇನೆಸ್ಟ್ ಏನಾಗಿಲ್ಲ. ಸರಿ ತೊಗೊಳ್ಳಿ. The claim, the counsel submission is that our plaintiff A to 5D by mistake they have been omitted, and they have also not suffered any decree in the appellate court, and the judgment of the trial court is confirmed, and hence they have not been made as respond number 8 to 11 in this second appeal, and hence the office objection is overruled. In respect of R12 and R13, that is D3, D4, they have suffered the judgment and they were not interested in prosecuting the appeal, and hence they were not made as party in this RSA irbeku. RA anta idu bardidiri? RA and RSA na? RSA nal madidiri. ಈಗ ಅವ್ರು R12 and 13, the defendant number 3 and 4 have suffered the judgment. They were not interested in prosecuting the appeal. ಕೆಳಗಿನ ಕೊಟ್ಟಲ್ಲ, and hence they were not made as party in RA, but here you have made, here the appellant made them as party R2 and R13, R12 and 13, and hence counsel submission is accepted in respect of them also. Post the matter for admission. 22/7.
34.
Venkatesh R. Bhagat.
Chandranath.
Cash katilwa? Pass over. Non-compliance of office objection for 4th time. ಹೇಳಿ ಮಾಡಿಲ್ಲಲ್ಲ? Appellant counsel seeks further time, and hence for on cost of rupees 500, 2 weeks time granted to comply with office objections. List this matter on 22/7.
35.
35, Kamaraj. Counsel submits that he has paid the cost. Again, comply madidra illa? And counsel again seeks time to comply, and hence another cost on further cost of rupees 500, another 2 weeks time granted. If further cost not paid and not complied, appeal is dismissed without reference to the bench.
36.
Non-compliance of office objection for 5th time. ಇನ್ನು 5 ಇದೆ. Counsel again seeks time. And ಹಿಂದೆನೂ ಮಾಡಿದ್ವಾ? ಕಾಸ್ಟ್ ಹಾಕಿದೀವ ಇಲ್ಲ? ಹಾಕಿಲ್ಲ ಯಾವಾಗ್ಲೂ. ತೊಗೊಳ್ಳಿ. Matter is listed for 5th time, and hence on cost of rupees 1000 payable at registry, another 2 weeks time granted. If cost not paid and not complied, appeal is dismissed without reference to the bench. ಹೇಳಿ.
37.
ದೇವರಾಜ್ ಕಾಸ್ಟ್? ಈಗ ಮತ್ತೆ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರಾ? Appellant counsel submits that he has paid the cost and once again 6th time, and hence another 2 weeks time granted on further cost of rupees 500. ಕಾಸ್ಟ್ ಹಾಕಿಲ್ವಾ? ಕಾಸ್ಟ್ ಹಾಕಿಲ್ಲ ಅಂತಲ್ರಿ? ಕಾಸ್ಟ್ ಕಟ್ಟಿದಿರಿ ಅಂತೀರಿ? ಆರ್ಡರ್ ತೋರಿಸ್ತಾ ಇದೆಯಾ ನೋಡಿ ಮೇಡಮ್. ದೇವರಾಜ್ ತಾನೆ 37.
37.
ಸೀರಿಯಲ್ ನಂಬರ್ 37 ರೀ. ದೇವರಾಜ್ ಆಫೀಸ್. ಯಾರು ಇದು? ನೀವಾ? ನೀವ್ಯಾಕ್ರಿ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀರಿ? ನಿಮ್ದಾದ್ರಿ ಮ್ಯಾಟ್ರು? ಹೋಗ್ಲಿ, ದಾರಿನಾರ್ ಬಿಡಿ ಅವರಿಗೆ.
RSA 1475.
Appellant counsel 6th time and matter is listed for 5th time, and hence 2 weeks time granted on cost of rupees 1000. 5th time alla 1000. If cost not paid and not complied, appeal is dismissed without reference to the bench.
38.
Shruti Chaganti. Non-compliance of office objections 5th time. Non-filing of acknowledgement. ಯಾವಾಗ? ಕಾಸ್ಟ್ ಕಂಪ್ಲೈ ಮಾಡ್ಲಿಲ್ವಾ? ಕಂಪ್ಲೈ ಮಾಡ್ಲಿಲ್ಲ office objections. Counsel submits that cost is paid today, and again 6 time and hence on further cost of rupees 500, another 2 weeks time granted. If cost not paid and not complied with office objections, appeal is dismissed without reference to the bench.
39.
Swami MM.
Swami MM.
Swami MM, ನಿಮ್ದ ಇದು ಹೇಳಿ ಏನು ಕಾಸ್ಟ್ ಕಟ್ಟಿದೀರಾ? ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ ದಟ್ ಹ್ಯಾಸ್ ಪೇಡ್ ದಿ ಕಾಸ್ಟ್. ಏನಾಗಬೇಕು ಮತ್ತೆ ಕಂಪ್ಲೇಂಟ್ಸ್ ಗೆ? And again 6 time and hence 2 weeks time granted on further cost of rupees 500. If further cost not paid and not complied with office objections, appeal is dismissed without reference to the bench within 2 weeks.
40.
Non-compliance 4th time. AP Bhuvan. Counsel is absent, 2 weeks time granted on cost of rupees 500 payable at registry. And list this matter on 22/7. If cost not paid and not complied for dismissal.
41. Prasanna Veer.
Counsel submits that he has paid the cost today and he seeks 1 week time to comply and hence on further cost of rupees 500, another 2 weeks time granted. If cost not paid and not further cost not paid and not complied, appeal is dismissed without reference to the bench.
42. Tanuja.
Cost paid compliance ಹೇಳಿ. Counsel submits that he has paid the cost and again 6 time and hence further cost of rupees 500, another 2 weeks time granted. If cost not paid and not complied, appeal is dismissed without reference to the bench.
43.
5th time, Syed Akbar Pasha. Appellant counsel is absent and matter is listed for 5th time and hence on cost of rupees 1,000 payable at registry. 2 weeks time granted. If cost not paid and not complied, appeal is dismissed without reference to the bench. Next 44.
44.
Mohan PS. Counsel is absent and also not paid the cost and also not complied and hence appeal is dismissed for non-compliance and non-payment of cost.
45.
Ravi MM. Same order. Dismissed.
46.
46 Idmalappa PM. Counsel submits that he has paid the cost today and again 6 2 days time and hence further cost of rupees 500, 2 weeks time granted. If further cost not paid and not complied, appeal is dismissed without reference to the bench.
47. Srinath P.
Srinath P. ಕಾಸ್ಟ್ ಕಟ್ಟಿದೀರಾ? ಕಟ್ಟಿಲ್ಲ ಏನ್ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕಾ ಏನು? ಪಾಸ್ ಓವರ್. ಅದೇನು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಬಿಡಿ. 7 objections ಇದೆ ಅಂತ್ರಿ. The counsel submits that he is going to pay the cost today and again 6 time since there are 7 office objections and hence on further cost of rupees 500, another 2 weeks time granted. If further cost not paid and not complied, appeal is dismissed without reference to the bench.
48.
Chandrapatti, 3rd time. Appellant counsel is absent. Finally, 2 weeks time granted to comply with the same. If not complied, list this matter on 22/7.
49.
49. Affidavit filed by counsel for appellant with respect to service of hand summons.
All the parties have been served. But we tried to serve the learned counsel also, but he refused as the papers are taken away.
Service ಆಗಿದೆ ಅಲ್ವಾ?
All been served. ಎಲ್ಲರಿಗೂ service ಆಗಿದೆ.
Service ಆದ್ಮೇಲೆ ಮತ್ತೆ ನೀವು service affidavit ಹಾಕ್ಬೇಕು.
Not necessary.
Non-filing of acknowledgement for having served the copies to the counsel for respondent before the first appellate court.
ಹೌದು. ಅದು ಈ ಸರ್ವಿಸ್ ಆಗಿದೆ, ನಾಟ್ ನೆಸೆಸರಿ.
ಏನ್ ಅವ್ರು ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ರಾ?
ಅಲ್ಲ, ಮುಂಚೆ ಎರಡೂನು ಕೊಟ್ಟಿದ್ರು, ಟೇಕ್ ಸಮನ್ಸ್ ಆಸ್ ವೆಲ್ ಆಸ್.
ಏನ್ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ರಲ್ಲ, ಏನಕ್ಕೆ ಅದು? ಅಫಿಡವಿಟ್ ಹಾಕಿರೋದು ಮೊದಲು ಅಫಿಡವಿಟ್ ಹಾಕಿದಿರಿ ನೋಡಿ.
ಅದು ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಅಲ್ಲಿ ಏನಾಯ್ತು ಅಂದ್ರೆ, ಅದು ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಸರ್ವಿಸ್ ಮಾಡುವಾಗ ಸ್ವಲ್ಪ ನೇಮ್ ಚೇಂಜ್ ಮಾಡಿದ್ರು, ಅದನ್ನ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿದ್ರು, ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ.
ಯಾರು ಅವ್ರ? ಅದಕ್ಕೆ ಅವ್ರು ತಗೊಳ್ಳಿಲ್ಲ.
ಹೌದು,
ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಡ್ಬೇಕು. ತಾವು ಕೊಟ್ರ ಕರೆಕ್ಟ್
ಅಲ್ಲ, ಅವ್ರ ಹೆಸರು ಕರೆಕ್ಟ್ ಆಗಿರೋದನ್ನ ಬರೆದು ಕಟ್ಟಿದ್ರು.
ಆಮೇಲೆ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿದ್ರ ನೀವು?
ಮಾಡಿದ್ದೆ.
ಅವಾಗ್ಲೂ ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ರ?
ಅಲ್ಲಲ್ಲ, ದೇ ಹ್ಯಾವ್ ಬೀನ್ ಸರ್ವ್ಡ್, ದೇ ಆರ್ ರೆಪ್ರೆಸೆಂಟೆಡ್. ಒನ್ ಪರ್ಸನ್ ಇಸ್ ರೆಪ್ರೆಸೆಂಟೆಡ್.
R4 ಇದಾರೆ,
ಬಾಕಿಯವರೆಲ್ಲ ಸರ್ವ್ ಆಗಿದೆ
ನೋಡಿ. ದ ಅಫಿಡವಿಟ್ ಇಸ್ ಟೇಕನ್ ಆನ್ ರೆಕಾರ್ಡ್. ಇಲ್ಲಿ ಮತ್ತೆ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಕ್ಲಾಂಟ್ ಫಾರ್ and in view of R1 to 3
ಅದು ಮುಂಚೆ ಆರ್ಡರ್ ಆಗಿತ್ತು.
R1 to 3 have been served personally.
ತಗೊಳ್ಳಿಲ್ಲ.
Filing of acknowledgement for having service ಅಷ್ಟ ಹಾಕೋಬೇಡಿ. List the matter for admission.
ಇಲ್ಲ, ಈಗ appointment of commissioner ಗೆ ಒಂದು ಅರ್ಜಿ
Consider ಮಾಡೋಣ ಅವತ್ತು. Admission ಬಂದಾಗ ಅದು ಕನ್ಸಿಡರ್ ಮಾಡೋಣ.
next week,
Along with IS 22/7.
any shorter date.
Starter date ಅದೇನೆ. ಒಂದ್ ಮಧ್ಯದಲ್ಲಿ ಏನೋ ರಜಾ ಬರುತ್ತಾ ಮೇಡಮ್ 22/7 ನೆನೆ 21 ಹಾಕಿದ್ವಲ್ಲ
ಇರ್ಲಿ ಬಿಡಿ 22nd ಇರ್ಲಿ, no problem.
22nd.
22nd, much blessed.
Yes, Nataraj Baba.
Well, for the appellant.
Arraying of
Defendant
D1.
number one died, my lords.
Ah.
Really, ಅವ್ರನ್ನ name already, because the LRs are already in record,
Ah.
ಅವ್ರ name delete ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಕೊಡ್ತೀರಾ ಮೆಮೊ ಅಥವಾ
REL ಅವ್ರ ಹೆಸರಿಲ್ಲ.
ಹೇಳಿದೀರಾ ನೀವು ಅದನ್ನ?
ಹೇಳಿದೀನಿ submission.
Sorry. Appellant counsel submits that D1 Kariyamma is no more and already LRs are brought on record and hence she was also not made as party in RA and in this RSA and hence counsel submission is accepted.
Please.
51.
Samar-
For the appellant, for the appellant.
Second time, ಎಷ್ಟು ಸಬೇಕು?
I've 1 week, so me ಎಲ್ಲಾ comply ಆಗಿದೆ ಸ್ವಾಮಿ.
Counsels ಎಲ್ಲ ಕಪ್ಲೈ ಆದ್ರೆ ಮತ್ತಿಲ್ಲ ಇನ್ನೂ ಇದೆ ನೋಡಿ ಮಾಡಿ 2 ವಾರ ಟೈಮ್ ಕೊಡ್ತೀನಿ.
ಆಯ್ತು.
Counsel
A date may be given.
2 weeks time to comply with office subsection.
Uh,
Is this
date
matter
may-
22/7?
Grateful.
52.
For admissions, my lord, please.
ಇದು ಅಷ್ಟೇನಾ? ಇದ್ರಲ್ಲೂ ಅಷ್ಟೇನೆ.
ಇದ್ರದ್ದು ಅಷ್ಟೇ sir.
22/7.
For admissions, my lord, please.
ನೀವು ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ಅಡ್ಮಿಷನ್ ಬರುತ್ತೆ
ಮಾಡ್ತೀನಿ.
ಅಷ್ಟೇ.
Grateful,
If complaint post the matter for admission ಅಷ್ಟೇ ಮೇಡಮ್. If complaint.
grateful.
Hearing on
ನೀವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದಲ್ಲ ಯಾಕೆ ಕೋರ್ಟ್ ಮೆಮೊ ಮೂವ್ ಮಾಡ್ತೀರಾ?
Clarification ಇತ್ತು ಸ್ವಾಮಿ, comply ಮಾಡಿ on objections post ಮಾಡಿ ಅಂತ ತಿಳಿಸಿದ್ವಿ ಸ್ವಾಮಿ.
ಏನ್ ಕ್ಲಾರಿಫಿಕೇಶನ್?
Objections.
ಆಯ್ತು ನೋಡಿ. ನೆಕ್ಸ್ಟ್
53.
ಗೀತಾದೇವಿ MP recalling the order dated 11/11/21 ಏನ್ರಿ ಅದು?
My lord,
Come along with the
non-compliance
receipt by
of
counsel.
objections, the
Ah.
appeal was dismissed. We have paid the
Good.
cost and complied with office objections, my lord.
Recalling the order dated ಏನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದಾ? ಯಾವಾಗ it was dismissed? 2021.
26/11/2021.
2021 it was dismissed. ಹೇಳಿ ಆಮೇಲೆ ಏನಾಯ್ತು? ಅದ್
We have
ಆಮೇಲೆ
complied with office objections and paid the cost, my lord.
ಯಾವಾಗ ಮಾಡಿದಿರಿ?
Uh,
ಡಿಸ್ಮಿಸಲ್ ಆದ್ಮೇಲೆ ಮಾಡಿದಿರಾ?
Now, my lord, we have paid the
One
cost of 2,000 rupees.
ಕನ್ಸಿಡರೇಷನ್ ಕೊಟ್ಟಿದಾರ ಮೇಡಮ್?
We have paid the cost and also done the,
ಅಂತ.
lord,
2 weeks
the,
time granted to comply with office objections failing which appeal stand dismissed ಅಂತ 16/3 ಆಯ್ತು. 21 ಆಮೇಲೆ ಎಲ್ಲಿದೆ?
after that it was dismissed recently, my lord.
ಮತ್ತೆ ನಾನು ಬಂದಿದೆ ಮೇಡಮ್ ಲಿಸ್ಟ್ ಆಗಿದ್ವಿ ಆಮೇಲೆ
And on 26/2024 it was listed.
ಏನು ಮಾಡಿದ್ದೀನಲ್ಲ 11 taking into consideration office objections are not earlier there were 11 office objections and at the time there were
All
3
being
office
complied now, my lord.
objections. Note of that some of the office objections were complied and still there were 3. Hence another 2 weeks time granted and cost of rupees 2,000 payable at registry to comply with office objections. ಈಗೇನ್ ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ಇದು
We have complied, my lord, and the office payment of fort fee also has been done.
not court fee.
Sorry, my lord, the cost has been also paid, my lord.
ನೋಡಿ ಮಾಡಿದಾರ ನೋಡಿ ಕಾಸ್ಟ್ ಕಟ್ಟಿದಾರ
Cost has been paid.
ಕಂಪ್ಲೈನ್ಸ್ ಏನಾಗಿದೆ ನೋಡಿ.
Office objections have been complied, my lord.
Counsel
Substantial
submits
question
that
of law.
as paid the cost of rupees 2,000 ಮಾಡಿದಾರ ಕೊಡಿ. And office objections are also complied and in view of compliance of order dated 26/24 and for the reasons stated in the accompanying application on A number 1 of 21, order of dismissal dated 11th day of November 2021 is hereby recalled. Post the matter for admission on 22/7.
54.
Issue notice on IA1 and also on main against the respondent.
55.
1 of 21, 2, 3, 7, 4 days in filing the appeal. ಹೇಳ್ರಿ ಇವರು ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟಾ? ಹೇಳಿ ಏನು? ನೋಟಿಸ್? ನೋಟಿಸ್? ಆಗ್ಲಿ ಹೇಳಿ ನೀವು. ಸುರೇಂದ್ರ ಮನಿಯಾನಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಸ್ ಸರ್ವ್ಡ್ ಅಂತ ಆಗಿದೆ, ಸರ್ವಿಸ್ ಆಗಿದೆ. ಯಾವಾಗ ಸರ್ವಿಸ್ ಆಗಿರೋದು ನೋಡಿ ಮೇಡಮ್, ಇತ್ತೀಚೆಗ ಮೊದ್ಲ?
22 ನಲ್ಲೇ ಆಗಿದೆ.
ಹಾ?
22 ನಲ್ಲೇ
22 ನಲ್ಲೇ ಸರ್ವಿಸ್ ಆಗಿದೆ. ಏಕೆ ವೈ ಒನ್ ಟೈಮ್? AGA 6 time. List this matter finally on 11/7 madam.
11/7.
11/7. Prasanna VR.
6.
Abhinav R.
Delay, my lords,
91 days.
Filing, my lord, I have
Avre
put
ನಾನು-
medical certificate also.
ಅವ್ರಿಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೀರಾ?
Serve ಮಾಡಿದ್ದೀವಿ.
So heard on IA 1 of 2018 and there is a delay after 91 days. And council submits that with regard to the delay is concerned. ಏನ್ ಹಾಕಿದಿರಿ?
Medical certificate, my lord, at page number 89.
Medical certificate is also produced and in spite of service of notice on the other side. They have not filed any objections. Copy ಯಾವಾಗ serve ಮಾಡಿದ್ರಿ ನೀವು?
Lord, notice was directed to the respondents.
ಹೌದಾ?
How earlier. Lord,
Notice
after
was
hearing.
also ordered earlier. And for the reasons stated in the accompanying application and affidavit and in view of non-filing of objections, delay of 91 days is condoned.
Divergent
Put the
finding.
matter
Lord.
for admission on 22/7 along with
LCR
other-
may be relevant, my lords. Divergent finding is there. LCR may be, my lords.
ಬರ್ಲಿ ನೋಡೋಣ ಆಮೇಲೆ ಅವತ್ತಿದ್ರೆ ನೋಡೋಣ.
Please, please.
22/7, 57.
For the appellants, my lord.
1 of 22 for impleading proposed R2.
They are the purchasers of the suitable land during the pendency of the matter, my lord.
Application ಹಾಕಿರೋದಾರ ನೀವಾ?
ಹೌದು, I am appellants.
Pleading ನವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ?
ಹೋಗಿ ಆಯ್ತು.
ಬಂದಿದಾರ?
To be allowed.
ಏನ್ರಿ? ಹಾ. Objections ಹಾಕ್ತೀರಾ? ಬೇಕಾ?
Purchasers.
ಆಯ್ತು. The proposed R2
And
counsel
R3.
seeks time.
R2 and R3.
File objections to IA 1 of 22.
R3 ಇದ್ದಾರೆ.
ಹಾ?
Propose R2 and R3.
R2 ನೇ? 3
Three.
ಇದಾರ?
ಇಬ್ರು ಇದ್ದಾರೆ, ಇಬ್ರು
ಏನು
purchasers.
ಮತ್ತೆ 2 ಅಂತಲೇ ತೋರ್ಸವ್ರೆ ಅದಕ್ಕೆ. ಆಯ್ತು. 2 and 3. List this matter on 11/7. ಒಂದು ವಾರದಲ್ಲಿ ಹಾಕ್ತೀರಾ? 2 ವಾರ ಬೇಕಾ? 22/7. ಏನ್ ಮೇಡಮ್ ಹೇಳಿ? ಹಾ. ಅಡ್ಮಿಟ್ ಅಂತ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ, admission ಆಗಿಲ್ಲ.
ಸಬ್ಸ್ಟಾಂಟಿವ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಫ್ರೇಮ್
Time ಆಗಿದೆ
ಅಡ್ಮಿಟ್ ಅನ್ನೋದು ಬಿಟ್ಟೋಗಿದೆ ಅಷ್ಟೇ.
ಅಷ್ಟೇ.
ಅದೇನ್ ಬೇಕಾಗಿಲ್ಲ. ಸಬ್ಸ್ಟಾಂಟಿವ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಆಯ್ತು ಅಂದ್ರೆ ಅಡ್ಮಿಷನ್ ಆದಂಗ ಅದು. ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್. ಇವನ್ ದೋ ಇನ್ ದ ಆಬ್ಸೆನ್ಸ್ ಆಫ್ ದಿ ವರ್ಡ್ ಅಡ್ಮಿಟ್. ಆಯ್ತು, ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನಾಗ್ತಾರ ಹಾಕಿ.
ಆಯ್ತು.
ಇಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 22/7.
ಒಬ್ಳೆ ಇದೆ.
58.
ರಾಜಗೋಪಾಲ್ ಎಂಆರ್
Rajagopal Emma. Here,
ಫೈಲಿಂಗ್ ದಿ LR ಅಪ್ಲಿಕೇಶನ್ IA 1 ಏನೋ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ ನೋಡಿ.
appellant sir, appellant A1.
ಡಿಸೀಸ್ಡ್ ಅಪಲೆಂಟ್ A1 to C ನ ಅದರ್ ಸೈಡ್ ಯಾರು ಇದಾರ? ಲಿಂಗರಾಜ್ ಇಲ್ಲ. ತೊಗೊಳ್ಳಿ. ಕಾಪಿ ಸರ್ವ್ ಮಾಡೋರು ನೋಡಿ. IS 1 of 22, 2 of 22, 3 of 22. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇಲ್ವಾ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಸರ್ವ್ ಆಗಿರ್ಬೋದು. ಬಟ್ ಅಲ್ಲಿ ಹಾಕುವಾಗ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಇಲ್ವಾ ನೋಡಿ. ಹಾಕ್ದಾಗ ತೊಗೊಳ್ಳಿ. Heard on IA 1 of perused ಅಂತ heard on ಅಂತ ಬರಲ್ಲ. I have perused the IA 1 of 22, 2 of 22 and 3 of 22, wherein prayer is sought to condone the delay of 14 days and also set aside the abatement and bringing the LRs of deceased appellant as A1, A to C. And both the counsels are absent and for the reasons stated in the accompanying application and affidavit, IAs are allowed. Appellant counsel is IAs are allowed by condoning the delay and setting aside the abatement and permission is granted to bring the LRs of deceased appellant as A1, A to C. The appellant counsel is directed to amend the cast title and file amended cast title within 2 weeks. Is this matter on 22/7?
Admit ಆಗಿದೆ.
ಅಡ್ಮಿಟ್ ಆಗಿದೆಯಾ? ಮತ್ತೆ ಅಡ್ಮಿಷನ್ ಬರಲ್ಲ. Is the matter for final hearing in the second week of August.
59. ಮುರಳೀಧರ HM.
ಮುರಳೀಧರ್ HM 670 days ನೋಟಿಸ್ ಬಂದಿದೆಯಾ?
Notice ಹೋಗಿ. ಸರ್ವ್ ಆಗಿದೆ.
R3 ಗೆ ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ sir. 3A.
R3A ಒಬ್ರೇನಾ?
ಒಬ್ರೇ.
R3A ಒಬ್ರೇನ್ರಿ?
ಹೌದು.
ಒಬ್ರೇನಾ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ? ತೊಗೊಳ್ಳಿ. Heard on IA 3 of 21, 1 of 21 and 2 of 21 and there is a delay of 670 days in filing the application and also sought for setting aside abatement and bringing LRs. And for the reasons stated in the accompanying application and in spite of service of notice against the LRs of R3 also, R3 LR did not choose to appear before the court. And hence IAs are allowed by condoning the delay and abatement is set aside and permitted to bring the LRs on record. Appellant counsel is directed to amend the cast title within 2 weeks and also file amended appeal memo within 2 weeks. Admission ಆಗಿದೆಯಾ? ಇಲ್ಲ. List the matter for admission on 22/7. ಯಾವ್ದಕ್ಕೆ? ಇಲ್ಲ 617th ಇದು. ಬಟ್ ಆಫೀಸ್
670 days.
617th ಏನೋ ಮಾಡಿದ್ದಾರೆ. ಆಯ್ತು.
ಫೈಲಿಂಗ್ ದಿ ಅಪೀಲ್ ಇರ್ಬೋದು ಸರ್ ಅದು.
ಯಾವ್ದು?
ಅದ್ರಲ್ಲೇನು ಬೇರೆ case.
ಬೇರೆ IAS ಮೋಸ್ಟ್ಲಿ ಬೇರೆ IAS ಏನೋ. Bringing LR 670 ಇದೆ ಕಂಡೌನ್. ನೆಕ್ಸ್ಟ್ 60 PM Sidmalappa, appointment of ADLR. Sanat Kumar Shetty, ilwa?
ಇಲ್ಲ
Sidmalappa.
PM ಸಿದ್ಮಲ್ಲಪ್ಪ.
ನೋಡೋಣ ಅವ್ರು ಬರ್ಲಿ. ಅವ್ರ absence ಆರ್ಡರ್ ಬರೆಯೋದ್ ಬೇಡ. Appellant counsel is absent and one more opportunity is given to consideration of IA 1 of 22. And counsel for respondent present. List this matter on 22/7.
61.
Vishwanatha Shetty.
Respondent number 2.
Notice.
Notice ಹೋಗಿಲ್ಲ?
ಹೋಗಿಲ್ಲ sir.
Issue notice on IA 1 of 24, 2 of 24, 3 of 24 against the LRs of R2, that is A to F. ಆಮೇಲೆ
ಆಮೇಲೆ 3
R3
same 3 madam, 3A to C.
62. ಗಿರೀಶ್
1147 days in filing. ಹೇಳ್ರಿ ಅಂತ.
The case of death, my lordship,
Anand, notice not ordered.
death due to electrocution. The appellants are the LRs of the deceased. The award amount was taken by the dispatch to the appellant on 15/4/2019. 15/4/2019. I produced the order sheet which is in page number 61, my lordship.
61.
Thereafter, due to COVID and other reasons, he is unable to contact the advocate and file the appeal within the
Trial
reasonable time.
court award ಆಯ್ತೇನ್ರಿ?
Award ಆಯ್ತು.
Award
Thereafter, amount has been, execution has been filed and amount has been deposited.
Execution file ಮಾಡಿದಿರಿ.
Execution file ಮಾಡಿ, then amount has been withdrawn on 25/4/2019, my lordship. I pleaded the reason that due to
appeal dispose ಆಗಿದ್ದೆ ಅವಾಗ?
appeal disposed,
appeal ಅಲ್ಲೇ award allow ಆಗಿರೋದಾ?
appeal allow ಆಗಿರೋದು. Appeal allow ಆಗಿ, then amount was deposited.
16th day of December.
Yes, my lordship.
Execution ಹಾಕಿದ್ದೆ ಅವಾಗ ನೀವು?
Execution was filed. Execution was filed on 16/3/2017. Due to financial difficulties, I am not received the amount from the.
Already you are able to file execution petition and get the award amount. Why you have not filed?
The award amount was, I have secured the amount on 25/4/2019, my lords, in the year 19.
25/4/2019.
19.
This second appeal ಹಾಕಿದ್ದೆ ಅವಾಗ?
Second appeal was filed on 23/11/2021.
ಮತ್ತೆ
Meanwhile, due to COVID,
ಇವನ್ ದುಡ್ಡು ರಿಸೀವ್ ಮಾಡಿರೋದು 25/4/2019.
COVID ಬಂತ.
ಈಗ ಇನ್ನೊಂದ್ ಚಾನ್ಸ್ ತಗೊಂಡಿದ್ದೀರಾ? ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಆಗ್ತದೆ ಅಂತ?
ಇಲ್ಲ COVID ಬಂತು.
ಕೋವಿಡ್ ಅವಾಗ ಬಂದಿದ್ದು?
19
ಒಂದ್ ವರ್ಷದ ಮೇಲೆ. COVID-19 ಅಲ್ಲಿ ಬಂದಿಲ್ರಿ, ಯಾಕೆ ಸುಮ್ನೆ ಸುಳ್ಳು ಹೇಳ್ತೀರಿ? March 20th, 2020 ಹೇಳಿ ಕೋವಿಡ್ ಬಂದಿರೋದು.
Due to these reasons, I am unable to.
ಇವನ್ ದುಡ್ಡು ತಗೊಂಡು ನೀವು 1 ವರ್ಷ ಹಾಕಿಲ್ಲ ಅಪೀಲು, ಹೌದಾ? ಈ ಅಪೀಲ್ ಹಾಕಿರೋ 1 ವರ್ಷ ಅಲ್ಲ, ಜಾಸ್ತಿ ಇದೆ. 11ನೇ ತಿಂಗಳು, 1.5 ತಿಂಗಳು. 25/4/2019. ನೀವು ಅಪೀಲ್ ಹಾಕಿರೋದು 25/11/21. 1.5 ವರ್ಷ.
Because I have good case on merits, my lordship.
ಅಲ್ಲ ರೀ, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಕ್ಕೆ ನಿಮ್ಗೆ ಟೈಮ್ ಇದೆ, ಗೊತ್ತಿದೆ, ಎಲ್ಲ ಇದೆ, ಅಲ್ಲಿ ತಗೊಳಕ್ ದುಡ್ಡು ತಗೊಳಕ್ ಇದೆ. ಈಗ ಒಂದ್ ಚಾನ್ಸ್ ತಗೊಂಡಿದ್ದೀರಿ, ನೋಡ ಏನೋ ಒಂದ್ ಚಾನ್ಸ್ ತಗೊಳ್ಳೋಣ ಅಂತ.
Chance ಅಲ್ಲ. I have legal grounds to enhance the compensation.
ಏನ್ ಹೇಳಿ ಹೋಗ್ಲಿ, ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
The compensation is awarded.
ಇದರಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡಂತದ್ದು ಏನಿದೆ?
ಅಲ್ಲ, consider the income taken by the court below is 4,500. And first appeal score taken 5,100.
ಒರಿಜಿನಲ್ ಸೂಟ್ ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು.
Original suit ಅಲ್ಲಿ ಕಡಿಮೆ ಅವಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ ಸರ್. By taking
ಎನ್ಹಾನ್ಸ್ ಆಗಿದೆ.
enhance ಆಗಿದೆ.
ಮತ್ತೇನೇನು?
The future prospects ತಗೊಂಡಿಲ್ಲ as per.
MEC ಕೇಸ್ ಏನ್ರಿ ಇದು? ಮತ್ತೆ
same principles has been adopted in the coordinate bench of this court, my lord. While granting the
the
compensation.
deceased on date of accident was 28 years.
And income has to be taken 5,500, and I have produced the valuation slip also, which is in page number 49, my lordship. And by adopting the same principle in the case of claiming the damages.
ತಪ್ಪೋದನಿಗೆ 28 ವರ್ಷ.
28 ವರ್ಷ.
ನೀವು ಈ ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡ್ಕೊಂಡು ಈ ಅಪೀಲ್ ಹಾಕಿದಿರಾ?
ಇಲ್ಲ, ಜಡ್ಜ್ಮೆಂಟ್ ಆಗಿರೋದೇ
ಅಪೀಲ್ ಗಿಂತ ಮುಂಚೆ.
ಜಡ್ಜ್ಮೆಂಟ್ ಗಿಂತ ಮುಂಚೆ ಹಾಕಿದೀನಿ ಸರ್.
ಆಫೀಸರ್ ಮಾಡಿದ್ರ ಅದರ್ ಸೈಡ್
ಆಫೀಸರ್ ಮಾಡಿ
ಅಮಿತ್ ಆನಂದ್ ನೋಟಿಸ್ ನಾಟ್ ಆರ್ಡರ್ ಅವರೇ ಬಂದವರು ಲೋಕಲ್
ಅವರೇ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ ಸರ್.
ವಕಾಲತ್ ಫೈಲ್ಡ್ ಬೈ ದೇಶಪಾಂಡೆ ಅಮಿತ್ ಆನಂದ್ is accepted and permitted to file objections if any within 2 weeks. List this matter on 22/7.
Much obliged.
P3.
ಮಂಜುನಾಥ್ DM grant leave. ಇಲ್ವಾ ಇಲ್ವಾ? ಎಷ್ಟನೇ ಸರಿ ಬಂದಿದೆ ನೋಡಿ?
Complaints first time ಬರ್ತಾ ಇದೆ sir.
First time, appellant counsel is absent. However, in the ends of justice, one more opportunity is given. List this matter on 22/7.
64,
If appellant counsel doesn't appear, appeal will be dismissed.
64,
13 days for delay.
Satish J. Nadi.
Yatish J. Nadiga. Ilva? Appellant counsel is absent. List this matter on 22/7. If counsel doesn't appear in the next date of hearing, appeal will be dismissed.
65,
Manjunath G.
Manjunath G.
Recall the order dated 10/6/24. Harish G. Manjunath G.
Pass over.
Pass over, yes, pass over.
66,
Chandranath Ariga. Maintenance of this appeal in view of section 100. ಏನಾಗಿದೆ ರಿಜೆಕ್ಷನ್ ಕ್ಲೈಂಟ್ ಅಲೋ ಆಗಿದೆಯಾ ಆದ್ರೂ ಆರ್ ಎಸ್ ಎ ಮೇಂಟೈನ್ ಆಗುತ್ತೆ ಮತ್ತೆ ಮೇಂಟೈನಬಿಲಿಟಿ ಮೇಲೆ ಹಾಕೋರು ಮೇಡಮ್
restored ಆಗಿ. Suit is restored ಅದಕ್ಕೆ.
ಸೂಟ್ ರೆಸ್ಟೋರ್ ಆದ್ರೆ ತಗೊಳ್ಳಿ ದಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಸ್ overruled and the second appeal is maintainable. List this matter for admission ಅಷ್ಟೇ ಬರ್ತಾರಾ ಆಯ್ತಾಯ್ತು ಪಾಸ್ ಅವ್ರು ಇಬ್ರು ಇದ್ರೆ ನಂದೇನು
67,
ದಯಾನಂದ್ ಸರಸ್ವತಿ ಅವ್ರು ಮೋಸ್ಟ್ಲಿ ಐಎನ್ಎಲ್ ಬರ್ಲಿ ಆಮೇಲೆ ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ ಅಂತ ಮೋಸ್ಟ್ಲಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಮೇಲೆ ಬರ್ಲಿ ಫೈನಲ್ ಇಯರಿಂಗ್ ಅಲ್ಲಿ ಬಂದಿತ್ತು ರೀಚ್ ಆಗಲ್ಲ ಅಂತ ಇದ್ರಲ್ಲಿ ಬರ್ಲಿ ಅಂದ್ರು ಅವರು ಅದಕ್ಕೋಸ್ಕರ ಇಟ್ಟಿದ್ದೆ ಹಾಗಾದ್ರೆ ಏನ್ ಮಾಡೋದ್ ಬೇಡ ಮೇಡಮ್ ಮೇಂಟೈನಬಿಲಿಟಿ ಆಮೇಲೆ ಬರೆಯೋಣ ಪಾಸ್ ಓವರ್
67,
67
Appellant,
TDF 50 days
50 days.
to notice an IA 1/24 and also on main against the respondent.
ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಸ್ಟೇ ಬೇಕಾದ್ರೆ ಟೆನೆನ್ಸಿ ಲ್ಯಾಂಡ್ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
ಆಯ್ತು ಡಿಲೇ ಇದೆಯಲ್ಲ 50 ದಿವಸ ಡಿಲೇ ಇದೆ ಹೋಗ್ಬರ್ಲಿ ನೋಟಿಸ್ ಹೋಗ್ಬರ್ಲಿ
Here this matters.
ಡಿಲೇ ಇದ್ದಾಗ ಹೆಂಗ್ ಕೊಡಕ್ಕಾಗುತ್ತೆ
ಯಾಕೆಂದ್ರೆ ಅಗ್ರಿಕಲ್ಚರಿಸ್ಟ್ ಅವರು ಅದರ್ ಸೈಡ್
ಕೌನ್ಸಿಲ್ ಡಿಲೇ ಇದ್ದಾಗ
taken a disposition of this is a tenanted land, my application
whatever
is
it may
pending
be,
before the.
whatever it may be, there is a delay. Next,
admission.
SV Prakash,
69, SV Prakash.
receipt filed by the counsel for appellant in a cash ಕಟ್ಟಿರ್ಬೇಕೇನ
For the appellate,
Huh?
it is a defense.
ಹೇಳಿ decreed confirmed suit for injunction
Suit for injunction.
ಹಾ
Completely, both the courts have relied upon the earlier alleged admission made by the father of the defendants in a suit, my lord. However, the property inherited by these defendants under a
inherited by
will.
the will ಆಯ್ತು
ಹೌದು.
who has executed the will
Yamuna Bai alias Gangamma.
ಹಾ
The suit property inherited by her from her mother.
ಆಯ್ತು
This aspect has not been properly considered. Only
that is not deciding of the title. Maybe property is inherited by her, but with regard to the possession is concerned, what is
possession, my lord.
material?
In the revenue records, even in column number 9, my name is, defense name is appearing. In column number 12, it is, our name is appearing. In spite of it, only the alleged admission made by the father in earlier suit filed by the plaintiff's father, it has been decreed. How far the alleged admission is
Go
admissible
to
binding
paragraph
on
number
the
13 and 14 counsel. And 15
my lord, it was
And
it has
16. And 16, ink page number 65. Contentions of defendants, ಅವ್ರು ಏನ್ ರಿಲೇ ಮಾಡಿದ್ದಾರೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅವೆಲ್ಲ ರಿಲೇ ಮಾಡಿದ್ದಾರೆ ನೋಡಿ.
my lord, I drive your lordship's attention to the year 1966 Supreme Court, my lord. Wherein Honorable Supreme Court has held that admission made by witness in other litigation is admissible against him alone, not against other defendants. We are not claiming through our father, my lord. The defendants not claiming the property through their father. It comes to them under a will. bequeathed by Yamuna Bai.
ಎಲ್ಲ ಬರ್ಲಿ ರೀ, ಅಪ್ಪ ಸ್ವಾಧೀನ ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಅಡ್ಮಿಷನ್ ಕೊಟ್ಟವನಲ್ಲ ಇನ್ ಅರ್ಲಿಯರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ.
But the revenue record speaks that we are in possession, our name is prevailing, my lord.
ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್
And
13, 14, 15 ಓದಿ.
Land Revenue Act 133 is have got a presumptive value.
ರೀಸನಿಂಗ್ ಹೋಗ್ರಿ 13, 14, 15 ಗೆ 16 ಆಲ್ಸೋ. Suit was filed in the year 2005 ಅಲ್ಲ?
ಹೌದು.
ಹಾ.
Even we have got
the
a
contention of the defendant that ನೀವು ಓದಕ್ ರೆಡಿ ಇಲ್ಲ, ನಾನೇ ಓದ್ಬಿಡ್ತೀನಿ. As
ಅಲ್ಲ,
the date of filing of
probate
the
has
suit,
been
the
issued
plaintiff
in
is
our
not in
favor, my
possession
lord.
over the suit shall property. In this regard, DW1 has produced exhibit D1 document which is the RTC in respect of the suit shall property, in which the name of the defendants are mentioned in column number 9 and 12. This document is for the year 2004, 2005, dated 18/8/2005.
Yes.
ಯಾವ ವರ್ಷ ಸೂಟ್ ಹಾಕಿದ್ರೋ ಆ ವರ್ಷದ ಸೂಟ್ ಅಲ್ಲಿ RTC ಡಿಪೆಂಡೆಂಟ್ ನೇಮ್ ಇದೆ ಒಂದು. Next, DW1 got marked the certified copy of judgment and decree passed in OS number 59 of 75 as against exhibit D2 and D3. Plaintiff has not denied the fact that defendant's father has applied for probate of will left by Srimati Paniyamma, who is the grandmother of the plaintiff and defendants.
Yes.
Further, DW1 has produced the certified copy of compromise petition filed in OS number 59 of 1975 as per exhibit D4. Admittedly, the name of the defendants in the RTC at column number 12 has been entered on the basis of the said probate order. Probate ಅಲ್ಲಿ compromise ಮಾಡ್ಕೊಂಡವ್ರೆ, ಅದ್ರ ಪ್ರಕಾರ ಎಂಟ್ರೀಸ್ ಮಾಡವ್ರೆ. Next, DW1 has produced the RTC
Our name, my
pertaining to
lord.
the suit shall
Defendant's
property
name
for
means
the year
our name.
2005, 6, 2006, 7, 2007, 8, 8, 9 and 2010 as per the exhibit D5 to 8. These documents have been obtained by the defendants after the filing of the suit. The defendants have not explained that how the name of the plaintiff is got entered in the RTC since 1969 to 2004, 2005. Further, DW1 has produced the tax paid receipts as per exhibit D9 to 12. These documents are also obtained after the filing of the suit. Exhibit P16 dated 17/8/2005, dated 18/8/2005. As per the exhibit P21, the name of the plaintiff is found placed in column number 12 to 2 of the RTC pertaining to social property. Since 1969 up to 2005, the name of the plaintiff could be seen in RTC, but suddenly without any notice to him, defendants have changed the entry in the RTC. Further, there is no evidence how the defendants got entered their name in the RTC.
My lord, yeah, all these in our favor, my lord.
Discussion.
Defendant's name are appearing from 1969. The
It's not
injunction suit.
defendant's name, plaintiff's name.
No, defendant's name. Deeded.
Plaintiff's
D9 to D12.
Hmm?
Further, DW has produced the receipts as per the D9 to 12. This is the defendant's appeal, my lord.
Defendant's appeal ರೀ. Plaintiff's entry ಅಲ್ಲ entry. 1967 ಇಂದ 2004, 5
Discussion ಅಲ್ಲಿ ಬಂದಿದ್ದಷ್ಟು
defendant's
defendants.
name enter ಆಗಿರೋದೇ ಈಗ 2004, 5
ಈಗಲ್ಲ.
ಅಲ್ಲಿ. ಹಾ.
ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ.
ಅದೇ
Pertaining to the
discuss
social
ಮಾಡೋದು
property since
track court ಅಲ್ಲಿ.
my lord. Now plaintiff could not be seen. Could not be seen, my lord.
You have to
In the
explain,
RTC.
you have to explain why your name has been entered in 2004 and 5 in RTC extracts ಅಂತ.
My lord,
Discuss
in
ಮಾಡಿದ್ದಾರೆ.
the above discussion,
ಹಾ?
probate ಮೇಲೆನೆ ಎಂಟ್ರಿ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಬಂದಿದೆ. 75 ನಲ್ಲಿ probate ತಗೊಂಡ್ರು, basing on the probate, it has been entered. They got mutated the name in
ಯಾವ
para
ವರ್ಷ
15.
ಯಾವ ವರ್ಷ ಎಂಟ್ರಿ ಆಗಿದ್ದದು?
ಇಲ್ಲಿ ಮೇಲೆ I read
ಹಾ.
14. Para 14 I read once again.
14 ಅಲ್ಲೇ
Further,
ರೀ ಓದಿದ್ದು.
ಅದೇ probate left by Srimati Paniyamma, who is the grandmother of the plaintiff and defendants. Further, DW1 has produced a certificate copy of the compromise
Pass
petition
as
filed in
appeared.
voice number 7. So as per exhibit D4, admittedly, the name of the defendants in the RTC column 12 class 2 has been entered
Entered on the basis of the said probate order.
So my name in column number 12 has been entered basing on the probate mail.
ಪ್ರೊಬೆಟ್ ಕಾಪಿ ಹಾಕಿದೀರಾ? ಯಾರಿಗೆ ಗ್ರಾಂಟ್ ಆಗಿರೋದು ಅದು?
Compromise ಆಗಿದೆ ಅಂತ admit ಆಗಿದೆ. It has been compromised.
ಕಾಂಪ್ರಮೈಸ್ ಕಾಪಿ ಹಾಕಿದೀರಾ? ಅವಾಗ ವೆದರ್ ದಿಸ್ ಪ್ರಾಪರ್ಟಿ ಏನಾದ್ರು ಕಾಂಪ್ರಮೈಸ್ ಅಲ್ಲಿ ಇದೆಯಾ? ಈ ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ
ಇದೆ,
ಟು ದ
ಇದೆ.
ಡಿಪೆಂಡೆಂಟ್ಸ್ ಅಂತ
ಇದೆ.
ಎಲ್ಲಿದೆ?
Exhibit D2 ಮೇಲೆ certificate copy of the judgment in voice number 59
ಹಾಕಿದೀರಾ?
ಹಾಕಿದೆ.
ಹಾ, ಏನಂತಿದೆ? ಯಾರಿಗೆ?
And also copy of the decree.
ಪ್ರಾಪರ್ಟಿ ಗೋಸ್ ಟು ಹೂಮ್ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಿ ಕಾಂಪ್ರಮೈಸ್.
ಈಗ ಇವರು ಡಿಫೆಂಡೆನ್ಸಿ.
ಅದೇ ಎಲ್ಲಿದೆ ರೀ? ಅದ್ರ ಬಗ್ಗೆ ಏನ್ ಆನ್ಸರ್ ಎಲಿಸಿಟ್ ಮಾಡ್ಸಿದೀರಾ?
my lord, these documents have been disbelieved. Explain ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. It is not a comprehensive suit, my lord. It
Suit
is
for
the burden
permanent
lies upon the
detention,
plaintiff to prove that they are, as on the date of suit, they are in
For
possession
permanent
enjoyment.
detention
But
ಅಲ್ವಾ?
ಹೌದು,
ಪ್ರೊಬೇಟ್ ಆರ್ಡರ್ ಆಗಿದ್ದು ಯಾವಾಗ?
75 ನಲ್ಲಿ.
75 ಇಂದ ನೀವು 2004-5 ವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
My lord, we are in cultivation.
Cultivation ಆಯ್ತ್ರಿ. No where it is entered your names from 69 to 2004-5.
My lord,
Huh?
the records we have, whatever they reveal, defendants
ಇಲ್ಲ madam.
evidence, my lord.
Call for records, ನೋಡೋಣ, then we'll see. Call for records. This matter on 29/7.
70.
ವಿಶ್ವೇಶ್ವರಯ್ಯ.
I appear for appellant.
ಹ್ಮ್. ಹ್ಮ್. ಹಾ.
Last time ತಾವು
Petition ಮಾಡಿದ್ರಲ್ಲ.
ತಾವು ಇದ್ ಮಾಡಿದ್ರಿ ಸ್ವಾಮಿ, ಅವರು ದೇವರ ಏನೋ ಆಸ್ಕಿಂಗ್ ಫಾರ್ 35 ಗುಂಟಾಸ್ ಆದ್ರೂ ಬೇಕು ಅಂದ್ರು. ನಮ್ ಅದಾ
ಟೋಟಲ್ ಇರೋದೇ 43 ಅಲ್ಲ,
ಅಲ್ಲ.
ಟೋಟಲ್ ಇರೋದೇ 43 ಗುಂಟಾಸ್.
ಇಲ್ಲ 2 acres 6 ಗುಂಟಾಸ್ ಇದೆ ಐಟಮ್ ನಂಬರ್ 1.
ಐಟಮ್ ನಂಬರ್ 1 ಅಲ್ಲಿ
2 acres 6 ಇದೆ ಒಟ್ಟು. ಅದನ್ನ 1/4 ಶೇರ್
6 ಗುಂಟಾಸ್ ಇದೆ. 40, 80 ಪ್ಲಸ್ 86 ಗುಂಟಾಸ್
ಹೌದು.
ಇದೆ. ಅಂದ್ರೆ ಅರ್ಧ ಬರುತ್ತೆ.
ಇಲ್ಲ 43 ಇಲ್ಲ
43
1/4 ಬರುತ್ತೆ ಇದ್ರ ಪ್ರಕಾರ. ಹಂಗಾದ್ರೆ ಆ ತರ ಆದ್ರೆ ಹಂಗಿಲ್ಲ. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾಯ್ತು ಸ್ವಾಮಿ, ಅವರು 35 ಗುಂಟಾಸ್ ಅಂದ್ರು. ನಮ್ಮವರು 10 ಗುಂಟೆ ಮೇಲೆ ಇಲ್ಲ 15 ಗುಂಟೆ ಆದ್ರೆ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳು. ತಾವೇ ಇಲ್ಲ ರೀ ಇಬ್ರಿಗೂ ಬೇಡ, ನೀವು ಸ್ವಲ್ಪ
25 ಅಂತಾನೆ ಹೇಳಿದ್ ನೆನಪು ನನಗೆ.
25 ಗುಂಟಾಸ್ 25 ಗುಂಟಾಸ್ ಅಂತ ತಾವ್ ಹೇಳಿದ್ರಿ. ಅದು ಅವರು
ಯಾರು 10 ಗುಂಟೆಲ್ ಇದ್ದಿದ್ದು 25.
ಹೌದು ಸ್ವಾಮಿ, ತಾವ್ ಹೇಳಿದಿಕ್ ನಾವು ಆಯ್ತು ಅಂತ ಕೇಳ್ತೀನಿ. ಇನ್ನು ಅವ್ರು ನಮ್ ಪಾರ್ಟಿ ಬಂದಿಲ್ಲ ಇವತ್ತು. ಅವ್ರ ಮೊಮ್ಮಗ ಬಂದಿದ್ದಾರೆ. ಅವ್ರಿಗೇನೋ ಈಸ್ ನಾಟ್ ಇನ್ ಎ ಪೊಸಿಷನ್.
ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್.
ಅಗ್ರಿಕಲ್ಚರ್
ಏನು ಕ್ರಾಪ್ ಏನು ಬೆಳೆಯೋದು?
ಕ್ರಾಪ್
ಆ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಏನ್ ಬೆಳಿತಾರೆ? ರೋಡ್ ಸೈಡ್ ಇದೆಯಾ? ಓ, ವ್ಯಾಲ್ಯೂ ಜಾಸ್ತಿ ಇದೆ ಅಂತ.
ಇದು ಕಳ್ಳೆ ವಿಜಯನ ಅಲ್ಲ. ಇದ್ರಲ್ಲಿ ಇನ್ನೊಂದ್ ಏನಾಗಿದೆ ಸ್ವಾಮಿ, ಅಕಾರ್ಡಿಂಗ್ ಟು ದೇಮ್ 8 acres ಆಫ್ ಲ್ಯಾಂಡ್ ದೇ ಹ್ಯಾವ್ ಆಲ್ರೆಡಿ ಸೋಲ್ಡ್.
ಎರಡು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕನ್ಕರೆಂಟ್ ಪೆಂಡಿಂಗ್.
ಇಲ್ಲ ಸೂಟ್ ವಾಸ್ ಡಿಸ್ಮಿಸ್ಡ್ ಬಿಫೋರ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
ಡಿಸ್ಮಿಸ್ಡ್.
ಫಸ್ಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಡಿಕ್ರೀಡ್ ದಿ ಸೂಟ್.
ಅದೇ ಪಾರ್ಟ್ಲಿ ಅಲೋಡ್.
partly allowed.
And 1/4 share.
1/4 share. Only dispute is regard to with item number 1 only, my lord. Other items, of course, 1/4 share ಇದೆ.
ನಿಮ್ಗೆ 5 ಜನ ಹೆಣ್ಮಕ್ಳು ಇದಾರ? ಅವ್ರಿಗೆ ಎಷ್ಟು ಜನ ಇದಾರೆ ಮಕ್ಳು?
ಅವ್ರಿಗೂ 5 ಜನ. ಅವ್ರಿಗೂ 5 ಜನ ಮಕ್ಕಳು.
ಅವ್ರಿಗೂ 5 ಜನ ಮಕ್ಕಳಲ್ಲ, ಹೆಣ್ಮಕ್ಳು ಅಷ್ಟೇ.
ಹೆಣ್ಣು ಮಕ್ಳು.
ಈಗೇನ್ ಹೆಣ್ಮಕ್ಳು ಗಂಡ್ ಮಕ್ಳು ಅಂತ ಏನ್ ಡಿಫ್ರೆನ್ಸ್ ಮಾಡಂಗಿಲ್ಲ.
4 ಜನ ಇದ್ದಾರೆ. ಅದ್ ಸರಿ ಅಲ್ಲ, ಅವ್ರು ಹೇಳಿದ್ದಕ್ಕೆ 4 ಜನ ಹೆಣ್ಮಕ್ಳು ಇದಾರಂತೆ ಅವ್ರ ತಾತ.
4 ಜನ ಹೆಣ್ಮಕ್ಳು.
ಹೌದು.
ಇವ್ರಿಗೆ 5 ಜನ.
ಯಾರಿಗೆ ಏನೋ 2 ಗಂಡು ಮಕ್ಳು 2 ಹೆಣ್ಣು ಮಕ್ಳು ಅಂತ ಹೇಳ್ತಾರೆ ಸುಮ್ಮನೆ.
ಏನೋ 2 ಹೆಣ್ಮಕ್ಳು 2 ಗಂಡು ಮಕ್ಳು ಅಂತಲ್ರಿ? ಈಗೇನ್ ಜೆಂಡರ್ ಚೇಂಜ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಏನಿದೆ ಹೇಳಿ. ಈಗೇನ್ ಜೆಂಡರ್ ಚೇಂಜ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಆಯ್ತ್ರಿ, ಒಂದು 30 ಮಾಡಿ ಅವ್ರಿಗೊಂದು 13 ಗುಂಟೆ ಎಕ್ಸ್ಟ್ರಾ ನೀವು ತಗೊಳ್ಳಿ.
ಅಲ್ಲ, ಇದು ಏನಾಗಿದೆ ಅಂದ್ರೆ ದಟ್ಸ್ ವೈ ಐ ಆಸ್ಕ್ ಮೈ ಪಾರ್ಟಿ ಟು ಪ್ರೆಸೆಂಟ್ ಹಿಯರ್. ತಾವ್ ಹೇಳ, ಬಿಕಾಸ್ ಇಫ್ ಐ ಸೇ ಎನಿಥಿಂಗ್ ಮೋರ್, ತಾವ್ ಹೇಳಿದಕ್ಕೆ ಸ್ವಾಮಿ. ಅಲ್ಲ ಹೌದು, 10 ಗುಂಟೆಯಿಂದ ಅವ್ರು 15 ಗುಂಟೆ ಅಂದ್ರು. ಆಯ್ತು, ತಾವು ಇಲ್ಲ ಅವ್ರು 35 ನೀವು ಒಂದು 15 ಕೆಳಗಡೆ 25 ಗುಂಟೆ, ಅವ್ರು 20 ಮೇಲೆ ಇಲ್ಲ ಅಂತ ಇದಾರೆ. ನಾನು ಇಫ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಟು 25 ಅಂದ್ರೆ ಅಟ್ ಲೀಸ್ಟ್ ಮೆಲಾಟ್ಸ್ ವಿ ಕ್ಯಾನ್. ಇಲ್ಲ ಅಂದ್ರೆ ಕಷ್ಟ.
20 ನಾನು 25 ಸಜೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ಡಿಫರೆನ್ಸ್ ಓನ್ಲಿ 18.
Yes.
18 ಗುಂಟಾಸ್. ಹ್ಮ್ 30 ಮಾಡಿ ಒಂದು 43 ನಲ್ಲಿ 30 ಕೊಡಿ ಅಷ್ಟೇ. 13 ಗುಂಟ ಬಿಟ್ಟಂಗ ಆಗುತ್ತೆ. 13 ಗುಂಟ ನಿಮಗ್ ಬಂದಂಗ ಆಗುತ್ತೆ. ವ್ಯಾಲ್ಯೂಯಬಲ್ ಪ್ರಾಪರ್ಟಿ ಅಂತಲ್ಲ.
ಹೌದು ಅದೊಂದೇ ಸಮೀರ್. ಅಂದ್ರೆ 2 acres.
ಅದಕ್ಕೆ ಇದು ಕುಸ್ತಿ ವ್ಯಾಲ್ಯೂಯಬಲ್ ಪ್ರಾಪರ್ಟಿ ಆಗೋತಿ ಇಲ್ದವ್ರಿಲ್ಲ.
It's very difficult for me to convince my client. That's why I asked him to present here.
Anyhow, totally he get 13 ಅಂದ್ರೆ 26 ಗುಂಟಾಸ್ ಮೋರ್ ದೆನ್ ದೆಮ್.
ಅಲ್ಲ ಅದು
ಅವ್ರು ಬಿಟ್ಕೊಡೋದು 13 ಗುಂಟೆ ಪ್ಲಸ್ 13 ಗುಂಟೆ ಅಂತಾರೆ. ಅವ್ರಿಗಿಂತ ಟೋಟಲ್ ಆಗಿ ಎಕ್ಸ್ಟ್ರಾ 26 ಗುಂಟಾಸ್ ಬರುತ್ತೆ ನಿಮ್ಗೆ. ಕಂಪೇರ್ ಟು ಹಿಮ್ 26 ಗುಂಟೆ ಬರುತ್ತೆ ಜಾಸ್ತಿ. ಅವ್ರು ಬಿಟ್ಕೊಡೋದು 13, ನಿಮ್ದು ಒಂದು 13. ಹ್ಮ್
Otherwise, divergent finding would maybe we may not make much of that. ಯಾಕಂದ್ರೆ oral partition ಅಂದ್ರೆ ಈಗ final court of fact has said oral partition is not. But that finding.
ಅಲ್ಲ ಅದೇ exhibit D1 is there, my lords. That was the by virtue of exhibit D1, this property is specifically allotted to this particular defendant. Of course, my lord, that is matter of merits. The 15 ಇಂದ 20 ಬಂದಿದೀವಿ, 25 ಹೇಳಿದೀರಾ, ದಟ್ ಅದನ್ನ ಮಾಡಿದ್ರೆ ವಿ ಕ್ಯಾನ್ ಕ್ಲೋಸ್ ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. ದಟ್ ಯಾಕೆಂದ್ರೆ ಮಿಕ್ಕಿದ ಪ್ರಾಪರ್ಟೀಸ್ ಇದೆ, ದಟ್ ಅದೆಲ್ಲ 1/4 ಶೇರ್ ಇದೆ.
ಆಯ್ತು 28 ತಗೊಳ್ಳಿ, 15 ಗುಂಟ ಬಿಟ್ಕೊಟ್ಬಿಡಿ. ಇನ್ ಬಿಟ್ವೀನ್ ಆಯ್ತು. ಯಾವಾಗ ಹೇಳ್ತೀರಿ ಹೇಳಿ. ಆಯ್ತು ತಗೊಳ್ಳಿ. ಕೌನ್ಸಿಲ್ ಫಾರ್
2 weeks time ಕೊಡಿ.
ಆಯ್ತು. ಲಿಸ್ಟ್ both counsel seeks time to report the settlement ಅಂತ ಹಾಕಿರ್ತೀನಿ. List this matter on 22/7. ನೋಡಿ ಮಾತನಾಡಿ. ಈಗ ಆಲ್ರೆಡಿ ನಾನೊಂದು ಸಜೆಸ್ಟ್ ಮಾಡಿದೆ 28 ಅದ್ರಲ್ಲಿ 15 ಅವರಿಗೆ ಕಡಿಮೆ ಆಗ್ತದೆ, ನಿಮಗೆ 15 ಗುಂಟ ಜಾಸ್ತಿ ಬರ್ತದೆ ನೋಡಿ.
71 ಚಂದ್ರನ ಸರ್ ಈಗ
partly decreed 1/3 in respect of A scheduled property confirmed. ಹೇಳ್ರಿ ಚಂದ್ರನಾಥ್ ತಾರೀಗ.
Kindly pass over.
ಆಯ್ತು. 72
It is Santosh.
SM legal.
There is a delay of 259 days, my lord, in filing the appeal.
ಯಾರು ಕ್ಲಿಯರ್ ಆಗಿದ್ದಾರಲ್ಲ?
ಕ್ಲಿಯರ್ ಆಗಿದ್ದಾರೆ. ನನಗೆ ಕಾಪಿನೂ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ. ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಾಪಿನೂ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ.
ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನಿದೆ? 250 days
215.
ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ, ನೋಡೋಣ ಬರ್ತಾರೆ. ಪಾಸ್ ಓವರ್ 73 ಬಾಲಕೃಷ್ಣ ಶಾಸ್ತ್ರಿ ಡಿಕ್ರೀಡ್ ಹಾಫ್ ಶೇರ್ ರಿವರ್ಸ್ಡ್ ಅಲ್ಲ?
My lord, seek an adjournment.
Why, madam?
Senior is present before Dharwad bench, my lord. Senior is present before Dharwad bench.
ಧಾರವಾಡ ಬೆಂಚ್ ನೀವೇ ಮಾಡಿ ಹೇಳಿ. ಡೈವರ್ಜೆಂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಲ್ಲ ಹೇಳಿ.
No, my lord.
ಹಾಫ್ ಶೇರ್ ರಿವರ್ಸಲ್ ಫೈಂಡಿಂಗ್ ಇದ್ದಂಗಿದೆ. ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆಯಾ? ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲ, ಕಾಲ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲ, ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಅಂಡ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 29 29 ಜಾಸ್ತಿ ಆಗಿರ್ಬೇಕು. ಮಂಗಳೂರಿಂದ ಬರುತ್ತೆ.
ಮಂಗಳೂರಿಂದ
22 ಬರಲ್ಲ, 37 ಕೊಡಿ ನೋಡಿ.
ಪ್ಲೀಸ್
ರೆಕಾರ್ಡ್ಸ್ ಬರಲಿ
ಪ್ಲೀಸ್.
74 ಪ್ರಸಾದ್ ಕೇಸ್. ಇಲ್ವಾ? ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. ಎಷ್ಟು ಸರಿ ಬಂದಿದೆ? ಅಡ್ಮಿಷನ್ ಫಸ್ಟ್ ಟೈಮ್, ಆಮೇಲೆ ಬಂದೇ ಅಲ್ವಾ 21 ಇಂದ? ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ, ಬರ್ತಾರೆ ನೋಡೋಣ. ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಮಧ್ಯಾಹ್ನ. 75
I'm for appellant, my lord.
Yes, madam.
A week's time kind.
No, madam.
My lord, I do file trace out ಆಗಿಲ್ಲ.
ಫೈಲ್ ಟ್ರೇಸ್ ಔಟ್ ಆಗಿಲ್ವಾ? ನಾನ್ ಬರಲ್ಲ ಹುಡ್ಕೊಡಕ್ಕೆ. ಮತ್ತೆ
That's why my inconvenience.
is it the reason, madam?
I search for the file.
No. ಹೆಸರು ಲಿಸ್ಟ್ ಆಗಿದೆ ನೋಡಿ. ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಶಂಕರ್ ಲಿಂಗಪ್ಪ ನಾಗರಾಜ್.
Last.
ಅದರ್ ಸೈಡ್ ಇಲ್ವಾ?
Other side already inform ಮಾಡಿದೀನಿ. I already informed the other side. My lord.
Apparent counsel seeks time and counsel for the respondent is also absent. This is the matter of the year 2018. And also this appeal is filed against the concurrent finding. And suit was dismissed before the trial court and the same is affirmed in the appellate court. However, in the ends of justice, one more opportunity is given. Since counsel praised time on the ground that file is misplaced. ಹೌದಾ? This matter on 22/7. ಮತ್ತೆ ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ.
Yes.
ನಿದ್ದೆ ಮಾಡಂಗಿಲ್ಲ ಇವತ್ತು ನಾಳೆ. ಫೈಲ್ ಸಿಗೋವರೆಗೂ.
26.
I am for
Appealing
the
for the respondent, my lord.
appellant.
Hmm.
Is plaintiff's appeal, my lord,
Hmm.
against the divergent finding.
Hmm.
The suit for declaration on the basis of the will dated
Cards
6/6.
ಬಂದಿದೆಯಾ?
The record has come.
Cards ಇದೆ. ಹಾ.
My lord, there is one more connected RSA,
ಯಾವ್ದು RSA?
1119 of 2018, my lords.
12/1
of
Ah.
2018, arising out of same common judgment.
common judgment.
Both
ಇನ್ನೊಂದು ಇದೆಯಾ?
suits were dismissed.
ಆಯ್ತು ನೋಡಿ. Respondent counsel submits that other RSA 1119
Please,
of 2018 is also pending arising out of the common judgment passed in RA. RA, ಅಲ್ವಾ?
please, my lord.
ಎರಡು RA.
Sir,
And hence list the same along with this appeal on 22/7.
much obliged.
30th,
22/7.
30,
Okay.
22 second, I am out of state.
22 ಇಲ್ಲ ಅಂದ್ರೆ next ಯಾವಾಗ ನೋಡಿ ಮೇಡಮ್.
ಆಗ್ಬೋದು.
23, 24,
ಆಗ್ಬೋದು.
23.
Much obliged.
77.
ಜನಾರ್ದನ್ GN. ಏನ್ ರೈತ್ರಿ ಕಂಪ್ಲೇಂಟ್ಸ್ ಅನ್ನ ಮಾಡಿದೀನಿ ಅಂತೀರಲ್ಲ?
ರೀಕಾಲ್ ಆದ್ಮೇಲೆ 27/6/2024 ಗೆ ನಾವು ಕಂಪ್ಲೇಂಟ್ ನೀಡ್ಫುಲ್ ಡನ್ ಅಂತ ಹೇಳಿದಾರೆ ಸರ್ ಕೊಲೀಗ್.
ಹೇಳಿದ್ರ ಸಾಲ್ರಿ ನೀಡ್ಫುಲ್ ಡನ್ ಅಂತ ನೀವ್ ಹೇಳಿದ ಸಬ್ಮಿಷನ್ ನಾವು ರೆಕಾರ್ಡ್ ಮಾಡಿರ್ತೀವಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಹೌದಾ? ಬಟ್ ಯು ಹ್ಯಾವ್ ನಾಟ್ ಕಂಪ್ಲೈಡ್ ಇಟ್.
ಅಲ್ಲ ಆಫ್ಟರ್ ರೀಕಾಲ್ ಆದ್ಮೇಲೆ 27/6 ಗೆ
ಪಾರ್ಷಿಯಲ್ ಇದೆ ಅಂತ ಇನ್ನು 2 ಇದೆ ಅಂತ ನೋಡಿ ಕೊಡಿ
ಎಲ್ಲ
ಅದೇಲ್ಲ.
ಒಂದ್ಸಲ ಎನ್ಕ್ವೈರಿ ಮಾಡ್ತೀನಿ ಸರ್.
ಸ್ಪೆಸಿಫಿಕ್ ಇಂಡಿವಿಜುವಲ್ ರ್ಯಾಂಕಿಂಗ್ ಟು ಬಿ ಸ್ಟೇಟೆಡ್ ಅದನ್ನ ಹಾಕ್ಬೇಕು ಕರೆಕ್ಟ್ಲಿ ಇನ್ ಕಾಸ್ಟ್ ಟೈಟಲ್. ಅದನ್ನ ಮಾಡಕ್ಕೇನು? ಸೀರಿಯಲ್ ನಂಬರ್ ಗಿವನ್ ಟು ಡೆಡ್ ಪರ್ಸನ್ಸ್ ಇನ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಟು ಬಿ ರೆಕ್ಟಿಫೈಡ್. ಇವನ್ ಇಲ್ಲೇ ಮಾಡಿ ತಗೊಳ್ಳಿ, ಮಾಡಿ ಪಾಸ್ ಓವರ್ ಮಾಡಿ. ರ್ಯಾಂಕಿಂಗ್ ಹೇಳಕ್ಕೇನು? ಪಾಸ್ ಓವರ್
78.
ಆಫ್ಟರ್ ರೀಕಾಲ್ ಮಾಡಿದ್ರು ಮಾಡಲ್ವಲ್ರಿ?
79 R Shashidhar, K Ram Bhatt.
ಆರ್ ಶಶಿಧರ, ಕೆ ರಾಮ್ ಭಟ್.
Correspondent.
5
to 9 5 to 9.
ಸೂಟ್ ಫಾರ್ ಪಟಿಷನ್ ಇಲ್ವಾ ಅವರು? ಶಶಿಧರ್
ಎಲ್ಲ ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ, ಅದಕ್ಕೆ ಬರ್ತಾ ಇಲ್ಲ ಮೋಸ್ಟ್ಲಿ.
ಹೌದಾ? ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
ಸೆಟ್ಲ್ ಅಂದ್ರೆ FDP ಅಲ್ಲಿ ಯಾರು ಇದು ಕಂಟೆಸ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ.
FDP ಯಾರು ಕಂಟೆಸ್ಟ್ ಮಾಡಿಲ್ಲ. FDP ಆಲ್ರೆಡಿ ಫೈನಲ್ ಡಿಗ್ರಿ ಆಗೋಗಿದೆ.
ಫೈನಲ್ ಡ್ರಾ ಮಾಡ್ಲಿಕ್ಕೆ ಪೆಂಡಿಂಗ್ ಇದೆ, ಸರ್ವೆ ಎಲ್ಲ ಆಗಿದೆ.
ಆಗಿದೆ. ಓ, ಸ್ಟೇ ಇರೋದ್ರಿಂದ ಫೈನಲ್ ಡಿಗ್ರಿ
ಸ್ಟೇ ಇಲ್ಲ, ಸ್ಟೇ ಇಲ್ಲ.
ಮತ್ತೆ ಫೈನಲ್ ಡಿಗ್ರಿ ಡ್ರಾ ಮಾಡಕ್ಕೆ ಟ್ರಯಲ್ ಕೊಟ್ಟು
ಏನೋ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ, ಅಮೆಂಡ್ಮೆಂಟ್ ಅಂತ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು, ಅದಕ್ಕೆ ಪೆಂಡಿಂಗ್ ಆಯ್ತು.
ನೋಡೋಣ ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ.
ಅನದರ್ ಕನೆಕ್ಟೆಡ್ ಸೂಟ್ ಆಲ್ರೆಡಿ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಕನೆಕ್ಟೆಡ್ ಬೇರೆ ಇತ್ತಾ?
RSA
ಅದೇನು ಹಾಕಿದ್ರಲ್ಲ DD ಫೈಲ್ RSA
ಅದು
1570
ಡಿಸ್ಪೋಸ್
ಜೊತೆಗಿದೆ ನೋಡಿ ಮೇಡಮ್.
ಅದು ವಿಡ್ರಾ ಮಾಡಿದ್ದಾರೆ. ಅದು 2 ಜಡ್ಜ್ಮೆಂಟ್ ಮೇಲೆ ಬಂತು, ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್.
ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಮೇಲೆ ಒಂದು ವಿಡ್ರಾ ಮಾಡಿದ್ದಾರೆ. ರೀಸನ್ ಏನು ಡ್ರಾಯಲ್ಗೆ ನೋಡಿ?
ಸೆಟ್ಲ್ ಮಾಡಿಕೊಂಡಿದ್ದಾರೆ. ಸಮ್ ಪೋರ್ಷನ್ ಹ್ಯಾವ್ ಸೋಲ್ಡ್.
Appellants have filed a memo seeking permission of this court to withdraw the appeal on the ground that dispute between the parties is settled out of the court. The same memo is identified by the counsel. Counsel for the appellants. In view of the said memo, the appeal is dismissed as withdrawn. First day of September 2023.
ಹೌದು, ಅದಲ್ಲಂದ್ರೆ ಹರಿನಾಥ್ ಬಾಬು
ಬಂದಿದಾರ ನೋಡಿ.
ಇಲ್ಲ, they are
Why this connected matter also listed?
ಹರಿನಾಥ್ ಬಾಬು, they are the buyers, purchasers.
It's also pending arising of the same judgment. This is directed to this.
ಪಾಸ್ ಓವರ್ ಮಾಡಿ ನೋಡೋಣ.
ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನೋ ಮೋರ್ ಡೈಡ್. ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಲ್ಲ.
ನೋಡೋಣ ಅವ್ರು ಏನ್ ಬಂದು ಹೇಳ್ತಾರೆ ಹೇಳಿ.
Please,
ಪಾಸ್ ಓವರ್, ಪಾಸ್ ಓವರ್.
Shift kind leave me not.
Ah.
The earlier matter, it
Ah.
was, they have taken time. Appellant has
ಯಾವ್ದ್ರಲ್ಲಿ ಹೇಳಿ?
taken
Serial number.
78 million, earlier matter.
ಹಾ,
It appears appellant has taken time. I was not informed about it. And it was posted to 22nd of this month. That week I have got inconvenience mail. I will be out of station during.
ನಿಮ್ಗೆ ಹೇಳಿದ್ರು ಏನಾರು ಹೇಳಿದ್ರ ಇಲ್ಲ?
ಇಲ್ಲ ಹೇಳಿಲ್ಲ.
ನಾನು ಐ ಆಮ್ ವೆರಿ ಸ್ಪೆಸಿಫಿಕ್. ನನ್ಗೆ ಗೊತ್ತು ಸುಳ್ಳು ಹೇಳ್ತಾರೆ ಅಂತ, ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದೆ. ಇಫ್ ಅದರ್ ಸೈಡ್ ಕಮ್ಸ್ ಅಂಡ್ ಟೆಲ್ಸ್ ನೋ ಸಚ್ ಇಂಟಿಮೇಶನ್, ಐ ವಿಲ್ ಟೇಕ್ ಅಪ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಅಂತ ಅವ್ರಿಗೆ ಹೇಳಿದ್ದೆ.
I am not informed about the adjournment.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ. ಮತ್ತೆ ಅದು 22ನೇ ತಾರೀಕಿಗೆ ಹೋಗಿದೆ ಅಂತ ಹೇಳಿದ್ರು. ಅವತ್ತು ಆ ವೀಕ್ ನಲ್ಲಿ ನಾನು ಊರಲ್ಲಿ ಇರುವುದಿಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಇರ್ತೀರಾ?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನಲ್ಲಿ ಇರ್ತೀನಿ.
ತಗೊಳ್ಳಿ. The counsel appearing for the respondent would submit that by making false admission, adjournment was taken and no intimation was given. And while taking date mentioned, it was mentioned that already informed the council. And this court also, while granting time, also made it clear that if any false submission is made before the court, appeal will be taken up for consideration, but counsel is absent. Counsel for the appellant is absent. And in view of making a false submission and getting an order of adjournment, cost of rupees 1,000 is imposed. And cost is payable at registry. And list this matter on. Yadar date kodi? Next week alle kodi. 11/7. ಯಾರಿ ಲೋಡ್ ಮರಿಯಪ್ಪ ಆಫೀಸ್ನವ್ರು ಯಾರು ಇಲ್ವಾ? ಎಲೆ ಲೋಡ್ ಮರಿಯಪ್ಪ.
ಇನ್ನೊಂದು ಕೇಳಿದ್ರು ನೀವು
ಇನ್ನೊಂದು ಕೇಳಿದ್ರಾ?
ಇನ್ನೊಂದು ಕೇಳಿದ್ರು ನೀವು ಕೊಡ್ಲಿಲ್ಲ 86.
ಸರಿ ಆಯ್ತು ಆಯ್ತು, ಕಾಸ್ಟ್ ಕಟ್ಲಿ, ದಂಡ ಕಟ್ಲಿ ಸುಳ್ಳು ಹೇಳಿದ್ಕೆ. 11/7 ಕೊಟ್ಟಿದ್ದೀನಿ. ಅವಾಗ ಇರ್ತೀರಲ್ಲ ನೀವು? ಆಯ್ತು.
80 ಅರ್ಜುನ್ 81
ಅರ್ಲಿಯರ್ ಏನ್ ಡಿಕ್ಟೇಷನ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಬೆಳಗ್ಗೆ, ಅದು ಕಂಟಿನ್ಯೂಯೇಷನ್ ಇದು.
81 ಕಾರ್ಯಗೌಡ
81. Decreed.
Injunction suit filed by.
Concurrent pending. ಯಾರೊಬ್ರು ಬರ್ತಾ ಇದ್ರಲ್ರಿ ಅವ್ರ ಕೊಲೀಗ್ ಯಾರ? ಸೀನಿಯರ್ ಹುಷಾರಿಲ್ಲ, ಸೀನಿಯರ್ ಹುಷಾರಿಲ್ಲ ಅಂತ.
Submission was made in the other court also that is not.
ಅವ್ರೇನ್ ಸ್ಟಿಲ್ ಹುಷಾರಾಗಿಲ್ಲ ಅವರು? ಇಲ್ಲ ಎಷ್ಟಲ್ಲ NOC ಏನ ತಗೊಂಡು ಹಾಕ್ತೀನಿ ಅಂತ ಕೊಡ್ತಾ ಇದಾರಂತ. ಆಯ್ತು, ಇನ್ನೊಂದು ಡೇಟ್ ಕೊಡೋಣ ನೋಡ ತೊಗೊಳ್ಳಿ. Appellant counsel is absent, counsel for respondent is absent.
I am responding.
Sorry, ಏನ್ ಹೇಳಿದೆ? ಉಲ್ಟಾ ಹೇಳಿದ್ನಾ? Appellant counsel is absent, respondent counsel is present. If appellant counsel doesn't appear in the next state of hearing, appeal will be dismissed for non-prosecution. List this matter on 22/7.
82 Arjun 83 MM Ashok.
For the appellant, my lord, this is defendant's appeal against the divergent finding of the
Suit for partition. Reverse ಮಾಡಿ 1/4 share ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು.
ಅದರ್ ಸೈಡ್ ಇಂದ ಅಪಿಯರ್ ಆಗಿಲ್ಲಲ್ಲ?
ಇಲ್ಲ.
ಆಯ್ತು, ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್, ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಂಡ್ ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್.
84
Is this matter on date ಕೊಡಿ, ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ. 5/8.
84 Arjun 85.
84 ಅರ್ಜೆಂಟ್. 85 ಪಾಸ್ ಓವರ್ ಮಾಡಿರಿ ಇಲ್ಲಲ್ಲ ಪುಂಡಿಕಾಯಿ ಅವರು? ಪಾಸ್ ಓವರ್.
86
86 ಲೋಡ್ ಮರಿಯಪ್ಪ. ಇದ್ರಲ್ಲೂ ಟೈಮ್ ಕೇಳಿದ್ರಾ? ಕೊಡ್ಲಿಲ್ಲ. ಪಾಸ್ ಓವರ್ ಮಾಡಿ.
87
ಮಂಜುನಾಥ್ ರಾವ್ ಬೋನ್ಸ್ಲೆ. This counsel please
Respondent, my lord.
partly decreed as owner of A schedule property allowed in appeal. Entitled
Possession has been given.
Earlier possession was not given in the appeal.
Only
possession was
declared as
given.
a owner.
Possession was given.
Yes, my lord. In the first appellate court, possession has given. Encroachment has been proved by.
ಎಷ್ಟಾಗಿರೋದು? ಒಂದೇ ಅಲ್ವಾ ಹಿಂದೇನು?
ಇಲ್ಲ, ಇವತ್ತೇ ಫಸ್ಟ್ ಬರ್ತಾ ಇದೆ.
ಫಸ್ಟ್ ಟೈಮ್
ಬರ್ಲೇ ಇಲ್ವಲ್ಲ ಅಂತ ನಾನೇ ಮೂವ್ ಮಾಡಿದ್ದೆ.
19 ಆದ್ಮೇಲೆ ಫಸ್ಟ್ ಟೈಮ್. ಎಲ್ಲ ಫೈಲ್ ಮಲಗಿಸ್ತಾವೆಲ್ಲ ಹೇಳಿಸ್ತಾ ಇದೀವಿ ನಾವು. ಆಯ್ತು.
ಇಲ್ಲ, ನಾನ್ ಮೂವ್ ಮಾಡಿದೆ ಅದನ್ನ.
ನೀವು ಮೂವ್ ಮಾಡಿದಿರಿ ಇದ್ರಲ್ಲಿ?
ಹೌದೌದು.
ಅದು ಬರ್ತಾ ಇರ್ಲಿಲ್ಲ ನಾ. ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ ನೋಡೋಣ ಬರ್ತಾರ.
88
ಇಲ್ಲ, ಹೊರಗಡೆ ನಿಂತ್ಕೊಂಡು ವಾಚ್ ಮಾಡ್ತಾ ಇರ್ತಾರೆ.
88 M Srinivas SP Prakash.
Number 1 and 2 in this one.
SP Prakash R3 M Srinivasa. ನೋಡಿ ಮೇಡಮ್, ಇದು ಇಲ್ವಾ ಪಾಸ್ ಓವರ್? ಎಲ್ಲ ಪಾಸ್ ಓವರ್. ಕರುಂಬಯ್ಯ
89
Award by judgment in similar matter ವಜಾಗಿದೆ. Last time ಒಂದು ವಿಡ್ರಾ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. Your lordship has dismissed the connected appeal.
Already you have dismissed. Yes madam.
Pass over, my lord. Kindly pass over.
Pass over.
Court sir ತಗೊಳ್ಳಿ.
ಕೊಡೋದೇನ್ ನೋಡೋಣ.
ಇನ್ನೊಂದು appeal ಅವರೇ ಹಾಕಿದ್ರು.
Same similar set of facts.
ಅವರೇ connected matter.
Connected. ತೋಪಮ್ಮ.
ಹೌದು. Same appellant. ಆರ್ಡರ್ ಕಾಪಿ ಅವತ್ತು ಇರ್ಲಿಲ್ಲ, ತಂದು ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಟೈಮ್ ತಗೊಂಡು.
In this case, there was a sale agreement and there was a stipulation in the sale agreement that the Fragmentation Act is prevailing and hence plaintiff cannot execute the document and the sale deed would be executed after the repealment of Fragmentation Act. Admittedly, the Fragmentation Act repealed in the year 1991 itself and suit was filed in the year 2011. All these factors have taken note of by the trial court as well as the first appellate court, considering governments made in the plaint, and no doubt it's settled law that court has to look into the governments made in the plaint and document with regard to the claim made by the plaintiff, and having considered the same, only an order has been passed, and hence I do not find any error committed by both the courts. Yes, madam.
Similar, ಅವತ್ತು ಆರ್ಡರ್ ಕಾಪಿ ಇರ್ಲಿಲ್ಲ ಅದಕ್ಕೆ ಟೈಮ್ ತಗೊಂಡು.
ಏನೇ ಪಾಸ್ ಓವರ್ ಸೀನಿಯರ್ ಬಂದು ಏನಾರು ಹೇಳೋದಿದ್ರೆ ಹೇಳಿ.
ಆಯ್ತು.
ಪಾಸ್ ಓವರ್. Pass over. Today is the Passover day.
91.
Hmm.
Miss Manjanna.
MS Manjanna, dismissed for non-prosecution ಅಂತ ಇಟ್ಟಿದೀವಿ ನೋಡಿ. ನೋಡಿ. ಬರ್ಕೊಳ್ಳಿ. This court-wide order dated 26/24. Taken note of appeal is of the year 2019. And appellant counsel is not pursuing the matter diligently. However, in the ends of justice, given one more opportunity to the counsel for the appellant. And also made it clear that if the counsel for the appellant doesn't appear in the next date of hearing, the appeal will be dismissed for non-prosecution. And in spite of this order also, the appellant counsel is not pursuing the matter and today also absent before the court. And hence, appeal is dismissed in view of the order dated 26/2024 for non-prosecution.
92. Somshekar came.
Somashekara came. Pass over.
93. Balraj AC. GB Shastri.
ಏನ್ರಿ ಏನಾರು ಹೊರಗಡೆ ಬೇರೆ ಏನಾರು ಆಯ್ತನ್ರಿ? ಏನಾರು ಯಾವ್ದಾರ ಇನ್ಸಿಡೆಂಟ್ ಏನಾರು ನೋಡಕ್ ಹೋಗೋರ ಏನು ಲಾಯರ್ಗಳೆಲ್ಲ ಒಬ್ರು ಇಲ್ಲ ಮತ್ತೆ ಯಾರು ಫಿಲ್ಮ್ ಆಕ್ಟ್ರೆಸ್ ಏನಾರು ಬಂದವ್ರೆ ನೋಡಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 69 ಇಂದ 90 ವರೆಗೂ ಬಂದ್ರೆ ಒಬ್ರು ಲಾಯರ್ ಇಲ್ಲ ಅಡ್ಮಿಷನ್ಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ಕೆ. ಅದಕ್ಕೆ ಡೌಟ್. ಆಯ್ತು.
93 ಪಾಸ್ ಓವರ್ ಮಾಡಿ.
90
93.
ಅದು ಪಾಸ್ ಓವರ್.
94. BS Nagraj. R2 ಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡಿದ್ದಾರೆ ಸರ್. R2 ಸೆಟ್ ಹೋಗಿದ್ದಾರೆ.
ಬ್ರಿಂಗಿಂಗ್ ಎಲ್ಲಾರ್ಸ್ ಆಫ್ ಡಿಸೀಸ್ಡ್ R2 ನಾ
ಮೇಲ್ ಕಂಪ್ಲೈನ್ಸ್ ಇದೆ.
ಅದು ಕಂಪ್ಲೇಂಟ್ಸ್ ಇದೆ. ಆಯ್ತು ಇಡಿ ಪಾಸ್ ಓವರ್. ಮತ್ತೊಂದ್ ರೌಂಡ್ ಕರ್ಸನ ಯಾರು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ. 95 ಚಂದ್ರಶೇಖರ TA ಸ್ಫೂರ್ತಿ ಹೆಗಡೆ.
93 ಪಾಸ್ ಓವರ್.
93 ರೆಡಿ ಇದೀರಾ? ಅಟ್ಲೀಸ್ಟ್ ನಿಮ್ಮನ್ನಾರು ಕೇಳೋಣ ಹೇಳಿ. ಬಾಲಕೃಷ್ಣ ಶಾಸ್ತ್ರಿ.
Suit for partition, the plaintiff suit. And so the trial court has partly declared the suit in respect of one item of the property. And in respect of another item, it has rejected. That has been confirmed by the lower appellate court. And my lord, in the
Only one extent of 1 acre ಮಾತ್ರ.
yes,
Item number 1.
yes, my lord.
The extent of 1 acre standing in the name of defendant number 7 is dismissed.
Yes, my lord.
However, suit property item number 1 to 1 to extent of 2 acre 18 guntas in survey number 24/1 standing in the name of the defendant number 1 is hereby decreed.
Yes, my lord, in 18, respondent number 1 is the father of the appellants, my lord. And my lord,
Respondent number?
1, my lord. He is the father of the appellants, my lord. But in 1987, my lord, he sold the property. And both the courts below, my lord, held that, my lord, the sale is for legal necessities. That is the only point, my lord, which is
No, it is a challenge made by the plaintiff.
Yes, my lord.
Reasoning ಏನು?
Reasoning, my lord, the sale is for legal and family necessities ಅಂತ.
ಯಾವಾಗ ಸೇಲ್ ಮಾಡಿದ್ದು?
1987, my lord.
1987. Challenge was made in the year
My lord, it was in the year 2008, my lord.
2008.
Yes, my lord.
Why they kept quiet from 87 to 2008?
My lord, it was said, my lord,
What was the age of plaintiff as on the date of filing of the suit?
my lord, plaintiff, my lord, age of suit 50 years. my
ವರ್ಷ.
lord. 50 years and 42 years.
ಮತ್ತೆ? ಇನ್ನೇನಾದ್ರು ಜಾಸ್ತಿ ಬರ್ತದ ಅಂತ ಅವನ ಮತ್ತೆ ವಸೂಲಿ. ತೃಪ್ತಿ ಆಗ್ಲಿಲ್ವಾ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಕೊಟ್ಟಿರೋದು ಮತ್ತೆ ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
My lord, serial number 94, I appear for the respondent number 2, my lord.
93, madam, now 93.
Apologize.
Only contention is that, my lord, there is no pleadings by the respondents that, my lord, to establish that the sale was for legal and family necessities. Neither any evidence was let in to show that sale was for the legal necessities.
Issue number 2 na?
Yes, my lord. No, ಅದ್ರ ಬಗ್ಗೆ legal necessity ಬಗ್ಗೆ there is no issues, man. Only say that it's.
ಡಾಕ್ಟರ್ಸ್ ಹಾಕಿರೋ ಸೂಟ ಇದು.
ಹೌದೌದು, ಡಾಟರ್ಸ್ ಹಾಕಿದ್ರು.
ಅವರೆಲ್ಲ ಮದುವೆ ಆಗಿದೆ ಅವಾಗ?
ಮದುವೆ ಲಾಂಗ್ ಬ್ಯಾಕ್.
ಈ ಪ್ರಾಪರ್ಟಿನ ಮಾರಾಟ ಮಾಡಿದ್ಮೇಲೆ ಮದುವೆ ಮಾಡಿರ್ಬೇಕು ನೋಡಿ. ಈ ಪ್ರಾಪರ್ಟಿ ಮಾರಾಟ ಮಾಡಿ ಹೆಣ್ಮಕ್ಳು ಮದುವೆ ಮಾಡಿರ್ಬೇಕು. ಆಮೇಲೆ ಮದುವೆ ಆಗಿ 25 ವರ್ಷದ ಮೇಲೆ ಸೂಟ್ ಹಾಕೊಳ್ಳೋದು. ಇದೆ ನೋಡಿ, ವಾಟ್ ಐ ಎಕ್ಸ್ಪೆಕ್ಟೆಡ್ ದಟ್ ಈಸ್ ದೇರ್ ಇನ್ paragraph number 17.
Yes.
Sale was executed for the legal necessity who had to perform the marriage of defendant number 2 to 6 and plaintiff number 1 and 2. The exhibit D1 reads ಶುದ್ಧ ಕ್ರಯಪತ್ರ ನನ್ನ ವಾಸದ ಮನೆಯನ್ನು ಕಟ್ಟಿಸುವ ಸಲುವಾಗಿ. Exhibit D3 also reads reflect towards legal necessity. Defendant number 1, defendant number 7 based upon the title of defendant number 1 who had acquired property by way of IHR way back in the year 1987. 91, 92 itself, and also above the plaintiffs have to prove that sale deed in favor of defendant number 7 by defendant was by way of fraud or misrepresentation as contended by them. No grounds. Third, this matter is listed for admission and heard the counsel appearing to the appellant and respondent. The second appeal is filed against the concurrent finding and suit is filed for the relation of declaration and permanent injunction. Injunction or partition, Ritu?
Partition.
Declaration.
So it is
Mostly sale deed no, it matter.
not binding anta.
Injunction. Legitimate share. The suit is filed for the relief of declaration of plaintiff. Entitlement of their legitimate share to extent of 2/8 share with consequential relief of permanent injunction. The plaintiffs the plaintiffs in the suit, it is contended that plaintiffs and defendant number 1 to 6 are the members of Hindu undivided family and the suit scheduled properties are the joint family properties. And the sale made by the defendant number 1 in favor of the defendant number 7 is not binding on their shares. And defendant number 2, 4 to 6 also claimed the share in the social property. And it is the case of the defendants number 7, who is the purchaser, contended that court has no peculiar jurisdiction and suit is also barred by time. And also the suit is bad for partial partition and suit is also bad for non-joinder of necessary parties. And trial court, taking into note of oral and documentary evidence, comes to the conclusion of they are the undivided joint family members, but comes to the conclusion that suit scheduled properties which they have claimed already sold in favor of defendant number 7 by defendant number 1. And while answering issue number 3 and additional issue number 1, given the finding that the recital made in the document itself in exhibit D1 and D3, and the same is for the purpose of construction of the house. And D3 also reflects that towards the legal necessity of defendant number 1. That too for the performing the marriages of defendant number 2 to 6 as well as plaintiff number 1 and 2, considering the material on record, and hence comes to the conclusion that plaintiffs are not entitled for any relief. Being agreed by the said judgment and decree of the trial court, an appeal is filed by the plaintiffs and the same is also numbered as RA 38 of 2016, and considering the grounds which have been urged by the appellant plaintiffs before the first appellate court. First appellate court also formulated the point whether the judgment and decree of the trial court is perverse and unsupported by any evidence, and whether it looks, whether it requires interference of the appellate court. And appellate court, having reconsidered the material on record, both oral and documentary evidence, answered the points as negative in coming to the conclusion that PW1 showed ignorance that the property value is increasing in market, and also taken note of sale deed executed by D1 in favor of D7. And when the allegation was made that seventh defendant has played fraud with the first defendant by creating false and fabricated documents, no such material is placed before the court. And also taken note of the recitals of document exhibit D1 to 3, and the sale was made for family maintenance and for construction of house and legal necessity. and hence confirm the judgment of the trial court. Being agreed by the said judgment and decree of concurrent finding that the present second appeal is filed and counsel appearing for the appellant would vehemently contend that both the courts have committed an error in coming to the conclusion that sale deed executed by the defendant number 1 in favor of defendant number 7 is for the legal necessity. And both the courts are not justified in holding that suit properties were disposed of for meeting family and legal necessity, though no evidence were led in by the respondents to prove any kind of such necessities. And hence matter requires reconsideration. For contrary, the counsel appearing to the respondent would submit that both the courts having considered particularly the documentary evidence of exhibit D1 to D3, recitals of the documents are also taken note of, and sale was made for the construction of the house and also for performing the marriages of defendant number 2 to 6 as well as plaintiff number 1 and 2. And the said material was considered while considering the issue number 3 and additional issue number 1. And not committed any error. Having heard the appellant counsel and also the counsel appearing for the respondent, and also it is important to note that properties were sold in the year 1987-88 and also 91-92, and suit is filed in the year 2008, that too by the two daughters. And also while selling the property, particularly the document exhibit D1, recitals is very clear that sale is made for the construction of the house. And also recitals of document exhibit D3 is also very clear that sale is made for the legal necessity. And suit is filed after almost 30 years. Suit is filed almost after 30 years. And while filing the suit, their age is mentioned as 50 of the first plaintiff and 42 of the second.
21 years. 21 years. 87 my lord, sale. 97, 2007, 2008. 20 years.
88, 90, 20, 18, 21 years. 30 alla madam, adu 21 years. And also having considered the age of the plaintiffs also not filed the suit within 3 years of the sale. And even at the time of the first plaintiff was also major. Hodala.
As
First and second, Ibru majors.
major.
Both are majors.
Both are.
And apart from that, the documents are also very clear that sale was for the benefit of the family, that too for the construction of the house and also performing the marriage and also for the legal necessity. And when such materials available on record, I do not find any error committed by both the trial court as well as the first appellate court in decreeing the suit only in respect of one of the item of the property and in respect of the property which have already been sold. Rightly comes to the conclusion that those properties are not amenable for partition. Hence, no grounds are made out to invoke section 100 of CPC to admit and frame substantive question of law. In view of the discussions made up, I pass the following order. Second appeal is dismissed.
94.
For the third respondent, they filed an LR supplication. I'll file objections because they seek to bring second respondent's wife. She's already separated from the second respondent. Second respondent committed suicide owing to that. She's remarried now. That being the case, she'll not be an LR of the second respondent.
I complaints in the office objections.
Date
IS 123 bringing LRs of deceased complaints. Last time order sheet kodi.
Complaints, I have served the notice to the respondent number 4. I have filed the LR application because it is.
Counsel for the appellant submits that copy is served on the respondent number 4 Ratnamma, and while filing the memo by mistake, it is mentioned as Mahadevamma instead of Ratnamma, hence held sufficient against respondent number 4. The counsel for the appellant seeks time to file memo since he submits that deceased respondent number 2 is not having legal representatives. Accordingly, 1 week time is granted ಅಂತ ಕೊಟ್ಟಿದ್ದೀವಿ ನಿಮ್ಗೆ.
ಕೊಟ್ಟಿದ್ರಿ, but
ಹಾ.
I have ascertained his wife is Bhagya is there.
ಹಾ.
And he says for giving the partition and all that, what is happened in the, within the family of that. He has not even submitted before this honorable court, where this honorable court is noticed, they know not served the copy and respondent. And all that, he several times is comes before this honorable court. And he is not disclosed the death of, even death of the respondent number 3. That is why I have ascertained and filed this application. If not necessary, my lord, let them produce the documents.
Please, office objections ಬಗ್ಗೆ ಹೇಳಿ ನೀವು.
The other office
Time
objection.
to file memo, since he submits that deceased respondent number 2 is not having any legal representatives ಅಂತ ನೀವು ಹೇಳಿದಿರಿ.
ಅದು ಹೇಳಿದ್ದೀವಿ, but I ascertained that there is a legal representative. ಅದಕ್ಕೋಸ್ಕರ I have filed the application. I have filed the application for bringing the LRs of respondent number 3. My learned friend says the respondent number 3 is no legal heirs is there.
R2, not R3.
R2.
R2.
Umesh is
ನಿಮ್ಮ
no
ಆಫೀಸ್
more.
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇರೋದು R2 ಯಾವಾಗ ಸತ್ರು ಅವ್ರ ಡೇಟ್ ಆಫ್ ಡೆತ್ ಹಾಕಿಲ್ಲ ಅಂತ.
ಅದೇ date of death they have not informed because I have ascertained.
Delays ಬರ್ದಿಲ್ಲ.
That is.
I'll file my objections for that. Use the.
What
Objections ಸಹಿಯಾಗಿ ಹಾಕಿರಂತ್ರಿ, but office objections to.
I can comply with the office objections.
In respect of the R2 is.
ಹೋಗ್ಲಿ ಯಾವಾಗ ತೀರ್ಕೊಂಡ್ರು R2 ಅಂತ ಅವ್ರಿಗೆ
I'll give the date because I'll have to seek instructions. I'll give the date. 2020.
Respondent is directed to furnish the date of death of the R2. ಹೌದಾ? And if the same is furnished, the counsel for the appellant is directed
And if
to
there is any legal heirs.
comply with office objections.
If there is any
The
legal
date
heirs
of
is there.
death and the date of delay. ಅವೆರಡಲ್ಲಿ ಇರೋದು.
And if there is any.
In the meanwhile, counsel for the respondent is also directed to file objections if any in bringing LRs of R2.
And in the meanwhile, let them not
That is, yes.
precipitate the orders
It
of
can be
the
date may be
execution.
fixed.
Because they have filed the execution.
ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಆಗ್ತಿರ್ರಿ objections?
ಒಂದು ವಾರದಲ್ಲಿ
ಆಗ್ತದೆ. List this matter 11/7.
ಆಮೇಲೆ till then, let them not precipitate.
ಆಯ್ತ್ರಿ, ನೀವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ನೋಡೋಣ, ವಿಲ್ ಸಿ. 11/7.
ಅವ್ರು ಕೊಟ್ಟ ತಕ್ಷಣ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ.
ಆಯ್ತು, ನೀವು ಇಮಿಡಿಯೇಟ್ ಕೊಡಿ ಅವರಿಗೆ.
ಇವಾಗ್ಲೇ ಕೊಡ್ತೀನಿ ಇವಾಗ.
ಆಯ್ತು.
T5 ಚಂದ್ರಶೇಖರ ಟಿ, ಸ್ಫೂರ್ತಿ ಹೆಗ್ಡೆ.
Lord, this is a suit for partition. It was filed.
Half share grant ಮಾಡಿದ್ದಾರೆ.
Half
That
share
is
grant.
also confirmed by the trial first appellate court. What is the error in the order?
My lord, exhibit D1 to D6, my lord, it has not been considered.
What are those documents?
Those documents, it says that the father of the appellant Aaron had mutated the revenue records in his name. And there was no father, the father of the defendants had repudiated their claim. This mutation of revenue records was in the year 1962-63. And the father of the defendants.
Genealogical tree ಹಾಕಿದಿರಾ? G tree ಹಾಕಿದಿರಾ?
ಹಾಕಿದೆ ಸುಮ್ಮನೆ.
ಎಲ್ಲಿದೆ?
Page 13 of the memorandum might be, I have written as 13.
Page 14, my lord.
Page 14.
14 of the.
ಹೇಳಿ.
Cheluvadappa was the owner of the.
Cheluvadappa.
Yellappa and Satyappa were the only legal heirs.
3 ಜನ ಇದಾರಲ್ರಿ, ಯಲ್ಲಪ್ಪ.
ಅಲ್ಲ, Rangappa is, he was no more. Before marriage, he died.
Unmarried.
Before marriage itself, he died. And Satyappa had only one daughter, who was the plaintiff before the trial court, my lord. And Yellappa had one son, two sons, but Hemachandrappa had died before marriage itself. And Rangaya was the only surviving male issue. But Satyappa during the year 1962-63, he was alive. The father of the plaintiff, he was alive, my lord. He did not make any claim. There was a mutation. Revenue records were mutated in the name of Rangaya. This Rangaya in turn died during the pendency of no much prior to the filing of the suit. And the children of Rangaya, they claimed it.
Mere transfer of properties in the name of a male person, whether it defeats the right of other legal
My lord,
heirs.
it may not defeat the right, my lord. I am
Then
that
is it
proposition
your
is well
case- Is
settled.
it your case that already there was a partition and they have taken the share on tenor? Is it your case?
My lord, that is also not my case.
No, then what is your case?
My case is that when there is the Rangaya has taken over the property. Even prior to that, Yellappa had also already taken over the property by leaving aside Satyappa. And Satyappa,
Yellappa
no,
is the
Satyappa,
Yellappa is the elder son of Chelwadappa. ಹೌದಾ?
yes, my lord.
ಅವನ ಹೆಸರಿಗೆ ಎಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಬಂತು.
ಇಲ್ಲ ಅವ್ರ ಹೆಸರಿಗೂ ಬರ್ಲಿಲ್ಲ ಅದು.
ಯಲ್ಲಪ್ಪನ ಹೆಸರಿಗೆ ಬರ್ಲಿಲ್ಲ. ಆಯ್ತು.
ಬಟ್
ಅಪ್ಪ ತೀರ್ಕೊಂಡ್ಮೇಲೆ ಯಾರ ಹೆಸರಿಗೆ ಹೋಯ್ತು ಮತ್ತೆ?
it was directly transferred to Rangaya.
ಆಯ್ತು. Is there any document of partition or any division?
There was a oral partition, my lord.
ಅದ್ರ ಬಗ್ಗೆ is it your
Oral
pleading?
partition is not
Is it your pleading? Is it your pleading that already there was a partition, oral partition, and they have relinquished their right? You are not disputing the property belongs to the Chelwadappa.
Chelwadappa, I am not disputing.
Chelwadappa having two sons.
Yes,
they are having
that is
legal
also
heirs.
not disputed.
ಮತ್ತೆ then
But he has waived his right, my lord, when the
counsel.
no,
Normally in Hindu
when
joint family, elder member of the family will represent.
it is
Mere transfer of property in your favor, you are not the exclusive owner. That is only your
there was a
ground.
oral partition, but there is no document to show that there was a oral partition, my
Then
lord.
what?
When
What
the
is your-
documents were
what is your
transferred,
defense anta?
my lord, only one.
Counsel,
When the
what is there to
when
be
the
said in
documents
second
were
appeal?
transferred way back in the year 1962-63, Satyappa was alive. When he has been excluded from
That
the
is not
joint
your,
family.
what you are making submission is not your defense. Your defense is that scheduled property was the property of one Rangaya and it was not the joint family property of plaintiff and defendants. That is your defense. Exclusive property of Rangaya. What is the material? To show that Rangaya.
But D1 to
mere
D6,
entries
my lord.
in his name.
D1 to D6, my lord.
ಅವೆಲ್ಲ ರೆವಿನ್ಯೂ ಎಂಟ್ರೀಸ್ ಅದು ಬಿಟ್ರೆ ಬೇರೆ ಏನಿದೆ ಅಷ್ಟೇ ಅಲ್ಲ. That is your defense. That is negative.
Issue number
Not
3.
property not belongs to the Rangaya exclusively.
My lord, when the limitation aspect has been considered by the trial court, no discussion has been made insofar as D1 to D6 is concerned, my lord.
D1 to D6 mere entry in the name of one of the joint family member is not a ground of counsel to comes to a conclusion that
My lord,
property exclusively belongs to him anta.
it was the oral partition that had taken place, my lord.
That is not your pleading. Your claim is that exclusively property belongs to the defendant anta. ರಂಗಯ್ಯನಿಗೆ exclusive property ತೋರ್ಸಕ್ಕೆ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಿ ದಾಖಲೆ?
That is what the D1 to 6, my lord.
ರೆವಿನ್ಯೂ ಎಂಟ್ರೀಸ್ ರೀ ಅದು.
My lord,
ರೆವಿನ್ಯೂ ಹೋಗ್ಲಿ D1
that
to
is
D6
all,
D1 to D6 ಹೇಗ್ ಬಂತ ಹೇಳ್ರಿ ಬೇಗ ಹೇಳಿ.
my lord, that is the property received by the Rangaya through his father. Through his father.
Go to page number 43. ರಂಗಪ್ಪ ಬಿನ್ ಯಲ್ಲಪ್ಪ ಪೌತಿ ಖಾತೆಯನ್ನು 1962-63 ಮಾಡಲಾಗಿದೆ. ಸದರಿ ಪೌತಿ ಖಾತೆ ಆದೇಶ ಪ್ರತಿಯನ್ನು ನಾನು ನೋಡಿಲ್ಲ. It clearly shows that DW1 not seen the order copy of Kata change under Parvati Varsha.
He is an independent witness, my lord. He is a Upatahsildar. He has come before the court and said, there was a wrong entry that was done.
D1 ಚೆಲುವಾದಪ್ಪರವರೆಗೆ ಇರುತ್ತದೆ. ನಂತರ ಅದು ರಂಗಯ್ಯ ಬಿನ್ ಯನ್ನಪ್ಪ ಎನ್ನುವ ವರ್ಗಾವಣೆಯಾಗಿದೆ. ಹೌದಾ?
1962-63 ನಲ್ಲಿ ಆಗಿದೆ ವರ್ಗಾವಣೆ.
Anything to submit, counsel?
My lord, their specific defense is that, my lord, due to the influx of time, the partition cannot be sought by the daughter when the brother itself has not claimed any right. That is, with respect to D1, my lord, we have specifically cross-examined him that This original records are not being produced, only a certified copy has been produced. And it's an IHC which has been entered in the year 1965 and 66 by name Rangappa Chaluappa, IHC and entry madidare. There is no dispute of any that it is not an ancestral property by them in the pleadings they will take the contention, but in the what documents produced, they themselves admit. And in themselves admit that 9 acres 15 guntas belongs to Kenchamma by his father, Rangayya himself, through exhibit P8 also.
ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದಾರೆ ನೋಡಿ. ದಾವಾ ಸೊತ್ತು ಚಲುವಾದಪ್ಪರವರು ಸಂಪಾದಿಸಿದ ಆಸ್ತಿ ಎಂದರೆ ಸರಿ, ಮುಂದುವರೆದು ಚಲುವಾದಪ್ಪ ಮೃತಪಟ್ಟ ನಂತರ ದಾವಾ ಸೊತ್ತಿಗೆ ಯಲ್ಲಪ್ಪ ಮತ್ತು ಸತ್ಯಪ್ಪರವರೇ ಹಕ್ಕು ಮಾಲೀಕತ್ವ ಹೊಂದಿದ್ದರು ಎಂದರೆ ಸರಿ, ಮುಂದುವರೆದು ಚಲುವಾದಪ್ಪ ಮೃತಪಟ್ಟ ನಂತರ ಆತನ ಮಕ್ಕಳು ಯಲ್ಲಪ್ಪ ಮತ್ತು ಸತ್ಯಪ್ಪರವರು ದಾವಾ ಸ್ವಾತಿನ ಖಾತೆ ಅವರ ಹೆಸರಿಗೆ ಮಾಡಿಸಿಕೊಂಡಿರಲಿಲ್ಲ ಎಂದರೆ ಸರಿ, ಅದೇ ಕಾರಣಕ್ಕಾಗಿ ದಾವಾ ಸ್ವತ್ತುಗಳು ಚಲುವಾದಪ್ಪನ ಹೆಸರಿಗೆ ಮುಂದುವರೆದುಕೊಂಡು ಬಂದಿವೆ ಎಂದರೆ ಸರಿ, ಯಲ್ಲಪ್ಪ ಮತ್ತು ಸತ್ಯಪ್ಪರವರು ದಾವಾ ಸ್ವತ್ತುಗಳಲ್ಲಿ ಪಾಲು ವಿಭಾಗ ಮಾಡಿಕೊಳ್ಳದೆ ಮೃತಪಟ್ಟಿರುತ್ತಾರೆ ಎಂದರೆ ಸರಿ. These are the admissions are extracted.
Much. Lord, this is one side, but it was not in the name of Satyappa or Yellappa. It is agreed, my lord. It is admitted.
ಸತ್ಯಪ್ಪನ ಹೆಸರಿಗೆ ಬರ್ದವ್ರೇನು? Property is standing in the name of his father, ಚಲುವಾದಪ್ಪ. You are not disputing the same.
Not disputed, my lord.
ಮತ್ತೆ ನೋಡಿ.
But
This
when
matter is
the
listed for admission.
And moreover, PW1, she does not subject herself for complete cross-examination also, my lord. There was a foul play that was played and a memo was also filed on the same day. When the matter was set down for cross-examination, the counsel also does not make any application that she is not well and she cannot come to the honorable court. On suo motu, on the other hand, suo motu, the court appoints a court commissioner, my lord. And when the counsel also goes to the place of the witness, she does not even respond. She does not even open her eye.
Cross examination ಮಾಡಿಲ್ಲೇನ್ರಿ?
Partly ಆಗಿದೆ, partly
ಕೋರ್ಟ್ ಕಮಿಷನರ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲ?
ಇಲ್ಲ, ಮಾಡೇ ಇಲ್ಲ. ಒಂದೇ ಒಂದು ಪದ ಮಾಡಿಲ್ಲ ಕೋರ್ಟ್ ಕಮಿಷನರ್. Court commissioner, not even a single word he said. I mean, recorded. Not even a single word was recorded by the court commissioner.
About 8 pages cross-examination is there.
ಅಲ್ಲ, ಅದು ಕೋರ್ಟ್ ಮುಂದೆ ಆಗಿರೋದು. ಕೋರ್ಟ್ ಮುಂದೆನೆ ಬರ್ಲಿ ಅಂತ ಹೇಳಿದ್ರೆ ಬರ್ಲಿಲ್ಲ ಕೋರ್ಟ್ ಮುಂದೆ. ಕೋರ್ಟ್ ಕಮಿಷನರ್ ನ ಸುವಮೋಟೋ ಕೋರ್ಟ್ ಅಪಾಯಿಂಟ್ ಮಾಡುತ್ತೆ. ಆಮೇಲೆ ನಾನು ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಲೆಟ್ ದಮ್ ಪ್ರೊಡ್ಯೂಸ್ ದ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಟು ಶೋ ದಟ್ ದ ಡಿಸಬಿಲಿಟಿ ಆಫ್ ದ ಪ್ಲೇಂಟಿಫ್. ದ ಕೋರ್ಟ್ ಸೇಸ್ ಹಿಂಗೆಲ್ಲ ನೀವು ಫೈಲ್ ಮಾಡಿದ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ ಅಂತ. The same words were used. And it was not a complete cross-examination that was done by the defendant.
My lord, I give this. Complete 8 pages cross-examination they have did, my lord. Only about 3 pages, 2.5 pages.
My submission is, it has not
filed
been
our
completed. Court
affidavit
commissioner appoint
against that.
ಒಂದೇ ಒಂದು ಪದ.
8 pages cross-examination was
ಒಂದು
been.
ಪದ ಮಾಡಿಲ್ಲ. He did not cooperate. And no medical records were also produced before the honorable court to show that she has some ailment.
And appeal before the lower appellate court was also delayed by them. And now in this appeal is also filed with a delay.
That is already condoned.
DW2 ಯಾರು?
DW2, my lord. DW2 is a son-in-law, my lord, who is a relative and son-in-law. ಅಕ್ಕನ ಮಗನ್ನೇ ಮದುವೆ ಆಗಿರೋದು, ಕಸಿನ್ ಅಕ್ಕನ ಹಾಕ್ತಾಳೆ ಕೆಂಚಮ್ಮ.
ಈ ಅಪಲೆಂಟ್ ಯಾರು?
ಈ ಅಪಲೆಂಟ್ ಕೆಂಚಮ್ಮ.
ಶ್ರೀಮತಿ ರತ್ನಮ್ಮ.
ರತ್ನಮ್ಮ ಅಂದ್ರೆ
ಅದರ್ ಆಫ್ ದ ಡಿಪೆಂಡೆಂಟ್ಸ್.
ಅದರ್ ಆಫ್ ದ ರಂಗಯ್ಯನ ಹೆಂಡತಿ.
ರಂಗಯ್ಯನ ವೈಫಾ?
ರಂಗಯ್ಯನ.
ರಂಗಯ್ಯ ಅದು ಇರ್ಲಿಲ್ವಾ?
ರಂಗಯ್ಯ ಇರ್ಲಿಲ್ಲ.
ರಂಗಯ್ಯ ಸತ್ತಿದ್ದು 2009 ನಲ್ಲಿ. ರಂಗಯ್ಯ
ರಂಗಯ್ಯ ಪರವಾಗಿ ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದಾರೆ?
ಒಬ್ಬರು ಲಲಿತಾ ಅಂತ DW2 ಮಾಡಿದ್ದಾರೆ. DW2 ಏನೋ ಮಾಡಿ.
DW2 ನೇ ಅದು ಅಡ್ಮಿಷನ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿರೋದು.
Yes, that DW2 itself. DW1 is a deputy tahsildar who was summoned to produce the original books of preliminary record where the manipulation that 65, 66, the entry of Rangaya was inserted. During a lifetime of his father itself.
ಅಂದ್ರೆ ಚೆಲುವಾಡಪ್ಪ ಇದ್ದಾಗ್ಲೇನಾ?
ಚೆಲುವಾಡಪ್ಪ ಇದ್ದ. ಚೆಲುವಾಡಪ್ಪ 92, 93ರಲ್ಲಿ. ಅಲ್ಲ ಚೆಲುವಾಡಪ್ಪ ಅಲ್ಲ, ಯಲ್ಲಪ್ಪ.
ರಂಗಯ್ಯನಪ್ಪ ಯಲ್ಲಪ್ಪ.
92, 93. ಮತ್ತೆ ರಂಗಯ್ಯನೇ ಒಂದು ರೆಪ್ರೆಸೆಂಟೇಶನ್ ಕೊಡ್ತಾರೆ, ಎಕ್ಸಿಬಿಟ್ ಡಿ P8. ಅದರಲ್ಲಿ ಕೆಂಚಮ್ಮ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಸಮೇತ ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ. ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಅವ್ರ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಒಂದು ಗಲಾಟೆ ಆಗುತ್ತೆ ಅವಾಗ. ಯಲ್ಲಪ್ಪ ಸತ್ತೋದ್ಮೇಲೆ ಪಕ್ಕದ ಜಮೀನವನು ಯಲ್ಲಪ್ಪನ್ ಸತ್ತೋದ್ಮೇಲೆ ಯಲ್ಲಪ್ಪನ್ ನೇಮ್ ಅನ್ನು ಅಬ್ಯೂಸ್ ಮಾಡ್ಕೊಂಡು ಅವ್ರದ್ದು ರಿಲೆವೆನ್ಸಿ ಆಫ್ ಸಿಮಿಲರ್ ನೇಮ್ ಇರೋದ್ರಿಂದ ಖಾತೆ ಚೇಂಜ್ ಅಪ್ಲೈ ಮಾಡ್ತಾನೆ. 68/1 ಮತ್ತೆ 68/5.
ಚಲುವಾದಪ್ಪ ತಾತನ ಹೆಸರು ಸೇಮ್ ಇತ್ತು ಅಂತ ಹೇಳಿ, ಅವ್ರ ತಾತ ಇವ್ರ ತಾತ ಹೆಸರು ಒಂದೇ ಇತ್ತು ಅಂತ ಹೇಳಿ ಈ ಅಪ್ಲೈಡ್ ವಿತ್
ನೈಬರರ್ ಅಪ್ಲೈ ಮಾಡಿದಾಗ ದಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಅಬ್ಜೆಕ್ಟೆಡ್.
ದಟ್ ವಾಸ್ ಅಬ್ಜೆಕ್ಟೆಡ್.
ಅದನ್ನ ಮಾಡಿದ್ದು ಇಟ್ ವಾಸ್ ಓನ್ಲಿ ದ
ರಂಗಯ್ಯ
who had
Rangaya himself has given, we are in a joint family in 92, 93.
ಅದೇನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅದು?
P8.
ಎಕ್ಸಿಬಿಟ್ P8.
ರೈಟ್, ಅದರಲ್ಲೇ ಇದೆ.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ.
ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ itself is there.
P8. ಸುಳ್ಳು ಮಾಹಿತಿ ನೀಡಿ ನನ್ನ ತಾತನಾದ ಚೆಲುವಾದಪ್ಪ ಬಿನ್ ರಾಮಪ್ಪನವರ ಜಮೀನನ್ನು ವಂಚನೆ ಮಾಡಿರೋ ಬಗ್ಗೆ ಹಾಗೂ ತಾವುಗಳು ಸತ್ಯ ದಾಖಲಾತಿಗಳನ್ನು ಸಲ್ಲಿಸಿ ಚೆಲುವಾದಪ್ಪ ಬಿನ್ ರಾಮಪ್ಪನ ಖಾತೆಗೆ ಜಮೀನನ್ನು ಹಿಂತಿರುಗಿಸುವಂತೆ ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ಕೋರುವ ಅರ್ಜಿ.
Same 9 acres, 15 kuntas. What she was in
ಅವರ ಏಕೈಕ ಮೊಮ್ಮಗನಾಗಿದ್ದು ಚೆಲುವಾದಪ್ಪ ಬಿನ್ ರಾಮಪ್ಪನವರಿಗೆ ಯಲ್ಲಪ್ಪ ಮತ್ತು ಸತ್ಯಪ್ಪ ಎಂದ ಹೆಸರಿನ ಇಬ್ಬರು ಗಂಡು ಮಕ್ಕಳಿದ್ದರು. ಇದರಲ್ಲಿ ಹಿರಿಯರಾದ ಯಲ್ಲಪ್ಪ ಬಿನ್ ಚೆಲುವಾದಪ್ಪ, ರಂಗಯ್ಯ ಬಿನ್ ಯಲ್ಲಪ್ಪ ನಾನು ಸತ್ಯಪ್ಪನಿಗೆ ನಷ್ಟ ಸಂತತಿನ.
ಚೆಲುವಾದಪ್ಪನಿಗೆಲ್ಲ ರಂಗಯ್ಯ.
ಸತ್ಯಪ್ಪನಿಗೆ ನಷ್ಟ ಸಂತತಿ ಬರೀತಾನೆ. ಕೆಂಚಂಬ ಎಂಬ ಹೆಸರಿನ ಒಂದು ಹೆಣ್ಣು
ಮದುವೆ ಮಾಡ್ಕೊಟ್ಟಿದ್ವಿ.
ಪಿತ್ರಾರ್ಜಿತ ಜಮೀನು ರೀಸರ್ವೆ ನಂಬರ್ 7 ಗುಂಟೆ ಜಮೀನು ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಗ್ರಾಮ ದ್ರಾವಿಡ ಜಾತಿ ಯೋಜನಾ ಮಾಹಿತಿ ನೀಡಿ ನಮ್ಮ ತಾತನಾದ ಚೆಲುವಾದಪ್ಪ ಬಿನ್ ರಾಮಪ್ಪನವರ ಜಮೀನನ್ನು ಯೋಗರಾಜ್ ಬಿನ್ ಚೆಲುವಾದಪ್ಪ ಎಂಬಂತೆ ಖಾತೆ ಮಾಡಿಕೊಂಡಿರುತ್ತಾನೆ. ನಿಮ್ದ ಲೆಟರ್ ಇದೆಯಲ್ರಿ?
ಅಂದ್ರೆ ನಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀವಿ ಅದು ಕಂಪ್ಲೇಂಟ್ ವಿಚ್ ಇಸ್ ಫೈಲ್ಡ್ ಇನ್ 92, 93. when Yellappa died, after Yellappa died, this came into existence. So in that I have not participated because I was already married and I was staying with my husband. But my name is shown by them in
this matter is listed for admission and I heard the counsel for the appellant and also the counsel for the respondent. The factual matters of the case of the plaintiff before the trial court while seeking the relief of partition and separate possession contended that one Cheluvaadappa had two sons, namely Yellappa and Satyappa. The said Yellappa had a son by name Rangayya, who is the husband of the first defendant and father of defendant number 2 to 6. The second son of Cheluvaadappa by name Satyappa had a daughter Kenchamma, who is the plaintiff in the above case. Plaintiff's father Satyappa and grandfather of defendant number 2 to 6 by name Yellappa were brothers. The properties are the ancestral and joint family properties of plaintiff and defendants. Originally suit settled property belongs to original propositors Cheluvaadappa, the grandfather of defendant number 2 to 6 and father of plaintiff. Yellappa and Satyappa were ignorant and illiterate persons. They have no worldly wise knowledge. After the death of their father, they were not made any attempts to change the kata of the suitable property, but they were in joint possession and enjoyment of the suitable properties. After the death of said Yellappa and Satyappa, their legal heirs, that is plaintiff and father of defendant number 2 to 6, had been in joint possession and enjoyment of the suitable property as joint owners thereof.
Not the Satyappa, my lord. Not Satyappa. After the death of only Yellappa, Satyappa was alive as on that date.
After the death of said Yellappa and Satyappa.
Not Satyappa, that is what.
ಅದೇನೇ ಇರೋದು. ನೀವು
Yellappa ಬರ್ದಿರೋದು.
But that is not
legal
the
heirs.
case of the-
ಯಾಕೆ ಸತ್ಯಪ್ಪ ಬದುಕಿದ್ರ? ಇಲ್ಲಲ್ಲ.
According to plaintiff, he was alive.
ಸೂಟ್ ಹಾಕುವಾಗ.
Suit ಹಾಕುವಾಗ. Suit ಹಾಕುವಾಗಲ್ಲ. 82, 83.
ಅದನ್ನೇ pleading plaintiff ಇದು. ಆಯ್ತು.
Sorry.
It is further case of the plaintiff that in the meanwhile, one Yogaraj, son of Cheluvaadappa of Belakare village, taking the advantage of the weakness of aforesaid persons and also taking the advantage of similar names appeared in revenue documents, comma, the said Yogaraj, son of Chelwadappa, moved an application to the revenue authorities to change the kata of the social properties in his name on the basis of inheritance. Accordingly, revenue authorities, without making proper inquiry, mutated the names of said Yogaraj and his mother Lakkamma, wife of Chelwadappa of Pelagara village. Though the kata of the social properties were changed in the name of Yogaraj and his mother, but plaintiff and N. Rangaraya had been in joint possession and enjoyment of the social properties. That in the year 1999, the plaintiff and father of defendant number 2 to 6 have got knowledge about the change of kata of the social properties in the name of Yogaraj and his mother, and having come to know about the same, challenge the same before the Assistant Commissioner in area number 69 of 99/2000. The said appeal was instituted only in the name of N. Rangaya, who is the cousin brother of plaintiff and senior male member of the family, comma, thereby the plaintiff was not actively participated in the appeal proceedings. In the said appeal, the respondents have appeared and submits no objection and consented for allowing the appeal. Accordingly, appeal was allowed, and revenue authorities have changed the kata of the properties in favor of name Rangaya, who is the cousin of the plaintiff. At that time, the plaintiff had also expressed for entering her name with her brother N. Rangaya in the kata of the social properties, but the said N. Rangaya, one or the other reason, prolonged the matter, and moreover, the plaintiff and her brother N. Rangaya were in cordial terms with each other, comma, and also both were in joint possession and enjoyment of the social properties, comma, thereby the plaintiff had not made efforts to change the kata of the suit properties, and the kata of the social properties are continued in the name of Rangaya. Thereafter, the said N. Rangaya and his son Tilak, that is defendant number 6, colluding with each other, taking the advantage of the kata standing in the name of N. Rangaya, and in order to deprive the plaintiff's legitimate share in item number 1 of the social property, created a false genealogical tree and submitted the same before the sub-registrar Chalakere and got up the collusive partition deed in respect of item number 1 of the social property. The said and Rangaya and defendant number 6 have no exclusive right over the item number 1 of the social property by making the division under registered partition deed dated 12/8/2008. The alleged partition deed is a collusive one and got up the same behind the back of the plaintiff, and hence the same is not binding on the plaintiff in respect of item number 1. It is also the case of the plaintiff that based on the said partition deed, revenue authorities, without making any proper inquiry, mechanically change the kata in respect of item number 1 of the social property in the name of Rangaya and Tilak. And when the plaintiff demanded share, not allowed the defendant plaintiff and for joint cultivation, and hence demanded half share in respect of the suit scheduled properties. And when they demand refused to give any share, and hence was without any other alternative filed the suit. In pursuance of the suit summons, defendants appeared and filed the written statement contending that the suit scheduled property exclusively belongs to the Rangaya and plaintiff is not entitled for any share. And also contended that plaintiff is not having any right or interest, share or claim over the suit scheduled properties, and hence pled the court to dismiss the suit. The trial court, having considered the pleadings of the parties, framed the issues in keeping the contentions raised, and also allowed the parties to lead evidence, and parties have led their evidence, and trial court, having considered the material available on record, comes to the conclusion that property admittedly belongs to the Chelwadappa, and Chelwadappa had 2 sons, that is the Yellappa and Satyappa, and plaintiff is the daughter of Satyappa, and the first defendant is the wife of the son of the said Yellappa. And did not accept the contention of the defendant that property belongs to the Rangaya, and exhibit D1 to 6 are the only the revenue entries of records of rights, index of land, and form number 5, form number 6. Records of right. And trial court taking into note of the material placed before the court comes to the conclusion that when the property belongs to the Chelwadappa, the plaintiff is also entitled for half share, and comes to the conclusion that copy of the registered partition deed not binds the plaintiff, and hence granted the relief of half share. Being agreed by the said judgment and decree of the trial court, an appeal is filed, and in area number 12 of 2021, the appellate court also having considered the grounds urged in the appeal memo, formulated the point whether judgment and decree is contrary to law, evidence on record, whether it requires interference, and on appreciation and re-extracting of evidence available on record. Taking into note of material available on record that there was no any division between the Yellappa and Satyappa during their lifetime, and also taking into note of the property document are standing in the name of D. Cheluvadappa, and the same was transferred in the name of Rangayya, son of Yellappa. And also considered the material on record that both Yellappa and Satyappa are the sons of the said Cheluvadappa, and there was no any division between both of them. And also considering the evidence available on record, particularly both oral and documentary evidence, comes to the conclusion that trial court has not committed any error in granting the half share, since the plaintiff is the daughter of the said Yellappa. And the same is extracted in paragraph number 41, considering the admission on the part of the witnesses, and dismiss the appeal. Being agreed by the said judgment and decree of concurrent finding, present appeal is filed. The counsel appearing for the appellant would vehemently contend that both the courts failed to consider the document of exhibit D1 to D6, particularly those documents clearly discloses that the property stands in the name of Rangayya. And those documents clearly demonstrate that father of the plaintiff was left out
Defendants,
the family properties.
father of the defendants,
Huh?
defendants, father of the defendants. There
Andre,
in the trial court,
Plaintiff father ನಿಮ್ ಕಂಟೆನ್ಷನ್ ನೀವು ಹೇಳಿದ್ರೆ ಬರೀತಾರದ್ ನಾನು ನಿಮ್ ಗ್ರೌಂಡ್ಸ್ ಏನಿದೆಯೋ ಅದೇನ ಅರ್ಜ್ ಮಾಡಿರೋದು ಅಪೀಲ್ ಅಲ್ಲಿ. Left out the family properties, and in such a situation left out person ought to have made the claim within a period of 12 years, failing which the right of person is deemed to have barred. The counsel also vehemently contend that when the property stands in the name of the Rangayya, and during the lifetime of Satyappa, when he did not claim any share, the plaintiffs cannot claim any share, and hence court has to frame the substantive question of law whether both the courts have committed an error in granting the relief in favor of the plaintiff when she has waived her right and also both the courts fail to take note of the fact that plaint is barred by law, and the very approach of both the courts is erroneous. For counter, the counsel appearing for the respondent would vehemently contend that the property belongs to the Cheluvadappa is not in dispute, and the fact that the relationship between the parties that Cheluvadappa had two sons by Yellappa and Satyappa is also not in dispute, and plaintiff is also the daughter of Satyappa is also not in dispute, and only contention that the Satyappa, who is the father of the plaintiff, has waived his right during his lifetime, and the said contention cannot be accepted, and no dispute with regard to the fact that property belongs to the Cheluvadappa, and mere entry made in the name of Rangappa cannot prove that he is an exclusive owner of the property, and both the courts taking into note of material available on record and rightly granted the half share in respect of the suit shall properties. Having heard the plaintiff and also the defendant counsel, and also considering the material available on record, no dispute with regard to the relationship between the parties. And also the Chelwadappa is the propositors of the family is also not in dispute. And property is also earlier standing in the name of Chelwadappa is also not in dispute. And subsequently the properties are transferred in favor of the grandson Rangaya is also not in dispute. And also no kata was changed in the name of the sons of Chelwadappa, that is Yellappa and Satyappa is also not in dispute. And having taken note of the said fact into consideration and mere changing of a entry in the male member of a family, that to a grandson, will not defeat the right of a son of the said Chelwadappa, and no documentary evidence is placed before the court that during the lifetime of Satyappa waived his right in respect of the properties. And the trial court also taken note of the said fact into consideration, particularly in paragraph number 21. And in detail discussed the same, including section 6 of the Hindu Succession Act, and also taken note of material available on record, and particularly when the defendant contended that the property belongs to the N. Rangaya, and none of the document produced before the court discloses that that is the exclusive property of said N. Rangaya. When such being the case, having considered both the evidence of plaintiffs as well as the defendant, both the courts comes to a conclusion that when the property belongs to the Chelwadappa and having two sons, and the plaintiff is the daughter of one son Satyappa, and defendant is the wife and defendants are wife and son of one Rangaya, who is the grandson of Chelwadappa, and their branch represents the family of Yellappa, and hence they get half share, and also the daughter of Satyappa get half share, and in apportioning the property also not committed any error. And even appellate court also, while reappreciating the evidence, also in paragraph number 41, taking into note of admission on the part of witnesses that exclusively property belongs to the Chelwadappa and having two sons, and that there was no any partition between the Yellappa and Satyappa, and hence I do not find any error committed by the both the trial court and also the first appellate court in granting the share of half share. The very contention of the appellant counsel that document exhibit D1 to D6 I have not been considered by the both the courts cannot be accepted, and those documents only with regard to the revenue entries standing in the name of Rangaya. That too, a transfer was made in respect of male member of the family, that will not create any exclusive right. And the trial court and first appellate court also considered the issue number 3 when specific pleading was made that the property belongs to the Rangaya, and the same is not the property belongs to the Rangaya, and the property belongs to the Chelwadappa, and hence legal heirs are entitled for equal share, and hence I do not find any error. In view of the discussions made up, I pass the following order. Second appeal is dismissed.
I may be given the opportunity to agitate whatever the grounds that is available for me before the trial court in FDP, my lord.
Okay.
Alla,
What is there to decide?
hangala. The division has been made.
Counsel, there must be some limit. You are enjoying the property throughout without giving any.
I am not asking in that way, my lord.
What is
Let
there
there be a proper division because the commissioner has filed a report.
ನೀವಲ್ಲಿ ರೈಸ್ ಮಾಡ್ಕೊಳ್ಳಿ ನಿಮ್ಮ FDP ನಲ್ಲಿ, ಅದಕ್ಕೆ ಲಿಬರ್ಟಿ ಕೊಡೋ ಅವಶ್ಯಕತೆ ಏನಿಲ್ಲ.
ಕೈಂಡ್ಲಿ my lord, FDP ನಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ
FDP ಹಾಕಿದಾರೆ ಆಲ್ರೆಡಿ.
FDP ಹಾಕಿದ್ದಾರೆ, ರಂಗಯ್ಯನ ಹೆಸರಿಗೆ ಹಾಕಿದ್ದಾರೆ. ರಂಗಯ್ಯನ ಮಕ್ಕಳು 4 ಜನ, ತಿಲಕ್ ಅವ್ರ ಅಕ್ಕಂದಿರಿದ್ದಾರೆ 4 ಜನ. ಅವ್ರು ಅಜಿಟೇಟ್ ಮಾಡಿ ಅವ್ರ ಭಾಗ ಕೇಳ್ತಾ ಇದಾರೆ.
ಕೇಳ್ಕೊಳ್ಳಿ,
ಅವ್ರು ಕೇಳ್ಕೊಂತ ಇದಾರೆ. ಆದ್ರಿಂದ ಅದು ಇವ್ರು ಅಲ್ಲನ್ನು ಸಮೇತ ನಿಲ್ಸಕ್ ಇದಕ್ಕೆ
ಅಲ್ಲಲ್ಲ ಅದ್ರದ್ದಲ್ಲ ನಾನ್ ಕೇಳ್ತಾ ಇರೋದು ಸ್ವಾಮಿ.
FDP ನಲ್ಲಿ ಎಲ್ಲ ಸ್ಕೆಚ್ ಎಲ್ಲ ರೆಡಿ ಆಗಿದೆ.
FDP ನಲ್ಲಿ ಡಿಸೈಡ್ ಮಾಡೋದು ಏನಿಲ್ಲ. ಪ್ರಿಲಿಮಿನರಿ ಡಿಗ್ರಿ ಏನಿದೆಯೋ ಅದು ಕನ್ಫರ್ಮ್ ಆದ್ಮೇಲೆ ಪ್ರಿಲಿಮಿನರಿ ಡಿಗ್ರಿ ಪ್ರಕಾರ ಅರ್ಧ ಭಾಗ ಮಾಡ್ಬೇಕು ಅಷ್ಟೇ, ಇನ್ನೇನ್ ಬೇರೆ ಏನಿಲ್ಲ ಅಷ್ಟೇ. ಹೋಗಿ
96 PB Sidramani
ಅದೇನಾಗುತ್ತೆ ಪ್ರಾಪರ್ಟಿ ಪರ್ಸನ್ಸ್ ಹೂ ಆರ್ ಇನ್ ಸ್ಕ್ವಾಟಿಂಗ್ ಆನ್ ದಿ ಪ್ರಾಪರ್ಟಿ ದೇ ಆರ್ ನಾಟ್ ರೆಡಿ ಟು ಲೀವ್ ದಿ ಪ್ರಾಪರ್ಟಿ ದಟ್ಸ್ ಆಲ್ ಅಷ್ಟೇ. ಸಾಕು. ಯಾವ ವರ್ಷದ ಸೂಟ್ ಇದು?
ಅದ್ರಲ್ಲಿ
ಸೂಟ್ ಯಾವ
ಪ್ರಾಪರ್ಟಿನಲ್ಲಿ ಅಲ್ಲಲ್ಲ ಪ್ರಾಪರ್ಟಿನಲ್ಲಿ
ಯಾವ ವರ್ಷದ್ದು ಒಂದೇ?
ಅಲ್ಲ ಪ್ರಾಪರ್ಟಿ ಇಸ್ ನೋಬಡಿ ಎಂಜಾಯಿಂಗ್ ಮೈ ಲಾರ್ಡ್. ನೋಬಡಿ ಇಸ್ ಎಂಜಾಯಿಂಗ್ ಪ್ರಾಪರ್ಟಿ.
ಮತ್ತೇನು?
ಅಲ್ಲ ನಾನು ಅದನ್ನ ಕೇಳ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಎಂಜಾಯ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಬಟ್ ಶೇರ್ ಕೊಡಕ್ ರೆಡಿ ಇಲ್ಲ ಅಂತ.
ಅಲ್ಲ ಅದನ್ನು ಕೇಳ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ, ಶೇರ್ ಅಲ್ಲ
ಹೇಳ್ತಾ ಇದೀರಿ ನೀವು.
ಅಲ್ಲಿ ಏನ್ ಗ್ರೌಂಡ್ ಇದೆಯೋ ಅದನ್ನ ಅಜಿಟೇಟ್ ಮಾಡೋದಕ್ಕೆ, ಅಂದ್ರೆ ಫೇರ್ ಆಗಿ ಆಗ್ಲಿ ಅಂತ ನಾನು ಕೇಳ್ತಾ ಇರೋದು ಅಷ್ಟೇ.
ಇನ್ನೇನ್ ಗ್ರೌಂಡ್ ಇರುತ್ತೆ ಅಜಿಟೇಟ್ ಮಾಡೋದು? ಏನು ಕ್ಲೈಮ್ ಮಾಡಿಲ್ಲ, ಏನು ಗ್ರೌಂಡೇ ಇಲ್ಲ ಅಲ್ಲ.
Commissioner has made a report, given a report saying that a larger portion has to be given to plaintiff.
ನಿಮ್ಮ ನೋಡಕ್ ಅದ್ರ ಮೇಲೆ ಒಂದು ಅಪೀಲು, ಅದ್ರ ಮೇಲೆ ಒಂದು ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಎಲ್ಲ ಬರುತ್ತೆ.
ಅದಕ್ಕೊಂದು objection
Whole crux of the matter is this, my lord. Rangaya has 4 daughters, my lord. One Tilak. If 2019 partition deed, 2009 deed was being cancelled by this honorable court, it is not binding on the this. It is also not binding on the sisters ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅಲ್ಲೂ ಹೋಲ್ಡ್ ಆಗುತ್ತೆ ಇನ್ನೊಂದು ಅದಕ್ಕೋಸ್ಕರ ಅವರು ಅದನ್ನ
ಇಲ್ಲಿ ಡಿಸೈಡ್ ಮಾಡಿದೀವಿ. ಹೋಗಿ ಈಗ 96 ವಿ ಬಿ ಸಿದ್ದರಾಮಯ್ಯ
Kindly pass out this one. Senior another portal help end up ಆಗಿದೆ. Kindly pass out.
ಪಾಸ್ ಓವರ್. ನೆಕ್ಸ್ಟ್
97 Cyril Prasad Vice.
Appellant, my lord, is the plaintiff before the trial court. Filed a suit for partition. Trial court, my lord, decreed the suit.
1/6 share.
1/6 share, granting 1/6 share, my lord. First
That is
appellate-
reversed in the
reversed by
appellate
the first appellate, against which, my lord, before my lords.
Issue notice and call for records.
But not to change the nature of the property, my lord, they're planning to alienate the property. Change, not to change the nature of the property.
Nothing will happen.
They're planning to sell the property, my lord. They're planning to alienate the property.
ಸೂಟ್ ಅಲ್ಲಿ ಹಾಕ್ದಾಗ ಏನಾದ್ರು ಇಂಜೆಕ್ಷನ್ ಆರ್ಡರ್ ಇತ್ತ ನಿಮಗೆ?
No, suit, there was no injunction order, my lord.
ಇರ್ಲಿಲ್ಲಲ್ಲ?
ಇಲ್ಲ, ಅಲ್ಲಿ suit ಅಲ್ಲಿ initial ಇತ್ತು ಸ್ವಾಮಿ, ನಂತರ ಡಿಕ್ಲೇರ್
ಇಂಜೆಕ್ಷನ್ ಆರ್ಡರ್ ಇತ್ತ ಅಂತ ಕೇಳಿದೆ. ಹೇಳಿದಿರಾ ನಿಮ್ಮ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ?
ಅಲ್ಲ, ಹೇಳಿಲ್ಲ.
You have enjoyed the
I will
order
just-
before the trial court ಅಂತ?
ಇಲ್ಲ, ಇಲ್ಲ.
Is there any averment in your affidavit? Okay. ಎಲ್ಲ ಗ್ರೌಂಡ್ ಸರ್ಚ್ ಮಾಡಿದಿರಿ, ಬೇರೆ ಏನಿದೆ ಅಪೀಲ್ ಅಲ್ಲೂ ಅದೇನೆ. ಅಪೀಲ್ ಗ್ರೌಂಡ್ಸ್ ಏನಿದೆಯೋ ಅದನ್ನೇ ರೀಟ್ರೇಟ್ ಮಾಡಿದಿರಿ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲೂ. ಹೋಗ್ ಬರ್ರಿ, ನೋಟಿಸ್ ಬರ್ಲಿ ಅಂತಂದ್ರೆ.
Let him not change the nature.
Call for records. Next 98.
98.
Appellate discussion. Not the suit for declaration, declaring that the plaintiff not is the
Was dismissed.
Suit was dismissed. But appellate court reversed the finding and granted it a partition in respect of the properties based on the alleged will, lords. Will has not been proved by cogent evidence. Not PW2 and PW3 are the attesting witnesses have stated contradictory, and the deposition of the PW1 is also does not support the actual will. The appellate court not just because not the will is being registered, not accepted the claim of the plaintiff.
Issue notice, call for records.
Not drawing the final decree may kindly be stayed, not otherwise. Not the mean profit is also directed, not without conducting inquiry, not.
ಏನ್ ಸ್ಟೇಟಸ್ ಏನ್ ಹೇಳಿ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಈಗ?
Trial court not dismiss this.
FTP status ಏನ್ರಿ?
Please, not.
FTP status ಏನ್?
FDP is filed, not.
ಫೈಲ್ಡ್ ಸರಿ, ಸ್ಟೇಟಸ್ ಏನು?
Notice ಈಗ ನಾವು objection.
ಆಯ್ತು, ಇನ್ನು ಹೋಗ್ ಬರ್ಲಿ ನೋಟಿಸ್. ಅದೇನು FDP ನಾಳೆನೇ ಇತ್ಯರ್ಥ ಆಗಲ್ಲ.
Records may be.
ಅವ್ರ ಅಪಿಯರ್ ಆಗ್ಲಿ, ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಮಾಡಿದೀನಿ.
Please.
Issue notice and call for records.
Final disposal 99.
99 Mahesh Chaudhary.
In this matter.
In this matter, I appear for R1. Kindly pass over the matter.
ಹೇಳ್ತೀನಿ ಸರ್. ಇದೇನಾಯ್ತು, the learned another coordinate bench had told the registrar to record the evidence. ನಾವು affidavit ಹಾಕಿದೀವಿ petitioner. We wanted to mark some hospital documents. Hospital ಅವರು there's all confidential documents ನಾವು ಕೊಡಲ್ಲ, ನೀವು ಕೋರ್ಟ್ ಇಂದ ಆರ್ಡರ್ ತಗೊಂಡ್ಬನ್ನಿ ಅಂತ. In the cause list last 18ನೇ number ನಲ್ಲಿ my application is there. Then the honorable registrar said, no, it's a judicial order, I cannot pass an order, post before court ಅಂದ್ರು. It has to go on, evidence has to go on there.
He can only record the evidence, that's all.
ಅಷ್ಟೇ.
Registrar can only record the
Now
evidence.
the only question is that application to call for the hospital records I had filed 2 weeks back. ನಾನು affidavit ಹಾಕಾಯ್ತು.
ನಾನು ಅಫಿಡವಿಟ್ ಹಾಕಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಮಾರ್ಕ್ ಮಾಡ್ಬೇಕು, ಅವ್ರು ತಗೊಂಬಂದು ಕೊಟ್ರೆ ನಾನು ಮಾರ್ಕ್ ಮಾಡಿ.
What is your objections, madam? Summoning of
We
document?
have no objections, my lord.
Then I will allow the IR and.
Sure, my lord. Kindly fix the date, my lord.
Heard on IR 1/24 and the same is filed for summoning the witnesses ಅಂತಿದೆ.
ಇಲ್ಲ, ಅವನು ಯಾರ ತಗೊಂಬರೋರು ಅವ್ನು ಹೇಳ್ಬೇಕಲ್ಲ, ಇದೆ ನಮ್ಮ
Summoning the documents from the ಕೊಡಿ application ಕೊಡಿ madam. Summoning the witnesses.
ಅದು ಒಂದು ಆನ್ಕಾಲಜಿ, ಮಿಕ್ಕಿದ ವಿಟ್ನೆಸ್ ಹೆಸರು
Adjudicate the present proceedings.
ಹೌದು.
And may be allowed to examine those witnesses, that is head of oncology and the you are advocate.
ಅದು ಇನ್ನೇನಾಗಿದೆ, attesting witness, they got probate. They are challenging that probate. So those witnesses also we have added here.
And other witness to tender the evidence pertaining to the affidavit of Umesh Kashinath Salian and to produce the notary register book. ಏನು ಇಷ್ಟೊಂದು ವಿಟ್ನೆಸ್ ಇದಾರಲ್ರಿ 6 ಜನ.
ಸ್ವಾಮಿ, ಅದು ಏನಾಯ್ತು, there are 2 wills, one is made by the wife, one is made by the husband, both are under challenge. ಒಂದೇ ಸತಿ ಎಲ್ಲ they are both clubbed together, ಒಂದೇ ಸತಿ ಎಲ್ಲ ಮುಗಿಸ್ಬಿಡ್ತೀವಿ ನಾವು, ಕರೆದ್ರೆ ಎಲ್ಲ ಮುಗ್ದೋಗ್ತದೆ.
ಈಗ ಹಾಕ್ಬಿಡಿ summoning the witnesses as stated in the application. Order 16 Rule 1 read section 151 of CPC. And counsel would submit that in order to prove the contentions of petitioners.
2 petitions.
Examination of these witnesses is necessary. And counsel for the respondent is also not seriously object for summoning of witnesses. And counsel would submit that date may be fixed for summoning of those witnesses and evidence may be recorded without delaying the proceedings. And in view of the submissions of both the respective counsel and in order to prove the issues between the parties, it is appropriate to summon the witnesses and examine them. And hence IA 1/24 is allowed. And register before recording the evidence of witnesses, issue summons to the witnesses and record the evidence. And accordingly, IAS disposed of.
Final hearing matter 100, excess work.
I appear for the plaintiff, appellant Miller. Before commencing the matter, please, madam, before commencing the matter on merits, this is the second appeal filed by the defendant. Suit for recovery of money of 5 lakhs rupees. Admittedly, the plaintiff respondent herein, in the plaint governments itself, he has stated the money was lent to the defendant on 19/3/2013. This is the date, very important. This was also admitted in the cross-examination by the appellant defendant. But whereas the suit was filed on 19/3/2016, but it is short of 1 day limitation. Of course, this ground was not raised before the trial court, not before the appellate court. But still, my lord, under section 3 of the Limitation Act, even if it is not raised, it can be considered by your lordship, my lord, the court. That is what section 3 of the Limitation Act says. Limitation ends on 18/3/2016. It is a calendar year. Year means a calendar year. That is 1st of January to 31st of December.
Suit is based on
based on a promissory note. That is also the same date.
Promissory note.
Yes, madam. And he said that he paid through the check. And his averments in the plaint and also the admission on the part of the defendant is 19/3/2013 is the money which was received. May take your lordships to in the paper book exhibit P1. It's a small promissory note.
Page
41.
Page
41. 41. I'm sorry, my lord, I thought that it may not reach in the afternoon. I'm sorry, I will come in person. Please, my lord, exhibit P1. Exhibit P1. May I read, my lord?
19/3/2013.
Please, my lord. Next may be seen, my lord. ಅದಾಗಿ ನನ್ನ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ ಅದಾಗಿ ನನ್ನ ಸಮಯ ನಿಮಿತ್ತವಾಗಿ ಅಂದರೆ ನಾನು ಗುತ್ತಿಗೆದಾರನಾಗಿದ್ದು ಇದನ್ನು ಅಭಿವೃದ್ಧಿಪಡಿಸುವ ಸಲುವಾಗಿ ಸುತ್ತೋಣ ಬೇಕಾದ್ರಿಂದ ನಿಮ್ಮಿಂದ ಕೆಳಕಂಡ ಸಾಕ್ಷಿದಾರರ ಮೊತ್ತ ಮಳವಳ್ಳಿ ಸೋನ್ಸು ಸೇರಿ ನಂಬರ್ನ ಚೆಕ್ ಮೂಲಕ 5 ಲಕ್ಷ ರೂಪಾಯಿ ಈ ದಿನ ನಿಮ್ಮಿಂದ ಸಾಲವಾಗಿ ಪಡೆದುಕೊಂಡಿರುತ್ತೇನೆ. ಸದರಿ ಮೊಬಲಿಗೆ ಸೋನ್ಸು ಸೋನ್ಸು. ದಿಸ್ ಈಸ್ ಆನ್ ದ 19th of March 2016. I mean 13. There is no dispute about it. May I take your lordship to in the same paper book in the plain governments, page 1. Page 1, man.
Yes.
That the defendant, second para, is the well-known person of the plaintiff. The defendant have borrowed the loan of rupees 5 lakhs on 19/3/2013 at Malavalli for the defendant legal necessities, the improvement so and so, my lord. Kindly see in the same at the right side, my lord, where the court has marked with the seal 19/3/2016. Therefore, the suit itself is barred by limitation. So, if that question
That is the only one ground. That is the only one ground in RSA.
That is also not even raised. I am sorry, my lord, it is transferred brief. That can be your lordship has to frame the substantial question of law only to that extent. If need be, I will answer other points also. Otherwise,
limitation is also a mixed question of fact and law.
No, my lord, this is admitted fact, both in the plain and also
mixed question of fact and law.
Very well, very well, my lord. But in the admitted, both plaintiff and defendant both admits that is the 19/3/2013 date of borrowing the loan.
Yes.
The limitation starts from the same day, 19/3/2013, ends on 18/3/2016, not on 19/3/2016. Therefore, my submission to lordship is the appeal has to be allowed and then suit has to be dismissed. Because the defendant admits.
Yes.
The money has been given by way of check. Check was dated 19/3/2013. The check has been encashed on 20th March 2013.
Where is that?
Suit has been filed on 19/3/2016.
Cast on 23.
It's within 3 years. Secondly, plea of limitation has not been raised as a question in the written statement. In the absence of such a plea, now for the first time in the second appeal, they cannot address it. Even in the first appeal also, they have not taken such a contention. The plea taken by them in the written statement filed by them, it is at para number 5, plea of discharge. Plea of discharge has not been proved. The first appellate court, taking note of the defense, has corrected the judgment which has been passed by the trial court. Para number 5 of the written statement, I will just read it for the sake of. The defendant submit that the defendant, para number 5 of the page number 4 of the written statement, paper book. The defendant submit that this defendant for the purpose of contract work has borrowed a loan of rupees 5,000 from the plaintiff on 19/3/2013. That at the time of advancing the loan, the plaintiff has taken 3 blank checks bearing number so and so, drawn on State Bank of Mysuru, Mandya, containing the signature only, and the rest being the blank. Further, the defendant has also taken the signature of the defendant and the stamp paper. The plaintiff has advanced a sum of rupees 5 lakhs with the condition that the defendant has to pay the interest at the rate of 2%. The defendant has paid the interest regularly and also repaid the entire principal amount to the plaintiff on 5/5/2013 in the presence of so and so, so and so. So plea of discharge has been said it. He has not proved it. The first appellate court, judgment. While answering point number 2, point number 3,
Yes.
point number 3, internal page number 11, ink page number 89, para number 14 has answered it. The points which are raised put at para number 10. So I will come to para number 14. The learned counsel for the appellant during the course of the argument submitted when the defendant in his written statement admitted the loan transaction and pleaded discharge. The trial court ought to have framed an issue burdening the defendant to prove the discharge of the loan as pleaded by the defendant in para number 5 of the written statement. It is the fact that the trial court has not framed the issue, placing burden on the defendant to prove the discharge. The issue number 2 framed by the trial court on the face of it is improper and not necessary to decide the dispute between the parties. Further, the court, being the fact-finding court, is empowered to raise proper points for consideration in order to effectively adjudicate the matter. Hence, the court raised point number 2, which is relevant to decide the dispute between the parties. Before filing the original suit, the plaintiff issued a legal notice to the defendant on 10/12/2015. The said notice has been marked as Exhibit P2. The issue of legal notice as per Exhibit P2 is not in dispute in response to the defendant and issued reply on 17/12/2015 when the same is marked as P4. The first document available on record appreciate the plea of discharge. Plea of discharge is Exhibit P4. I have carefully gone through Exhibit P4. Nowhere in Exhibit P4, the defendant has claimed that he has repaid the entire loan amount of rupees 5 lakh along with the interest. On the other hand, the defendant had claimed that he had given 3 blank checks bearing number so and so and so, and 1 promissory note. However, in reply notice, it is not specifically mentioned so as to what amount he had given the check and proper pronote to the defendant. However, in the written statement filed before the court, the defendant admitted that he had borrowed a sum of rupees 5 lakh on 19/3/2013, and he has not even disputed the passing of the consideration. Further, for the first time, the defendant pleaded that he discharged the said loan on 5/5/2013 in presence of one Raju and Ramesh, so and so. In order to prove the plea of discharge, the defendant examined DW2 by name Ramesh. In affidavit filed in chief examination, it is contended the defendant repaid 5 lakhs to the plaintiff in his presence on 5/5/2013. Further, it is contended that the plaintiff did not return the check and pronote, saying that forgot in the house and agreed to return the same. It is an admitted fact that the defendant is a contractor. He is claiming that he had repaid the entire amount on 5/5/2000 without getting any document from the plaintiff. Even for argument's sake, if we believe that the plaintiff did not return the pronote and checks on 5/5/2013, nothing prevented him from getting at least an acknowledgement.
That is with
from,
regard to the proving of discharge is concerned.
Yes,
Is there
plea
any
of discharge.
submission with regard to the limitation point
Yes.
which you had raised? With regard to the limitation point.
20th is the date of encashment. No plea of limitation has been raised in the Article 31. It is only the date on which the check has been encashed, 20th. There is no issue which has been raised with regard to the limitation.
Yes.
In the absence of it, he cannot argue before this honorable court. For the first time, there is a limitation.
Yes, that's all.
Therefore, the appeal has to go.
Yes, counsel, any reply?
Correct. Only one short answer for my learned friend's arguments. May I take your lordship to the cross-examination of the PW1, page 11, my lord. Only I will only a few sentences.
Whether amount was encashed on 20th or
That is
19th only?
yes, my lord. That's what exactly the point. May I read, my lord? My lord?
Yes.
My lord, kindly see,
Class
my
of
lord.
PW1.
Class of PW1 at page 11. I will not read the entirety. Page 11.
Yes, 11.
About 10 lines, my lord. Nanu 6 laksha hanavannu koಟ್ಟಿದ್ದೇನೆ. Your lordship got me. ಪ್ರತಿವಾದಿ 6 ಲಕ್ಷ ಹಣ ಪಡೆದಾಗ ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಮೈಸೂರು ಮಂಡ್ಯ ಶಾಖೆ ಚೆಕ್ ಅನ್ನು ನೀಡಿದ್ದರು. ಚೆಕ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ. ನಾನು ನೀಡಿದ ಚೆಕ್ಕು ಮಳವಳ್ಳಿ ಶಾಖೆ ಹ್ಯಾಡ್ಲಿ ಬ್ರಾಂಚ್ ನದು. ಚೆಕ್ ಮೂಲಕ ಹಣವನ್ನು ಪ್ರತಿವಾದಿಗೆ ಸಂದಾಯ ಮಾಡಿರೋ ಬಗ್ಗೆ ನನ್ನ ಬುಕ್ ನಲ್ಲಿ ನಮೂದಾಗಿದೆ. ಸದರಿ ಪಾಸ್ ಬುಕ್ ಅನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಿಲ್ಲ. No material is produced before the court that the amount was passed on 20th of March 2013. On the other hand, admitted in the plaint and admitted were even not even a averment in the plaint. that it was passed on 20th of March 2013. Now, Melanophant cannot raise anything without a pleading and no documents produced before the court to show that it was passed on 20th of March. In fact, it was raised in a cross-examination. Now, Melanophant cannot take up that plea. And so far as first time raising is concerned, I would like to draw your lordship's attention again, section 3 of the Limitation Act. I will just read for your lordship's sake, my lord. Limitation of suits, appeals and applications. 3. Bar of limitation. Subject to the provisions contained in section 4 to 24, every suit instituted, appeal preferred and application made after the prescribed period shall be dismissed, although limitation has not been set up as a defense. But this is what the court's for Melanophant cannot contend that I have not raised anywhere in the original suit or in the first appellate authority. Therefore, the appeal has to be allowed, suit has to be dismissed.
What was the mode of discharge according to you?
Mode of discharge,
Only
of course,
by cash?
By cash and the
Only by cash?
Only by cash. That is what they say,
Cash.
that without going to that, the question is whether the suit is well within the time of 3 years. My submission to your lordship is, it is
That's
beyond
why I
limited.
said limitation is also mixed question of fact.
It's a question of fact. But the admitted facts are before your lordship's, my lord.
Yes. Heard. Reserved.
Please, madam. Grateful, my lord.
In fact, we have produced the bank statement before the first appellate court in order to establish that the check was.
Amount was paid on 20th.
Yes,
Hakidira?
yes, ಹಾಕಿದ್ದೀವಿ. However, the first appellate court felt it rejected that application. That document is available on record.
But appeal was
27 ಅಲ್ಲಿ ಹಾಕಿದ್ರಾ?
Yes, madam.
But that appeal he has not filed to that extent.
Yes, yes.
To that finding, they have not filed an appeal.
Discharge prove ಮಾಡಿ.
Discharge prove ಮಾಡಿ.
Trial court ಹೇಳಿದ್ದಕ್ಕೆ ನಾವು ಅದನ್ನ ಹಾಕಿದ್ವಿ.
Trial court has taken a wrong approach that I have not proved the payment. In that connection, in order to prove that I have paid the money, I have produced that document before the first appellate court.
Yes.
There is no pleading.
101.
RBS.
Pass over your lordships.
Pass over.
102.
For R3, my lord.
For appellants, my lord.
Yes.
My name is not correctly shown in the cause list. So last time you were on.
Surya Narayana Rao.
My name is Surya Prakash Rao.
Surya Prakash Rao.
20ನೇ ತಾರೀಕು ತಾವು ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀರಿ. ಐ ಮಸ್ಟ್
ಮತ್ತು ತೋರಿಸಿಲ್ವಾ? ಮತ್ತು ಸರಿಯಾಗಿ ತೋರಿಸಿಲ್ವಾ?
ಇಲ್ಲ ತೋರಿಸಿಲ್ಲ, ಅವತ್ತು ಸರಿಯಾಗಿ.
ಯಾಕೆ ಮೇಡಮ್?
ನಾನು ಏನು ರೆಗ್ಯುಲರ್ ಚೆಕ್ ಮಾಡುವಾಗ ಐ ಕೇಮ್ ಟು ನೋ ದಿಸ್.
Anyhow, you are here before the court. Yes, counsel.
Senior is not able to be before this court, my lords. One short accommodation, my lords.
No accommodation.
My lords.
Ask him to come at 2:30.
My lord, one submission is there. Some compromise talks were held about 1 year back.
Personal inconvenience, my lords.
Yen personal inconvenience.
Death anniversary of father.
Huh?
Death anniversary of the father, my lords. Deceased father. Kindly fix a date, my lords. We'll finish the arguments.
ಯಾವಾಗಿದೆ ರೀ? No such correction order passed.
ಇದೆ ಸರ್ 20ನೇ ತಾರೀಕು. 26.
ಯಾವ 20? 20ನೇ ತಾರೀಕಲ್ಲಿ ಇಲ್ಲ. Learned counsel for the appellant seeks time ಅಂತ ಇದೆ. Learned counsel for the respondent number 3 is absent.
ಅದರಲ್ಲಿ
R3 is absent ಇದೆ ರೀ.
ಅದೇ ಸರ್ ನನ್ನ ಹೆಸರು ಕರೆಕ್ಟ್ ಆಗಿ ಬಂದಿಲ್ಲ, ಅದರಿಂದ ನಾನು ಅಬ್ಸೆಂಟ್ ಆಗಿದ್ದೀನಿ
ಅಂತ ಹೇಳಿ ಕರೆಕ್ಷನ್ಸ್ ಗೆ ಆರ್ಡರ್ ಇಲ್ಲ.
ಅಲ್ಲ ಅದನ್ನ ಕರೆಕ್ಷನ್ ಮಾಡ್ಬೇಕು ಅಂತ.
ಆಯ್ತು ಮಾಡೋಣ. ತೊಗೊಳ್ಳಿ. Appellant counsel seeks time and counsel for the respondent submits that his name is wrongly mentioned as K. Surya Narayana Rao and his correct name is K. Surya Prakash Rao. Surya Prakash Rao. And hence registry is directed to correct the name in the cause list. List this matter on. ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. 2 weeks ಡೇಟ್ ಕೊಡಿ. 22/7. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಡೇಟ್ ಕೇಳಾಗಿಲ್ಲ.
Much obliged.
103. Santosh
Nagarale Subramanya.
For respondent, raised for short accommodation. Advocate on record has raised for short accommodation. Kindly have it on Monday.
What happened to the advocate?
Advocate on record has personal inconvenience and he is unable to come to court due to some personal inconvenience.
What is that personal inconvenience? Any health reason? Any health reason?
Health reason. Health reason.
ಕೇಳಿದ್ಮೇಲೆ ಹೇಳ್ತಾ ಇದೀರಲ್ರಿ ಏನ್ ಪರ್ಸನಲ್ ರೀಸನ್ ಅಂತ ಕೇಳಿದೆ.
I have also instructed health reason.
You are from same office or different office? Then ಏನು ರೆಡಿ ಇದೀರಾ ನೀವು?
Please, my lords. Please, my lords.
Then we'll hear. Inconvenience is not the ground, counsel.
Kindly have it on Monday.
Why?
Monday.
When your counsel is free, then court has to take up your matter. You are not mentioning the reason for inconvenience also. 2018 appeal. So, the respondent counsel seeks time on the ground of inconvenience, but counsel is not ready to disclose the inconvenience. Cast ಮೇಲೆ urgent ಮಾಡೋಣ. And appellant counsel says ready, and this is the matter of the year 2018. ಇನ್ನೇನ್ ರೀಸನ್ ಇದ್ರೆ ವಿತೌಟ್ ಕಾಸ್ಟ್ ಕೊಡ್ತೀನಿ ನಾನು. ನೀವೇನು ಹೇಳಕ್ ರೆಡಿ ಇಲ್ಲ.
Health reason ಅಂತೇಳಿ ಊರಿಗೆ ಹೋಗ್ತೀನಿ ಅಂತ ಹೇಳಿ.
ಊರಿಗೆ ಹೋಗ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು, ಅದನ್ನ ಹೇಳಿ.
ಅಲ್ಲ ಅಂದ್ರೆ ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್ ಹೋಗ್ತೀನಿ.
ಆಯ್ತು, ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 22/7.
Much obliged.
104 PF Kumbar.
ಕುಂಬಾರ್ ವಸಂತ್ ಫಕೀರಪ್ಪ.
Yeah, for the appellant in this case, my lord. My lord, senior is held up in other court. I'll have it on next week, my lord.
ನೆಕ್ಸ್ಟ್ ವೀಕ್
One
ಅಲ್ಲೇ
week.
ಇರ್ತಾರ ಪೂರ್ತಿ ಇವತ್ತೆಲ್ಲ
ಇಲ್ಲ
detail ಅಲ್ಲೇ
ಇಲ್ಲ
ಇರ್ತಾರಾ?
ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಇದೆ. 1 week time maybe.
ಆಯ್ತು, ನೋ ಡೇಟ್ ಬರಕ್ ಹೇಳಿ ಮಧ್ಯಾಹ್ನ. ಪಾಸ್ ಓವರ್.
105
106.
106
ಶೇಷಗಿರಿ ರಾವ್, ಮಂಜೇಶ್ HM, ME Charati.
Divergent findings. First appellate court not had dismissed the suit of
ಇಲ್ಲ ಯಾಕೋ R3 ಗೆ ಸರ್ವಿಸ್ ಆದಾಗಿಲ್ವಲ್ರಿ? ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು R3 ಅಂತಿದೆ ನೋಡಿ. Charati for caveat or R1 and R2, R4 served.
I will,
R3.
R3 may come along with the appellant. I will just, R3 may come along with the appellant. That's a very short question was involved.
Putting the appellant plaintiff for amendment of plaint. Non-filing of paper book ಹಾಕಿಲ್ವಾ ನೀವು?
I mean, very short point was involved.
That point ಆಗ್ಲಿ ರೀ, ಆರ್ಡರ್ ಇದೆಯಲ್ಲ ಅಡ್ಮಿಟ್ ಆಗುವಾಗ ಪೇಪರ್ ಬುಕ್ ಹಾಕ್ಬೇಕು ಅಂತ.
Maybe ಒಂದ್ 3 ವಾರ ಕೊಟ್ರೆ
ಪೇಪರ್ ಬುಕ್ ಹಾಕ್ಲಿಕ್ಕೆ ಆರ್ಡರ್ ಇಲ್ವಾ?
Very short point was there. ಏನಾಗಿತ್ತು, the survey number was
Justified in reversing the judgment and decree passed by trial court on the ground that the description of the property given in the plaint was not sufficient enough to identify the property, though the same meets the requirement of Order 7, Rule 3 of CPC.
Once there is a survey number and now
R3 whether he is necessary or not.
They would be.
Service ಆಗಿಲ್ಲ.
They would be necessary. They would be necessary.
Necessary na.
Because ultimately she is also a co-owner, and the property will have to go to all four.
Process kodi. It is noticed that
I'll ensure she'll file the wakalat in the next 15 days.
It is noticed that notice has not been served on the respond number 3.
If the lordships could fix a date,
I will issue the notice first. You pay the PF. You pay PF.
All right, but by then the wakalat can be filed. I will instruct because they sail together in the sense
sailing together.
There was a counter claim.
Appellant counsel would submit that the R3 is also sailing together with the plaintiff appellant, and he will see that R3 is also represented, and hence list this matter on 22/7. Nodi astroli wakalat haksira haksi.
I'll do it.
Paper book beda agara eno short.
Very short question. It's very short question. Once there is a survey number, once nowadays, once there is a survey number and there is a survey state.
The court also not directed to file paper book, and hence filing of paper book is dispensed.
Right.
In view of the short question involved in the matter.
The previous matter, what I have addressed, there is no plea of limitation even.
Already ಹೇಳಿದ್ರಲ್ಲ. ಎರಡು ಕೋರ್ಟಲ್ಲೂ ಇಲ್ಲ ಅಂತ ಹೇಳಿದಿರಲ್ಲ ನೀವೇ. ಅವರು ಕೂಡ ಅವ್ರೇನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಅದನ್ನ. But only his contention is that it can be urged in second appeal with his only contention. Even without
first appeal.
His contention is even if there is no any specific plea in the trial court, appellate court also, in second appeal also, as a question of law, it can be urged anta. That is his ಕಂಟೆನ್ಷನ್ ಅದಕ್ಕೇನಾರು ಹೇಳಂಗಿದ್ರೆ ಹೇಳಿ. Point of law.
There cannot be a plea of limitation when discharge is fixed. And 31 says, when you're suing on a promissory note, that's the limitation will arise when the due date is fixed under the promissory note and that ends. That is the starting point, not for the limitation. And from there it is 3 years. From there it is not from the date of execution. I am sorry,
From the date of document anta ನೀವು ಹೇಳೋದು.
it is date.
Not from the date of promissory note ಅಂತ.
It is not from the date of promissory. Article 31. Article 31 says,
ನೋಡ್ರಿ ಮೇಡಮ್ ಲಿಮಿಟೇಷನ್ ಆಕ್ಟ್.
from the date it falls due. That is what Article 31 says.
Date is fixed for payment from that date starts ಅಂತನಾ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್?
It would start from there. It would start from there. And
31.
on a bill of exchange of
Article 31.
Please, that's 3 years and time begins not when the
On a bill of exchange or promissory note payable at a fixed time.
Yes, and when it falls.
After date.
And once
3
there
years
is, yes,
when the bill or note falls due ಅಂತಿದೆ.
falls
When the bill or note falls due
falls
ಅಂತಿದೆ.
due. There should be a time fixed there in minutes. ಇಂತಿಂತ ದಿವಸ ಆದ್ಮೇಲೆ ನಾನು ತಗೋತೀನಿ ಅಂತ. When it falls due, minutes ಅಲ್ಲಿಂದ 3 ವರ್ಷ ಆಗುತ್ತೆ. And minutes once there is a
But
plea of discharge.
whether any promise in this promissory note that going to pay the amount so and so date?
You know, ಇಸ್ಕೊಂಡು ಇಷ್ಟು ದಿವಸದಲ್ಲಿ ಕೊಡ್ತೀವಿ ಅಂತ ಒಂದೇ ಒಂದು. This is not, sorry.
Limitation is 3 years from the date of promissory note.
Please, ಕಾಲಕ್ಕೂ ಕಟ್ಕೊಂಡ್ ಬರ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ರು.
ಅಷ್ಟೇ. ಕಾಲ ಕಟ್ಕೊ ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿದಾರೆ.
ಕಾಲ ಕೊಟ್ಕೊಂಡ್ ಬರ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. Now they have raised a plea of discharge. The point was,
ಹೇಳಿದ್ದು ಕಾಲಕ್ಕೆ ಅಂತಂದ್ರೆ ಯಾವ್ದು ಡೇಟ್ ಇಲ್ಲ ಡ್ಯೂ.
let's say the date which is execution date is 19/3. Suit filing date is 19/3. So there is no limitation. What it was urged by not so 18/3 was the date of the stamp paper. 19/3 is the date of execution. My lordship will find out the typing.
18/3 ಗೆ suit
Execution is on 19/3.
Execution is on 19/3. 19/3, my lords.
His argument is ought to have filed the suit on or before 18/3/2013 anta his argument.
That may not come because, my lords, one thing is, once we raise a plea of discharge, there is no concept of limitation.
That is your argument.
Yes, once there is a discharge raised, my lords, there is no concept of limitation. If they deny the transaction, my lords, yes. Once they plead, there is a discharge, my lords, there is a reverse onus.
Any precedents?
I will check and place it.
Examine it.
I will check and place it by the end of the day. Minutes, I will also submit a copy.
Two aspects you give a citation, precedents.
Minutes.
Our students are also are there, note down. We'll also make research. And you also make your effort.
I will also.
Article 31.
Article 30.
According to you.
Article 30.
When the date is fixed, that is not the law.
What if the date is not fixed?
As far as my knowledge. Promissory note, exact 3 years. That is the law is settled. That is one thing. But you are arguing other way. You also place any precedent. That is one thing.
I'll do the needful.
And second one is you are contending that they have pleaded that discharge. They made the payment on so and so date.
Once
discharge. That is in 2015, some date.
They have, yes.
Made the payment.
Within 2 months.
Within 2 months they have pleaded discharge.
Whether save you from the limitation. That also you.
Whether when there is a plea of discharge, can the question of limitation be raised in a money request?
Yes.
That is all.
Yes.
My lordship, I'll have to tender some citations. I will try and do that.
You can furnish.
I'll do.
But furnish it within 2-3 days.
I'll do that.
File will not be there more than 8 days in my chamber for dictation.
I'll furnish it.
Not 7.
My lords, I appear for the appellant, my lords. My lords, I pray for 2 days accommodation, my lords. As a senior has a part heard matter at 2:30, my lords. There's some inconvenience in that.
2:30.
At 2:30, there's a part
it will be.
My lords, it's a labor matter, my lords. Kalburgi.
Maybe how long it will be?
My lords, just 2 days, my lords.
Ask him to come after after finishing of part heard matter.
My lords, just 2 days, my lords, or at least tomorrow.
No,
If
2
the same
days.
may be taken tomorrow.
Other side Aridara KV Narasimhan.
My lord,
LS Manjunath.
we are ready. We are ready with the matter. We are ready.
Other side all are ready. Virupakshaya for R3. You are also ready. Then note.
Or if the same may be taken tomorrow, my lord.
Counsel, let him complete and come here.
Certainly.
Part heard, no court will hear for about whole day. Let him finish it and come here.
108.
108.
K. Shivashankar.
I'm ready.
For the respondent number one.
Yes, counsel.
I'm ready.
Ready?
Yes,
Sir, ready?
No, my lord. Senior is held up in another matter.
Held up in? Held up
In
in?
another matter.
Let him come after finishing that work.
After 2:30.
2:30 only?
Yeah.
109.
P. Ramesh and HV, Harish HV.
Could it be taken up on Monday, my lord? It could be taken up on Monday, my lord.
I'm ready.
You are ready? And then why you are
No,
taking
I'm not
time?
ready, my lords, for this reason. My lords, day before yesterday, my brother-in-law passed away. My lords, I could not get prepared, my lords. Monday,
Appellant counsel seeks time and on the ground that his brother-in-law passed away 2 days back and hence he could not ready. And counsel for the respondent is also present. List this matter on 22/7.
Much of.
Remaining matters at 2:30.
Permission, lordship. Serial number 91. Serial number 91, lordship.
Yeah, 91.
Actually, it was dismissed for non-prosecution. I was first round and 54 matter I was attended.
Preemptive order ittu adke dismiss.
Sorry, lordship. Actually, 54 matter has been completed and then I go to the get Xerox, lordship. Kindly recall the.
Counsel last time mene ನೀವು ಇರ್ಲಿಲ್ಲ ಅಂತ
Yes, yes, lordship. Yes, sir. Today I particularly.
Matter is listed for dismissal.
Kindly recall that.
Are not there.
Just I complete the matter of serial number 54. Then I went to the Xerox.
54 ಇದ್ದಿದ್ದು ನಾವು 91 ಬಂದಿದ್ದು.
Just I'll get the Xerox. Kindly
ಬಂದು recall ಮಾಡಕ್ ಮುಂಚೆ ಬಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. If you are ready to argue, then I will recall them.
79 minutes. Pass over.
over.
Monday or Tuesday minutes.
No dates.
87.
Court officer serial number 104.
Court officer, sir.
Serial
number 86.
Okay, sir. ಬರ್ತಾರೆ ಸರ್ ಇವತ್ತು ಮೋಸ್ಟ್ಲಿ ಬರ್ತಾರೆ.
Madam, serial number 86 ಏನಾಯ್ತು madam?
Court officer 104 ಏನಾಗಿದೆ ಮಿಲ್ಲ? 72 matter. Court officer 72.
27.
4 pass over.
81 ಅಲ್ಲಿ.
6 pass over.
81.
81 ನಿಮ್ಗೇನೋ
104.
date ಕೊಟ್ರು ಅನ್ಸುತ್ತೆ.
Court officer
ಹೇಳಿ.
72 matter.
22.
72 pass over.
104 ಕೇಳಿಸ್ಲಿಲ್ಲ ನಂಗೆ. 104.
Pass over.
Thank you.
27.
22 weeks ಕೊಟ್ಟಿದ್ದಾರೆ ಅದು. Taking steps. ಅವ್ರು ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂತ ಸೋಲ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೋಚಿತಿನ ಆರ್ಡರ್ ಇದೆ. 27. ಅಯ್ಯ ಹಾಕ್ಬೇಕು. 27 ಏನೆ. 89 of 2020. RSL. ಅದರಲ್ಲಿ ಆ ಸೋಲ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸತ್ತೋಗಿದ್ದಾರೆ. ಅಯ್ಯ ಹಾಕ್ಬೇಕು 2 weeks. ಆಮೇಲೆ ಅದು ಕೊಡಿ ಕಳಿಸ್ಬಿಟ್ರೆ ಫುಲ್. ಅದೇ ರೀಕಾಲ್ ಆಯ್ತಲ್ಲ 91.
ಮತ್ತೆ ಕರೆದ್ರ 79 ಬಂದಿಲ್ಲಲ್ಲ?
ಮೇಡಮ್ ತಿರ್ಗಾ ರೀಚ್ ಆಗ್ಬೋದಾ ಅದು? 84 ಅಲ್ಲ ಹೌದಾ?
ಆಮೇಲೆ 91 ಹೋಗ್ತೀರಾ ಆಮೇಲೆ ಏನ್ ಹೇಳಿ? ಹೋಗಿಲ್ಲ ಅಂತ ಇದ್ದಾರಾ? ಹೇಳಿದ್ನಲ್ಲ ಅಷ್ಟು ಫೈಲ್ಸ್ ತಂದ್ರ ಇಲ್ಲ.
ಅಪಿಯರ್ ಆದ್ರಲ್ಲ ಕೊಲಿಗ್ ಅಪಿಯರ್ ಆದ್ರಲ್ಲ.
ಅಪಿಯರ್ ಆದ್ರು ಯಾರು ಹೇಳಿದ್ರು? ಹೋಗಿದೆ ಕೊಡಿ ಅವ್ರು. ಜಾಸ್ತಿ ಕಮಿಷನ್ ಮಾಡಿ ಪೆಂಡಿಂಗ್ ಹೋಗಿದ್ಯಾ? ಒಂದ್ ಫೈಲ್ ಮಾಡ್ತೀನಿ. ಅದ್ ಹೇಳ್ಬೇಕಾ? ಹೇಳಿದ್ರ? individual ranking to be stated correctly in custody. Serial numbers given to the dead person. ಹೇಳಿ ಸರ್.
ಏನಾಯ್ತು ನಂದು ಕರೆದ್ರ
ಇಲ್ಲ ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ವಿ ಹೇಳಿದ್ರಲ್ಲ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀವಿ.
ಅಂದ್ರೆ ಆಗ ನಂಗೆ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಇದೆ, ಅರ್ಧ ಮಾಡಿ ಬಂದಿದ್ದೇನೆ ಆದ್ರೆ ಈಗ 2:30 ಇಲ್ಲಿ ಏನಾಗಿದೆ ಪೊಸಿಷನ್ ಅಂದ್ರೆ 108 ಕಾಣ್ತಾ ಇದೆ ನಾನು ಇದ್ರಲ್ಲಿ ನೋಡ ಭಯಂಕರ ಯಾರು ರೆಡಿ ಇರೋ ಅದು ಮುಗೀತಾ
ರಿಸರ್ವ್ ಆಗೋಯ್ತು.
ನೋಡ ಐ ವಿಲ್ ಟ್ರೈ ಟು ಕಮ್ ಆಫ್ಟರ್ ಅಲ್ಲಿ ಅರ್ಧ ಆಗಿದೆ ಅದು ಆದ ತಕ್ಷಣ ಬರ್ತೇನೆ ಒಂದಾದ್ರೂ ಮಾಡ್ತೇನೆ ಅಟ್ಲೀಸ್ಟ್ ಅದ್ರಲ್ಲಿ ಅಟ್ಲೀಸ್ಟ್
ಮಾಡಿ. ವೆಂಕಟ್ ಸರ್ ಇವಾಗ ವೆಂಕಟ್ ರೆಡ್ಡಿ ಅವ್ರು ಸತ್ತೋಗಿದ್ದಾರೆ. ನೀವು ಅವ್ರನ್ನೇ 2 ಅಂತ ಮಾಡ್ಬಿಟ್ರೆ ಅವ್ರು ಸತ್ತೋಗಿರೋರ್ಗೆನೆ ರ್ಯಾಂಕಿಂಗ್ ಕೊಟ್ಟು ಇವ್ರಿಗೂ ರ್ಯಾಂಕಿಂಗ್ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ ಸರ್. ಇವಾಗ ಸತ್ತೋಗಿದಾರಲ್ಲ ವೆಂಕಟ್ ರೆಡ್ಡಿ ಸಿನ್ಸ್ ಡಿಸೀಸ್ ಬೈ ಎಲ್ಲ 2A ಅಂತ ಹಾಕ್ಬೇಕಾಗಿತ್ತು. ಸೊ ನೀವು ಆಸ್ ಇಟ್ ಈಸ್ ತಗೊಂಬಂದಿದ್ರು 2A ಅಂತ ಹಾಕ್ಬೇಕಾಗಿತ್ತು. ಯಾಕೆ 3 ಅಂತ ಹಾಕಿದ್ರಿ? ಆಮೇಲೆ ಇನ್ನ ಒಂದೇನು ಸ್ಪೆಸಿಫಿಕ್ ಅದಕ್ಕೆ ಇಲ್ಲಿ ಇದಾಗತ್ತೆ, ಇದು ಹೋಗುತ್ತೆ ಅವಾಗ. ಇಲ್ಲಿ ಸೆಕೆಂಡ್ ಅಪಲೆಂಟ್ ಅಂತ ಇಲ್ಲಿ ತೋರಿಸ್ತೀರಾ ಆರ್ಯ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಲ್ಲ, ಹೈಕೋರ್ಟ್ ಅಲ್ಲ. ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಅಪಲೆಂಟ್ ಅಂತ ಆಗಲ್ಲ. ಇವರು 3ಗೆ ಸೆಕೆಂಡ್ ಅಪಲೆಂಟ್ ಅಂತ ಹೆಂಗ್ ಸರ್ ಬರೀತೀರಾ? ಈ 2 ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದೀರಾ, 3 ಅಂತ ಮತ್ತೆ ರ್ಯಾಂಕಿಂಗ್ ಕೊಟ್ಟಿದ್ದೀರಾ, ಇಲ್ಲಿ ಸೆಕೆಂಡ್ ಅಪಲೆಂಟ್ ಅಂತ ಹೇಳ್ತೀರಾ. ಇನ್ನು ಹೈಕೋರ್ಟ್ he has become second appellant ಆದ್ರೆ ಈ 3 ಚೇಂಜ್ ಆಗ್ಬೇಕು. ಅದು ಆ ತರದ್ ನೋಡ್ಕೊಳ್ಳಿ ಸರ್. ಇನ್ನ ಒಂದೇನೋ ಇರ್ಬೇಕು ಇದೇ ತರದ್ದು. ಆಮೇಲೆ ಇದಕ್ಕೂ ಹಂಗೆ ಮಾಡ್ತೀರಾ. 10 ಮುನಿಯಮ್ಮ ಸತ್ತೋಗಿದ್ದಾರೆ, ಅವ್ರಿಗೆ 10 ಅಂತ ಕೊಟ್ಬಿಟ್ಟು ಕಂಟಿನ್ಯೂಷನ್ಗೆ 11, 12 ಕೊಡ್ತೀರಾ. ಎಲ್ಲ ಮಿಸ್ಟೇಕ್ ಅವಾಗ. ಅವಾಗ ಅವ್ರು ಯಾರ್ಯಾರು ಅಂತನಾದ್ರೂ ನೋಡ್ಬೇಕು. 11 ಅಲ್ಲಿ ಪಾರ್ಟಿ ತಗೊಂಬಂದಿದ್ದೀರಾ ಲಕ್ಷ್ಮಮ್ಮನ ಮುನಿಯಮ್ಮಗೆ, ಡೈರೆಕ್ಟ್ ಆಗಿ ತಗೊಂಬಂದ್ಬಿಟ್ಟಿದ್ದೀರಾ ನೋಡ್ಲಿಲ್ವಾ ಸರ್? ಮುನಿಯಮ್ಮ ಇಸ್ ಡಿಸೀಸ್ಡ್. ಅದೇ ಅಲ್ಲೂ ಹಿಂಗೆ ಇದೆ. ಮುನಿಯಮ್ಮ ಡಿಸೀಸ್ಡ್ ರೆಪ್ರೆಸೆಂಟೆಡ್ ಬೈ ಲಕ್ಷ್ಮಮ್ಮ ಅಂಡ್ ನಾಗರತ್ನಮ್ಮ. ಇವ್ರಿಬ್ರು ತಗೊಂಬಂದಿದ್ದೀರಾ ಅಲ್ವಾ? ಹಂಗೇನೆ ಎಲ್ಲಾದ್ರಲ್ಲೂ ಮಿಸ್ಟೇಕ್ ಮಾಡಿ. ಇದ್ರಲ್ಲೂ ನೋಡಿ ಮುನಿಯಪ್ಪ ಇಸ್ ಡೆಡ್, ಇಸ್ ಎಲ್ಲಾರ್ಸ್ ಆರ್ ದೇವರಾಜ್ ಅಂತ ಇದೆ. ದೇವರಾಜು ಮತ್ತೆ ಅಲ್ಲ ಅಲ್ಲೇ ಹೋಗಿದ್ದಾರೆ ಅವರು, ಆರ್ಯನಲ್ಲೇ ಹೋಗಿದ್ದಾರೆ. ಇಲ್ಲಿ R1 is dead represented by R1A. R1A is also dead represented by these R1A1, A2, A3 ಅಂತ ತಗೊಂಡ್ ಬಂದಿರೋದು. ನೀವ್ ಇದನ್ನ ತಗೊಂಡ್ ಬರುವಾಗ ಅದೇ ತರನಾದ್ರೂ ತೋರಿಸ್ಬಿಟ್ಟು ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ಇದೆಲ್ಲ ಮಿಸ್ಟೇಕ್ ಆಗುತ್ತೆ, ಎಲ್ಲಾನು ಮಿಸ್ಟೇಕ್ ಆಗುತ್ತೆ. ಇಲ್ಲ ಅವಾಗೆಲ್ಲ ಈ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅದೆಲ್ಲ ಹೋಗುತ್ತೆ. ಮಾಡಿ ಆಯ್ತು. ಹೌದು ಏನಾಗಿದೆ ಅದು? ಪರವಾಗಿಲ್ಲ ಅಂತಾನೆ ಹೇಳ್ತಾರೆ. ಇಲ್ಲೂ ಇರ್ಲಿಲ್ಲ.
Movement has been carried over. Server number 5 or P instead of 5 or P. Can it be done in a P? That is so.
ಅದೇನ್ ಮಾಡಿದ್ರ ಮೇಡಮ್ ನೀವು?
ಪಿನ್ ಕೋಡ್ ಬರ್ದಿದ್ದೀರಾ?
ಇನ್ಯಾವ್ದು?
ಇದು
ಪೇ ಮಾಡಿ. ಪೇ ಮಾಡಿ.
ಪೇ ಮಾಡಿ.
None obligation.
Serial number 89, my lord, it is covered by your lordship judgment. But I was not, I was adept in other court. So it can.
ನಿಮ್ಮನ್ನ ಕೇಳಿ
Okay, ಇಲ್ಲ, ನಾನು ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ದೆ ತಮಗೆ.
ಸೇವ್ ಮಾಡ್ರಿ.
It's 89. ಕಾಪಿ ಕೊಟ್ಟಿರಿ.
ಕರೆದಾಗ ನಾನು ಡಿಕ್ಟೇಟ್ ಮಾಡ್ತೀನಿ ಬಿಡಿ.
I'll be here.
ಅದು ಇದ್ರು ಬರಲ್ಲ, ನೋ ಪ್ರಾಬ್ಲಮ್.
79, my lords. Last occasion I submitted, my lord, is connected with 1570/2018. 1570 by 2018 RSA. But my lord, it shows that, my lord, that appeal is disposed of. I'll verify, but that.
ನೋಡಿದ್ವಲ್ಲ ಅದು.
Verify that, my lord, Monday or Tuesday, my lord, submit.
ಇದೆಯಲ್ಲ ನೋಡಿ, ಇಲ್ಲೇ ಕೊಡಿ, ಅವ್ರ ಫೈಲ್ ತಗೊಳ್ಳಿ, ನೋಡಿ ವೆರಿಫೈ ಮಾಡಕ್ಕೆ.
Not ready, my lord, that's why. Matter is not listed, my lord, I am not ready. Monday or Tuesday.
ನೀವು ನೋಡಿಲ್ಲ ಅದನ್ನ, ರೆಕಾರ್ಡ್ ತರಿಸಿಟ್ಟಿದೀವಲ್ಲ ಜೊತೆಗೆ.
Monday or Tuesday, my lord.
ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. ಇದೇನು 1/3 ಕೆ ರಾಮ್ ಭಟ್ ಅದ್ರ ಮಾಡಿದ್ವಲ್ಲ ಅದಲ್ಲ. ಎತ್ ಕೊಡಿ. ಅಪ್ಲೈಂಟ್ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್ ರಾಮ್ ಭಟ್ ಅವ್ರು ಇಲ್ವಾ? ರಾಮ್ ಭಟ್ ಇಲ್ಲ, ಬೆಳಗ್ಗೆ ಇದ್ರಲ್ಲ ಅವರು.
ಅಲ್ಲ 79 ಇದು.
ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ 11/7
ಆಗ್ಬೋದು.
Serial number 87. So, senior is not in station. Senior is out of station.
ಪಾಸ್ ಓವರ್ ಮಾಡಿದೀವಿ ನೋಡಿ ಬೆಳಗ್ಗೆ.
ಬೋನ್ಸ್ಗೆ
ಸೀನಿಯರ್ ಇಂದವರೇನಿಲ್ಲ, ಜೂನಿಯರ್ ಸಾಕು ನಮ್ಮ ಕೋರ್ಟ್ಗೆ. ಪಾಸ್ ಕರ್ಸಿ ಮೇಡಮ್ ಎಲ್ಲ ಒಂದ್ ಕಡೆಯಿಂದ.
ಫಾಸ್ಟ್ ಓವರ್ ಮ್ಯಾಟರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಕೆ ಶ್ರೀಹರಿ.
13
Because I have paid the cost, Millers. I have
compliance,
made good the
compliance.
cost. Compliance, Millers, I have written the pin code with respect to the other Millers, 4 pages.
ಆಯ್ತು, ಆಮೇಲೆ
4 pages are photocopies.
ಹಂಗೆ ಹಾಕಿದ್ದಾರೆ ಅಂದ್ರೆ ಸೀಲ್ ಹೊಡೆದಿಲ್ವಾ?
ಅಲ್ಲ, seal photocopies of.
ಫೋಟೋ ಕಾಪಿ ಹಾಕಿದೀರಾ? OS ಟ್ರೀಟ್ಮೆಂಟ್ ಅಂದ್ರೆ OS ಜೆರಾಕ್ಸ್ ಹಾಕಿದೀರಾ ಅಥವಾ ಏನು?
ಇಲ್ಲ, OS ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಇದೆ, ಬರೀ 4 ಪೇಜ್ ಮಾತ್ರ ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಆಗಿದೆ.
4 ಪೇಜ್
ಅದು ಇರ್ಲಿಲ್ಲ ಅಂತ ಜೆರಾಕ್ಸ್.
ಬೇರೆ ಪೇಜಸ್ ಅನ್ನ ಈ ತರ ಸೀಲ್ ಇದೆ. ಈ 4 ಪೇಜಸ್ ಮಾತ್ರ
ಇಲ್ವಾ?
ಜೆರಾಕ್ಸ್ ಹಾಕಿದ್ದಾರೆ, ಅಂದ್ರೆ ಇಲ್ಲಿ ಅವರು ಸೀಲ್ ಹಾಕಿದ್ದಾರೆ, ಅಲ್ಲಿ ಹಾಕಿರೋದನ್ನೇ ಜೆರಾಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ಇದು ಸರ್ಟಿಫೈ ಮಾಡಿಲ್ಲ ಅಂತ.
ಆಯ್ತು ಬಿಡಿ, ಏನು ಅದೇನು ಇದಾಗಲ್ಲ. ಅದ್ ಬಿಟ್ರೆ ಇನ್ನೇನು ಬೇರೆ ಇದೆ? ತಗೊಳ್ಳಿ, ಪಿನ್ ಕೋಡ್ ಹಾಕಿದ್ರಾ? ಆಯ್ತು. ದಿ ಕೌನ್ಸಿಲ್ submits that she has paid the cost and also in respect of other office objections is in some pages seal is not found ಅಲ್ವಾ? ಅದೇನ ಸರ್ಟಿಫೈಡ್ ಆಗಿಲ್ಲ.
Seal is not found.
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ, ಅದು ಓದಕ್ ಸರಿ ಇದೆ ಅಲ್ವಾ?
ಓದಕ್ಕೆ
The same is overruled.
Oblige, Millers.
Post the matter for admission on 22/7.
Oblige.
Copy. ನೀವು ಸರ್ವ್ ಮಾಡಿಲ್ವಾ? Appellant counsel is directed to serve the copy to the AGA.
Please, Millers.
Forthwith.
Oblige.
31 ಕೇಸ್ ರಾಮಸ್ವಾಮಿ ಅಯ್ಯಂಗಾರ್.
This case, madam, filed NOC ವಕಾಲತ್.
ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ರಾ?
ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ದೀನಿ.
ಯಾವಾಗ?
ಇವತ್ತ ಕಟ್ಟಿದ್ದೀನಿ.
ಕೌನ್ಸಿಲ್ submits that he has paid the cost. ಈಗ NOC compliance ಗೆ ಎಷ್ಟು ಸಬೇಕು?
ಒಂದೇ ಸಬ್ಜೆಕ್ಷನ್ ಇರೋದು.
ಏನದು ಹೇಳಿ?
ಕೇವೇಟ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬೇಕಲ್ಲ.
ಮಾಡ್ತೀನಿ. NOC ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ. SN Bhatt undertake to file. SN Bhatt advocate undertake to file ವಕಾಲತ್. NOC ವಕಾಲತ್.
SN Bhatt ಇಲ್ಲಿ ಯಾರು ಇಲ್ವಲ್ರಿ?
ಅದರಲ್ಲಿ NOC ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಯಾರು? KS ರಾಮಸ್ವಾಮಿ ಅಯ್ಯಂಗಾರು NOC ಕೊಟ್ಟವ್ರ ಯಾರಿಗೆ?
SN Bhatt.
SN Bhatt ಗೆ. ಈಗ SN Bhatt ವಕಾಲತ್ ಆಗ್ತಾರಾ? ಅಂಡ್ ಕೌನ್ಸಿಲ್ SN Bhatt undertakes to file wakalat with NOC for the appellant. And also undertakes to furnish the copy on the respondent cavator counsel within 1 week. List this matter on 19/7. Huh? 19 or 11/7? 11/7 ಯಾಕೆ?
1 week.
1 week. ಅದ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಕ್ಕೆ. ಆಯ್ತು.
33.
Venkatesh R. Bhagat.
ವೆಂಕಟೇಶ್ ಆರ್ ಭಗತ್.
My lord.
ಹಾಲೇಶ ಆರ್ಜಿ.
The clerk has been in the counter. The cost has been paid, my lord. He is in the counter. He's filing the acknowledgement.
Complaints.
With regarding to compliance, my lord, copy served to other side. We have served through WhatsApp. That acknowledgement we have filed in the counter. And 3 objection, I have a submission in this, my lord. First objection is with regarding to initial of respondent number 1, my lord. Respondent number 1 in the in RA and in OS, initial of husband is not matching, my lord. The initial of husband has been mentioned in OS as B N Nagaraju. In RA, it is mentioned as G N Nagaraju in the judgment, my lord. Actually, his name is G N Nagaraju. That's what is in the
Number 1.
respondent number 1's husband name.
The council submission regarding the mentioning the initial. And the same is a typographical error and then same is accepted. Bharat, the next.
My lord, next objection is with regarding to
ಇಲ್ಲಿ ಸರಿಯಾಗಿ ಮಾಡಿದೀರಾ?
paragraph and all I have corrected, my lord. Disposal dates I have
Correct
mentioned. my
name
lord.
is mentioned in RSA ಅಂತ ಹಾಕ್ಬಿಡೋದು continuation. Next.
Manja.
With regarding to their name, my lord.
Has executed wakalat as Manjegowda and Nagaraj. To be clarified.
My lord,
Wakalat of appellant number 2 and 4.
ಮಂಜಾ ಚಂದ್ರ ಅಂತ ಇದೆಯಂತಲ್ಲ?
Chandra, his name is Alias as Chandra. Chandra.
Yes.
Yes, my lord. That I have been mentioned even in the affidavit 2 like that only, my lord.
Which affidavit?
The IA which I filed along with the appeal itself. My lord, may I take you to the IA?
He also called as
Uh,
Chandra alias
Nagaraj. Yes, my lord.
So the council submits that the name of Manja and Chandra is mentioned. Manja is also called as Manjegowda and Chandra is also called as Nagaraja.
Yes, ma'am.
And the same is also mentioned in the affidavit and hence the said office objection is accepted. So office objection overruled and council submission is accepted.
No, yes, name of appellant number 4 is stated.
That has been stated in IA also, my lord. That is another office objection. That is
In respect of
Yes, ಅಂತ ಅವ್ರು ಏನ್ ಬರ್ದಿದಾರೋ ಅದು IA ನಲ್ಲಿದೆ. IA affidavit ಅಲ್ಲಿ ಬರ್ದಿರೋದನ್ನ but it is not reflected in OS RA and RSA corporate law.
the appellant name alias is mentioned in the affidavit but not mentioned in the OS and appeal. And hence the council submission is accepted that all are one and the same. Houda?
Yes, my lord.
The council also submit that he has paid the cost on Pantal madam Parlilala, paid the cost and I'll mugitalla.
Yes, my lord. That we have served through WhatsApp, my lord. The same acknowledgement is been filed.
WhatsApp ಅಲ್ಲಿ serve ಮಾಡಿದ್ದೆಲ್ಲ service ಅಲ್ಲ
Physically, I'll serve, my lord.
and council submits that copy to the cavator served through WhatsApp and also undertakes to serve physically. And hence office objections are complied. List the matter for admission
Please,
on 22/7.
please, my lord.
65.
65. Yes, 65. What is that? Recall the order?
Sir.
There was some.
10/6/24 order.
Mention of the name. Name, Manjunath.
Sir.
Manjunath Ji intidiyalla.
So Manjuna, in an advocate, it has been Manjunatha. So that's why we couldn't. Yes, that's why we couldn't find that it has been listed on that 10/6. That
10/6 and dismiss ಆಗಿದೆಯಾ?
Dismiss ಆಗಿದೆ for non-prosecution.
Recall of the order. ಅದೇ ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಯಾಕೆ ಅಂತಂದ್ರೆ ನಮ್ಮ ಲಿಸ್ಟ್ ಬರ್ಲಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳೋದು. Second appeal is dismissed for non-compliance of office objections and non-payment of cost. ಯಾವಾಗ ಇದಾಗಿದ್ದು request of the counsel for the appellant? After 2 weeks. Today also the counsel is absent.
Paid
not paid the cost and also not complied the office objections. Once again on 22/1 at the request, you have appeared before the court on 22/1.
Yes, my lord, and amount has been paid in the bar council. Amount pay ಮಾಡಿದೆ. Fine amount has been paid by that and the receipt has been attached to the before for of the non-compliance.
On what date you have paid the cost, madam? On 5/1/24 itself, cost was imposed.
Yes, my lord.
But you did not comply the same. However, on 22/1/24, at the request of the counsel for the appellant, this court ordered to list the matter after 2 weeks. Today also, the counsel is absent before the court and not paid the cost and even not complied the office objections. On what date you have paid the cost? Where is the receipt?
Receipt has been attached with the file of petition. Presentation has been filed in before the court.
Acknowledgement ಇಲ್ಲಿದೆ ಯಾವತ್ತು ಕೋರ್ಟಿಗೆ ಹಾಕಿದಿರಿ
Has not been-
for having paid the cost and filed.
NOC ವಕಾಲತ್.
This was listed on 10th day of June 2024.
Yes, my lord.
Huh.
That is on that day, Manjunatha, that name has not been, we are searched on the advocate name Manjunatha. So it has been Manjunath. That's why we couldn't appear on that day, my lord. Hence it has been.
ಆಯ್ತು ನೀವು 22 ಫೋನ್ ನಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರಿ ಹೇಳಿ? Did you made the payment of court
Yes,
cost immediately after 22/1/24?
Yes, my lord.
ಯಾವಾಗ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ರಿ? Before 10th of June 2024. ಜನವರಿಯಿಂದ ಜೂನ್ ಒಳಗಡೆ ಯಾವ ಕಾಸ್ಟ್ ಕಟ್ಟಿದಿರಿ?
So that receipt file has been in the
ಏನಂತ
office.
ಹಾಕಿದಾರ? ಹಾಕಿರ್ಬೇಕಲ್ಲ. ಮೋಸ್ಟ್ಲಿ ಪೇಮೆಂಟ್ ಆಗಿರ್ಬೇಕು, ಅದಕ್ಕೆ ತೋರಿಸಿಲ್ಲ ಅಂತ. Not filed the acknowledgement ಅಂತಿದೆ ಮೇಡಮ್, for having paid the cost ಅಂತ.
I will submit,
On what date you have paid the cost?
I will submit the office copy once again. in the
Totally, the council submits that already paid the cost but not produced any receipt. And there is an office note also to that effect. And hence council is directed to produce the receipt or acknowledgement for having produced the same before the court on 11/7. 11/7,
Much of-
verify and submit on that day.
Yes, ma'am.
If cost is paid, I will recall, otherwise I will not recall the order.
Yes, ma'am.
66 Chandranath Tariga.
ಎಲ್ರಿ ಅವ್ರು ಯಾರೀಗ? ಬೆಳಗ್ಗೆಲ್ಲ ಇಲ್ಲ, ಈಗ್ಲೂ ಇಲ್ಲ, ಅವ್ರ ಕೊಲಿಗೂ ಇಲ್ಲ ಈಗ.
ಫೋನ್ ಮಾಡಿದೆ ಕೊಲೀಗ್.
ಲಾಸ್ಟ್ ಟೈಮ್ ನೋಡಿದ್ರೆ ಅರ್ಜೆಂಟ್ ಬೇಕೇ ಬೇಕು ಅಂತ
ಅವ್ರೇ
ಹಾಕ್ಸ್ಕೊಂಡ್ರು
mention
ಅವ್ರೇನೆ. Told, the appellant counsel is absent. Respondent 1 and 2 counsel is present. Fix this matter on 22/7. Maintainability ಮೇಲೆ ಬೇಡ, ಅದು ಮತ್ ಬರಲ್ಲ ಅಂತ. ಅವ್ರಿಗೇನೋ ಅರ್ಜೆಂಟ್ ಇದೆ, ಇದ್ರಲ್ಲೇ ಬರಲಿ ಅಂತ. Next 22/7.
71
ಇದು ಅವ್ರದೇನಾ ಯಾರೀಗ? This matter. If counsel doesn't appear in the next state of hearing, appeal will be dismissed. For non-prosecution, this matter on 22/7.
72
My lord, I am appearing for the
Yes.
respondent number 2 in this case, my lord. I have complied the office objection in this matter, Your Honor, my lord.
Now the matter is for the consideration of IA 1/18. There is a delay of 250 days. What are the reasons you have given? You are appearing for respondent?
I am appearing for the appellant.
Respondent number 2, Your Honor.
I filed
You are
an
appearing for
application.
respondent.
I have filed an application for condonation of delay. Lord, there is a delay of 250 days in filing the appeal. My lords, para 3 of the affidavit, my lords, I have explained that I was not able to approach the advocate in time, and as I suffered from severe illness.
What is that? What is that? Suffered?
Suffered from severe illness.
Severe illness.
Please,
Any document you have produced?
no document is produced.
Then? By saying that I suffered severe illness, that itself is enough to condone the delay? Para 3,
para 3.
Was not able to meet my advocate immediately as I suffered from severe illness andre ಏನದು? Not able to travel my hometown. Deliver the certified copies of judgment to my advocate and instruct him to file the appeal. That is the only reason.
Please.
Without any document. Yes, madam. What is your objections?
1 week may be given, Your Honor. I'm not keeping well. That's the reason in person I could not appear today. 1 week may be given, Your Honor. So I'll come and appear in the person.
Madam, what is your objections to the condonation of delay? Objections hakidara, madam?
We have filed the objection, my lord. The objection is that each day's delay is not in preferring the appeal is not explained in the affidavit.
It is further along with statement of objections to IA 1 of 2018 antide. Counsel for art anta. That is memo. ಇದೆಯಾ? Appellant is a resident of Chikkaballapura, which is a district headquarters of Chikkaballapura district and is situated just 55 kilometers away from Bangalore. There are sufficient transport and communication facility available between Chikkaballapura and Bangalore. Suit for injunction and the same is also dismissed,
My lord,
concurrent pending.
This is a suit for the declaration and injunction. Earlier, a bare suit for injunction was filed by the appellant before your lordship. That suit came to be dismissed in the year 2006. My lord, subsequently, there was a representation given by the respondent number 2 to the panchayat, stating that, my lord, the kata which is standing in the name of the appellant has to be deleted. I mean, the kata has to be cancelled and it has to be made in his name. There an order came to be passed transferring the kata in the name of the second respondent. That came to be challenged in the appeal. That appeal was disposed of in the year 2016 after the filing of this suit. My lords, now the trial court, my lords, did not frame an issue with regard to limitation, but my lords dismisses the suit on the ground of limitation.
Suit is only for permanent injunction.
No, my lords, this suit is a comprehensive suit for declaration and injunction.
But it will very permanent injunction antide. Declaration of her title and consequential relief of permanent injunction. No issues framed?
No, your lordship may kindly take page number 29, issues.
Did you raise whether they raised the issue with regard
They have
to
not
the
raised.
limitations?
They have not raised. My lords,
Is there any pleading with regard to the suit is barred by limitation?
barred by limitation, they have taken they have taken a specific stand that the suit is barred by limitation. But there was no issue framed. The lower appellate court, my lords, dismisses the appeal only on the ground of limitation. If your lordship pleased to see the page number 16, that is the judgment of the lower appellate court, page 16, paragraph 17.
You would have filed an application for recasting of issues.
It was not done before the trial. Court. It was not done before the trial.
Then why you are finding fault with the court? When the court did not frame an issue, you can seek for an alternation of the issues.
My lords, my suit came to be dismissed on the ground of delay and limitation.
Sari re, issue ಯಾವಾಗ frame ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ನೀವ್ ಈಗ ಹೇಳ್ತಾ ಇದೀರಿ, limitation ಮೇಲೆ dismiss ಮಾಡಿದಾರೆ ಅಂತ. Discussion ಇದೆಯಾ ಇಲ್ಲ? Even in the absence of the issue.
Kindly take page number
Because
16.
they have specifically took the contention of suit is barred by limitation in the written statement. ಹೋದಲ್ಲ?
The present suit is filed for relief of declaration and permanent injunction as per Article 58 of the Limitation Act.
Yes, madam, 258 cents delay. Serious objections ಇದೆಯಾ?
ಇದೆ, Your Honor. ಯಾಕಂದ್ರೆ it is there, my lord. Because they have just telling that they had barely, they are telling any, they are not giving any proper reason. That time even there is no corona, nothing was there. And 55 kilometers is a very, they can come from any vehicle. And they are just telling that, and also they are telling that certified copy and all those things. There are no proper reasons are given in the matter, Your Honor. If there is a delay condom.
Appeal was dismissed on March 2017.
Yes, Your Honor.
Please,
My lord.
please.
You have filed the appeal in the March of 2018. Why there was a delay of 1 year? How it will be 250 days? Madam, make
And
reason.
they are telling there is no vehicle for that to
March
come and.
2017 alle dismiss
Silly reasons
agide
they are
28th
quoting for
March
that. This reason.
365 days agutte 250 days henge agutte appeal period only
Appeal period.
ಫ್ರೆಂಡ್ ಶೀಟ್ ಅಲ್ಲ
Appeal period is excluded.
354 days ಆಗುತ್ತೆ 90 days ಡಿಲೇ ಮಾಡಿದ್ದಾರೆ 264 ಆಗುತ್ತೆ ಮತ್ತೇನೋ 14 days ಏನೋ ಕಳೆದೇನೋ ಮಾಡಿದ್ದಾರೆ ಓ ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡಿದ್ದು ಇದು ತೆಗೆದು why there was a delay of 250 days except giving the reasons that suffering from severe illness
Because of her old age, my lords, and she was not able to.
what was the age?
Because at that time, my lords, she was
45 years.
Age is not even not the criteria, Nari.
45
Ignorance they are doing.
It is not your case that you are not having any knowledge of the judgment.
She had the knowledge, my lords, but
No,
the
then-
only reason is that, my lord, she was not able to approach the advocate in time and instruct to file the appeal.
Then it is lapses on the part of the appellant.
Age is also 45, not so old, Your Honor.
Either you
Submission is that
produce
it is
any certificate for having taken the period treatment during that period. Otherwise, no grounds.
I will take instructions. my lord.
Told
If
the
there is
counsel to the
certificate, I
appellant
shall
seeks
produce it.
time to file better affidavit along with documents to condone the delay. And hence, list this matter on 22/7.
Obliged.
Much obliged.
Prasad case.
Severe illness ಏನಾದ್ರು ದಾಖಲೆ ಇದ್ರೆ ಕೊಡಿ.
I shall.
74 Prasad case. This matter is called twice. In the early morning and also in the afternoon, and no representation. This is the appeal of the year 2018. And counsel for the appellant is not pursuing the matter diligently. However, in the ends of justice, another 2 weeks time granted. And if counsel doesn't appear in the next date of hearing, appeal will be dismissed for non-prosecution. This matter on 22/7.
77. Janardana G.
In this case. ಇದರಲ್ಲಿ 4 members
Compliance of office objections ಇದೆಯಲ್ರಿ?
ಅಲ್ಲ 4 members ಎಕ್ಸ್ಪೈರ್ ಆಗಿದ್ದಾರೆ. ಅವ್ರು ಎಲ್ಲಾರ್ಸ್ನ ಇದ್ ಮಾಡಕ್ ಹೋದ್ರೆ ಎಂಟೈರ್ ಅಪೀಲ್ ಮೆಮೋನೇ ನಾವು ರೀನಂಬರ್ ಆಗುತ್ತೆ.
2, 3, 4 ಅಂತ ಕೊಟ್ಟವ್ರೆ.
ಸ್ವಲ್ಪ ಕರೆಕ್ಷನ್ ಆಗ್ಬೇಕಾಗ್ತದೆ.
ಅಲ್ಲ ರೀ ಡಿಸ್ಮಿಸಲ್ ಆದ್ಮೇಲೆ ರಿಕಾಲ್ ಮಾಡಿದ್ರು ಹೋಗಿ ಕಂಪ್ಲೈ ಮಾಡಲ್ಲ ಅಂದ್ರೆ ಏನ್ರಿ ಇದು?
ಆಕ್ಚುಲಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದಾರೆ ನಿಮ್ ಕೊಲೀಗ್
ಮಾಡಿದ್ದಾರೆ
27/6/2024 ಅಲ್ಲ ನೀಡ್ಫುಲ್ ಡನ್ ಅಂತ ಎಂಡರ್ಸ್ಮೆಂಟ್ ಇದೆ ಸರ್.
ಕಾಸ್ಟ್ ರೈಟ್ ಎಲ್ಲ ಕರೆಕ್ಷನ್ಸ್ ಮಾಡ್ಬೇಕು.
ಅಲ್ಲ ಕಾಸ್ಟ್ ಐಟ್ಲ ರೀ ನಂಬರ್ ಆಗ್ಬೇಕಷ್ಟೇ.
ರೀ ಮಾಡ್ದಲ್ಲ ಮತ್ ನಾ ಮಾಡಿದೀನಿ ಅಂತ ಹೇಳ್ಬಿಡಿ. ಅಲ್ಲೇ ಇದೆ ಅಲ್ವಾ ಕರೆಕ್ಷನ್ಸ್ ಮಾಡಿದಿರಾ? ಸತ್ತವನ್ಗೂ ಒಂದ್ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದೀರಿ. ಬೇರೆ ಎಲ್ಲಾರ್ಸ್ಗೂ ಒಂದೊಂದು ನಂಬರ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಕೊಂಡು ಹೋಗಿದ್ದೀರಿ.
ಎಂಟೈರ್ ಅಪೀಲ್ ಈಗ ಕೇಳ್ದೆ ನಾನು ಕೋರ್ಟ್ ಆಫೀಸರ್ನ ಅದ ಎಂಟೈರ್ ಅಪೀಲ್ ರೀ ನಂಬರ್ ಆಗ್ಬೇಕಾಗ್ತದೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ನಾನು.
Appellant counsel seeks further time and in spite of recalling the order of dismissal, appellant counsel not pursuing the matter diligently to comply with office objections and on cost of rupees 500, 2 weeks time granted. If not complied with the office objections and failed to pay the cost, dismiss the appeal without reference to the bench. ಎಲ್ಲ ಮಾಡ್ಕೊಳ್ಳಿ 2 ವಾರದಲ್ಲಿ.
85.
ಹುಂಡಿಕ ಈಗಲೂ ಬರ್ಲಿಲ್ವನ್ರಿ ಇವರು? Appellant counsel, this matter is called And counsel in the earlier occasion made submission that he has got some other matters in other courts. And even this court has passed over in the afternoon also no representation. This matter on 22/7 finally.
88. 86 ఉంది.
86 load Mariappa.
86 ఉంది.
86. ಬೆಳಗ್ಗೆ ಇವರು ಬಂದಿಲ್ಲಲ್ಲ? This matter is called twice and no representation in the early morning and also in the afternoon. However, in the ends of justice, one more opportunity is given. If counsel doesn't appear in the next state of hearing, appeal will be dismissed. This matter on 22/7.
87.
Dismissed for non-prosecution ಅಂತ. 80? ಹೇಳಿ counsel.
Other documents to be collected, madam. So 1 week time is required.
We want
Senior,
time, counsel. Morning you were there, you are not there. Possession order to deliver the possession, that's all, you deliver possession, that's all. Without arguing the matter, you kept the matter pending from 2018 to 2024 instead of delivering the possession. Now also you seek time.
so senior is not
Earlier order sheet
station.
ಕೊಡಿ madam. ಅವ್ರಿಗೂ ಅದೇ ಬೇಕಾಗಿತ್ತು. ಅವ್ರಿನ್ನು ಪೊಸಿಷನ್ ತಗೊಂಡಿಲ್ವಾ, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಸ್ಟೇ ಆಗಿಲ್ವಾ?
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಅವ್ರು ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಇನ್ನು ಪೊಸಿಷನ್ ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರಿಗೆ.
ಅದೇ ಡೆಲಿವರಿ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ.
ಡೆಲಿವರಿ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಆಗಿಲ್ಲ ಇನ್ನು 6 ವರ್ಷದಿಂದ. ಹೌ ಅವರ್ ಕೋರ್ಟ್ ಫಂಕ್ಷನ್ಸ್ ಅನ್ನೋದಕ್ಕೆ ದಿಸ್ ಇಸ್ ಎ ಕ್ಲಾಸಿಕ್ ಎಕ್ಸಾಂಪಲ್. ನೀವ್ ಇಲ್ಲಿ ತಂದು ಒಂದು ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಬಿಸಾಕ್ತಿರಿ 2018ರಲ್ಲಿ. ಅಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕೊಂಡ್ರೆ ಪೊಸಿಷನ್ ಕೊಡಲ್ಲ. ಪೊಸಿಷನ್ ಆರ್ಡರ್ ಆಗಿರೋದು ಲಾಂಗ್ ಬ್ಯಾಕ್ 2017 ಅಲ್ಲಿ. ದಿಸ್ ಅಪೀಲ್ ಇಸ್ ಇನ್ 2018 ಫಾರ್ ಎ ಪೀರಿಯಡ್ ಆಫ್ 6 years. Though there is a decree for possession, possession has not been delivered. ಇವಕ್ಕೆಲ್ಲ ಕೋರ್ಟಿಗೆ ಬರ್ಬೇಕ ಜನ.
ಮಂಡೇ
The appellant counsel again seeks time. ನೀವೇನಾ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇರೋದು? ನಿಮ್ ಸೀನಿಯರ್ ಆಫೀಸರ್?
Senior.
ಸೇಮ್ ಆಫೀಸರ್?
seniors
ಏನಾಯ್ತು ಸೀನಿಯರ್ಗೆ?
is out of station.
And counsel, junior counsel submits that senior counsel is out of station. And this appeal was filed in 2018. ಒಂದು ನಿಮಿಷ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್. 2018. And appellant is also not pursuing the matter diligently from 2018 and on cost of ₹1,000. Finally, 2 weeks time granted. This matter on 22/7. If counsel doesn't argue the matter, appeal will be dismissed on the next date of hearing.
88.
Srinivasa.
Appellant.
ಹೇಳ್ರಿ.
Let the appellant Murad is a agriculture university college at Mandya. Murad on 29/3/1965 Murad, after constitution of the university, for the first time Murad, all the department of agriculture department run the various research stations throughout the state. Murad has been transferred to the agriculture university. This Mandya Murad VC farm is one among the research station. It was transferred Murad to the university. 655.2 acres of land Murad VC farm is transferred to the university. Murad, the question is only Murad is survey number 100. All the survey numbers has been mentioned Murad before the trial court. It is recorded in the judgment. Survey number 100 Murad, it's consisting of 194 acres, 19 guntas is the total extent. Out of which Murad 143 acres Murad transferred to the university. From the beginning, the rest of the land Murad 51 acres, 19 guntas is concerned. The Tahsildar Murad certain bits of land, 5 acres and that, it was granted to certain villages 1987 under the Regularization of Unauthorized Cultivation Act. The respondent number 3 Murad, he was granted 1 acre, 5 guntas. We Murad, there are various villagers are encroachers. Therefore, we approached the Tahsildar. Please look at which land you have been granted. A sketch was been prepared by them, 5 acres and that. 143 acres belonging to us. The rest of the land belonging to the state government. A sketch was prepared by Tahsildar and demarcated the extent of land grant in their favor. Milord, I have no grievance regarding grant. Now, Milord, we have the grievances of encroachers of not only respond number 3, there are others also. We approached the Milord Tahsildar for grant of Milord for conducting the survey and Podi Adbast. He did not do because of the land order problem created by them. Then, my lord, I filed an appeal before the AC. AC, my lord, allowed my appeal, directed to conduct the survey in respect of entire land and identify. Then, my lord, against which the respondent number 3 filed an RP before DC. DC also, my lord, dismissed and confirming his order. When the matter is pending before AC, immediately he filed a present suit and obtained an injunction order obstructing all the officers as well as the university staff from conducting the survey. This is the sum and substance of this case. My lord, in the meanwhile, after dismissal of the deputy commissioner, my lord, their appeal, I filed a writ petition before this honorable court. Look at, it is a valuable land. If it is, my lord, falls under within the 53 acres, left out of 43 acres, my lord, I have no grievance. But they have not been allowing to conduct the survey to identify the government land, university land, as well as the land granted by them.
What is your case?
My lord, my case is, my lord, conducting the survey, identify the land to demarcate the boundaries to the consisting of.
Whether you are claiming in respect of this property, any right?
I am not claiming his property.
Then
Now injunction has been granted, preventing from conducting the survey. Kindly see, my lord, this honorable court in the writ petition directed the Mandya Superintendent of Police, Deputy Commissioner, AC, every should be presented before the spot and to conduct the survey and identify the land to demarcate the boundaries. Now injunction is granted in favor of only one person.
injunction only on their behalf from interfering with plaintiff's peaceful possession.
Only where injunction? If we go there, they never allow to government officers to conduct the survey. This is, therefore, I file a writ petition. Kindly see, my lord, the order passed by this honorable court. Because of the injunction order granting in my favor, he is, my lord, taken a leadership and preventing from others. There is a government land also. Who has to identify? There is no body. That is one aspect.
What happened to this order?
This order, my lord, creating the land order problem, not been done, still it is there because of the injunction order.
You would have filed the contempt before the court if they have not.
Lord, I am a
conducted
government institution, my lord.
Huh?
I cannot.
Okay?
I am.
Government instructions are
La-
okay.
I-
When your right has
My
been
lord, I am-
violated.
the agriculture department, my lord, is controlled by the agriculture universities.
I three.
Against,
Huh.
because of, my lord, to give the
You, already there is a
assistance.
specific direction according
Yes,
to
my lord.
the writ petition.
Correct,
If this order has not been implemented, what is
Look
the
at-
course open to you?
correct. This is an injunction order is operating against me. Please see, my lord. Otherwise, now the suit filed for survey number 100 for P7. Now before the appellate court, his application was allowed and corrected.
Who
Survey
appears,
number?
who appears for this plaintiff?
Plaintiff, my lord, the-
Plaintiff or Billy Gowda?
Respond number 3 here in Biligoda. He is also party in the writ petition.
SV Prakash, Ilvoru.
Illa. Only my grievance is, it is granted. Tagole nivo. Injunction order cannot be operate against the officers of the state as well as the university.
What is their claim in this suit?
My lord, claim is
Granted to them or not?
granted to them by
Plaintiff
the,
is absolute owner and in possession of social property which was granted to him by defendant number 2. Wait, so and so order dated 25/10/1987.
please,
As per that second issued, no circular it was issued from the date of grant, he is continuous possession of suit property as absolute owner. Defendants have also made out the kata in the name of the plaintiff and all the revenue records pertaining to social property standing in his name. When the land was granted in favor of the plaintiff,
out of 191 acres, my lord, where exactly? That is the crux of the
while
matter.
passing an order of grant, whether sketch has been prepared or not.
This has been prepared by the Tahsildar.
Then
According to that, if they go to the, my lord, spot for conducting survey, they are never allowed. Kindly see, my lord, the decree. Survey number 100 bar,
council while granting the
P7.
land, whether sketch has been drawn or not.
sketch has been drawn for the purpose of, unless, my lord, the podi and adbust is fixed. It cannot be, my lord, they cannot climb.
You
This
have
is
no-
my land.
Council, you have no case.
My lord, if it is, kindly see, my lord, page number,
When the grant was made in their favor,
lord, which 191 acres, where it was?
maybe sketch was done according
Take
to you
and
by
done.
showing the property, what was the property?
No,
was
no,
granted
no.
to them.
No, grant is somewhere. Encroachment is government university land. That is my case. That's why I approached this honorable court.
You would have produced the material before the trial court, that's all.
My lord, at that time, my lord, this order was not available. Therefore, I filed an application.
Which order was not available?
My lord, the DC order is not available. AC order was available. It was produced. Now before the appellate court, exhibit, I produce the application along with the, please permitted to produce the document. My application rejected, but the application filed by respondent number 3 for amendment of plight, what has been sought for injunction order 100 bar P7, that has not been modified. In the appellate court, my lord, on the application filed by him, it has been, my lord, corrected as a server number 100 bar P5.
The party is also sought for the relief of permanent injunction in respect of
Granted land.
100 bar P7.
P7.
Measuring 22.8 guntas of.
My lord, 1 acre 5 guntas. Subsequently, the brothers, they partitioned and 22.5 guntas. My lord, that is the different aspect. Now, on looking into the Tahsildar document, they are nothing to do my land, 143. They are encroaching my land by taking the shelter of the injunction order. It cannot be permitted, my lord.
You have to prove that encroachment. Unless you prove the encroachment, the relief is granted only in respect of the property which granted in their favor.
Where exactly? Unless it is, my lord, Podi is conducted, demarcated the boundary.
Sketch is produced or not?
The sketch is not been produced by them. If it is produced, my lord, along with the Tahsildar sketch, then it, my lord, the sketch.
RTC extract Darkhast application given to the Tahsildar, grant certificate, Ahwal Takte, copy of the, Adhikruta Gnapana Patra.
Official memorandum.
Taking letter, consideration receipt. No sketch.
No, not been produced sketch. 191 acres, ಇವರು ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥ 1 ಎಕರೆ ಎಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ ತಹಸೀಲ್ದಾರ್ ಅದ್ಬಸ್ ಮಾಡಿ ಸರ್ವೆ ಮಾಡಬೇಕು. ಈಗ ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್ ನನ್ನ ಮೇಲೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ಸರ್ವೆಗೆ ಹೋದ್ರೆ ಇಂಜಂಕ್ಷನ್ ಇದೆ ಅಂತಾರೆ. Now encroachment is a vast extent of land has been encroached. Therefore, all the grantees have been made a party in the writ petition. Because of this order, my lord could not able to.
So if any encroachment of your property, you have to seek appropriate relief, that's all.
We have sought for the appropriate relief, my lord. There is already an order by the revenue courts. This honorable court also. Now the injunction order is for 1 acre 5 guntas. Other than 1 acre 5 guntas, your lordship may made it observation that the Tahsildar may go and identify. Government also, my lord, want to protect their property also.
What do you say?
45 ಎಕರೆ ಇದೆ ಸರ್ಕಾರದ್ದು.
Instant case, my lord, the suit for in respect of the land measuring of land survey number 100 by P7, my lord, measuring 22 guntas, 0.8.
22.8 guntas.
8 guntas. My lord, the appellate court. Yes.
22.08 guntas.
Yes, ma'am. The appellate court by in the operative portion, the judgment. IA number 3 filed by the respondent number 1 plaintiff under Art 6 Rule 17 of CPC hereby allowed. In the result, the plaintiff shall carry out amendment to the plaint schedule to correct the subdivision of the survey number 100 as P5 instead of P7. Consequently, the trial court shall also carry out amendment to the decree schedule to that effect. So, the lower appellate court has committed serious error. In fact, the trial court has granted the decree in respect of
P7.
Serial number 100 bar P7.
7. Now P5.
The lower appellate court has committed serious error. So without granting.
Because they sought for an amendment.
So without granting opportunity, otherwise the appellate court has to remand the matter to the trial court to adjudicate the providing the opportunity to the defendant to file the written statement. So unilaterally, the lower appellate court has committed serious error. So it is not permissible in the eye of law.
State is also a party, Tahsildar also a party, my lord. Please, in the judgment and decree, both the court.
So entire subject matter is different, my lord, as could be seen from the trial, the appellate court judgment. So therefore, the reconsideration is very much required.
State of Karnataka, Tahsildar and Krishi Vishwavidyalaya. All of them are parties. Now the Tahsildar also cannot conduct a survey.
Before allowing the amendment, my lord, the trial court has to provide the opportunities to the defendants to put forth their.
Have you objected the application when the same is filed for amendment? Whether amendment application was allowed?
My lord,
Hereby allowed, in the result, the plaintiff shall carry out amendment. Have you filed any objections to this IA number 3?
Lord, in the foregoing paragraphs, I have referred to the material certified by the plaintiff and Lord, para 23. Proceed to appreciate the material offered by the defendant And in cumulative effect, when combined reading of the said materials are
Whether
made,
any
it was
specific issue with
block
regard to
number
the
5
amendment is concerned?
demarcated out of survey number 100 to the extent of 1 acre 5 gunta came to be granted in favor of the plaintiff, which of course later becomes survey number 100 bar P5 by virtue of mutation of the name of the plaintiff in the long-standing RTCs produced as
Number
per
3.
so on, so on. I number 3 shall be rectified. Rather, any such a proposed amendment will not change the nature of the suit nor any description of so on, so on. That cannot be done it in before the appellate court because Lord, there are various bits of land P1, P2, P3, Lord, 191 acres. Now is
Whether grant was in respect of 100 bar P5 or P7?
Lord, that is also Lord, is
Grant records.
as per the grant records, Tahsildar records, Lord, it is granted Lord, out of.
Whether he has produced the grant certificate before the trial court?
I didn't think so.
P1 to 8. Telecast
One
application.
copy
Grant
of the order of
certificate
the
exhibit P10. P10 prakara yenu? 100 and P7 or P5?
grant certificate.
Grant certificate all 100 P for 5 or P for 7?
P5. ನೂರು ಅಂತ ಹಾಕಿದ್ದಾರೆ ಸರ್ಟಿಫಿಕೇಟ್ 100 ಅಂತ ಹಾಕಿದ್ದಾರೆ ಕೊಡಿ ಮೇಡಮ್ ಸಾಹೇಬ್ರು 1 ಎಕರೆ 5 ಗುಂಟೆ ಅಂತ ಹೇಳಿ 100 ಅಂತ ಇದೆ
Already in evidence nothing to do with the suit schedule property to the extent of 22.8 guntas of land and that is the evidence of defendant number 3 and 4.
correct grant is melad 1 acre 5 guntas out of 191 acres. A sketch was prepared by Tahsildar. Our grievance is please conduct the body.
It is nothing to do with the land granted to the plaintiff. Further, he has deposed that the record of rights with respect to one is not standing in their name and he has not inquired regarding that further deposed is not aware of the schedule shown in the plaintiff. This
Correct.
is your evidence.
Unless melad the entire land is
Here is a clear admission on the part of you. Nothing is.
ಅವ್ರ ಗ್ರಾಂಟ್ ಮಾಡಿರ್ತಕ್ಕಂಥ ಜಾಗನ ಗುರ್ಸ್ಕೊಂಡು ಪೋಡಿ ಮಾಡ್ಕೊಳ್ಳಿ.
That is not your case where you have pleaded like
No,
that.
kindly melad see the judgment.
Your evidence is very clear. Nothing to do with the land granted in favor of the plaintiff. Go to paragraph number 13
The
of the
Tahsildar sketch is
you
grant
are
is
arguing against the admission given by your witness.
please see melad 143 acres belonging to us.
Counsel,
There-
every time you are telling like that, you go to the paragraph number 13 of the judgment of the trial court. You read the
13.
printing.
Office staff of defendant number 3 and 4 has filed an affidavit stating that the state of Karnataka has granted 652 acres, that is various survey number, in their favor comprising several survey number, but on perusal of the survey number, nowhere the survey number 100 bar P7, where the suit schedule property is situated, is mentioned. Further, he has deposed that before filing of this suit, they have not challenged the grant in favor of the plaintiff and also that name of the plaintiff is shown in the record of right pertaining to survey number 100 bar P7. Since from 2001-2, he has also admitted that this suit is related to the 22.8 guntas of land granted to the plaintiff and also that their university is nothing to do with the land granted to the plaintiff. Further, he has deposed that the record of right with respect to 100 bar P7 is not standing in their name and he has not inquired regarding the further deposit. He is not aware of this so and so, so and so. Well, at 107, correct. Now amendment is 100 bar 5P. It is amended now. What has been deposited before the trial court? Now I have no grievance with regard to the grant of land. I am grievance is only unless and until my lord the body durasi has been carried out by the department of ADLR and Tahsildar. Identification of the land. My land is where? Granted land is somewhere.
Get it identify your property that is 655.02 acres of land.
Please, my
In
lord.
your favor.
Even till today, let them get the survey, the land, get the adbust. My grievance is to conduct my 143 3 acres of land in survey number 100. Therefore, all the two orders in my favor, AC, DC. Then this honorable court also directed to give.
Then you get it, survey your land, what is granted in favor of you.
Now injunction order is operating against me.
Injunction in respect of 100/P7. No grant in favor of you in respect of 100/P7.
That was rectified by the appellate court.
Counsel, you get it, survey the land, what granted in favor of you. If he is in possession of the property within the boundary which is granted to you, you file a suit for.
Right, it is not grant, my lord. It is a transfer of the entire unit to the university.
ಯಾವ property ನಿಮಗೆ grant ಆಗಿದೆ ಅದನ್ನ ನೀವು.
Correct.
First you get it, identify your
If that
property.
is so, my lord, if that is so, by virtue of the injunction granted for 22.5 guntas.
No, I don't know why you are not understanding this.
My lord, I understand.
ನಿಮಗೆ ಲ್ಯಾಂಡ್ ಗ್ರಾಂಟ್ ಆಗಿದೆ ರೀ. ಆ ಲ್ಯಾಂಡ್ ಯಾವ್ದು ಅಂತ ಫಸ್ಟ್ ನೀವು ಐಡೆಂಟಿಫೈ ಮಾಡ್ಕೊಳ್ಳಿ. ನಿಮ್ಮ ಪ್ರಕಾರ ಅವ್ನು ಐಡೆಂಟಿಫೈ ಮಾಡಿ ನಿಮ್ ಲ್ಯಾಂಡ್ ಏನ್ ಐಡೆಂಟಿಫೈ ಆಗಿದೆಯೋ ಆ ಪ್ರಾಪರ್ಟಿ ಒಳಗೆ ಅವ್ನು ಕುಳಿತುಕೊಂಡಿದ್ದಾನೆ ಅಂತ ಅಂದ್ರೆ ಯು ಫೈಲ್ ನೆಸೆಸರಿ ಸೂಟ್ ಫಾರ್ ದಿ ಪೊಸೆಷನ್, ದಟ್ಸ್ ಆಲ್.
Correct.
ಮತ್ತೆ
Should I
first
not?
of all, your property is not yet identified. How you can say
no.
that he is squatting on your property?
No, so person is whether he has encroached or not of my land. Should I not get the conduct of the survey to the extent of entire my 143 acres?
Say case for you file a appropriate suit, that's all. So
Lord, it
this
is
matter is listed for admission. I
Lord,
heard.
kindly see, my lord, the order is.
You are not claiming any right in respect of survey number 107. Even you are also not claiming 107P5 also. Your land is different.
My lord,
University is nothing to do with the property granted in favor.
please
of the
consider this
plaintiff.
aspect, my lord, when the entire unit is transferred 1965, only survey number 100. Thereafter, the P1, P2, P3 Act has come. It is not for my land, P1, P2, various others. It is a bit of land that has been, survey sketch has been.
ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ನಿಮಗೆ ಸರ್ವೆ ನಂಬರ್ 100 ಅಲ್ಲಿ ಗ್ರಾಂಟ್ ಆಯ್ತಲ್ಲ, ಆ ಪ್ರಾಪರ್ಟಿ ಡಿಮಾರ್ಕೇಶನ್ಸ್ ಇರುತ್ತಲ್ವಾ ನಿಮಗೆ ಗ್ರಾಂಟ್ ಆದಾಗ.
ಸರ್ಕಾರದಲ್ಲಿ ಒಂದೇ ಸ್ಕೆಚ್ ಇದ್ದಿದ್ದು ನಮಗೆ ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥ 143 ಎಕರ್ಸ್ ಎಲ್ಲಿ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಏನಿದೆಯೋ ಆ ಸ್ಕೆಚ್ ಸರ್ವೆ ಮಾಡಿಸ್ಕೊಳ್ಳಿ.
ಯಾರು ಮಾಡ್ಬೇಕು? ಅವರು ನನ್ನ ಜಮೀನು ಮಾಡೋದಕ್ಕೂ ಬಿಡಲ್ಲ, ಅವ್ರ ಜಮೀನು ಮಾಡ್ಕೊಳಕ್ ಹೋಗಲ್ಲ. This is the crux of the matter.
ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ನೀವು ಮಾಡಿಸ್ಕೋಬೇಕು. ನಿಮ್ಮ
ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಆದ್ರೆ ಎಂಟೈರ್ ಗೊತ್ತಾಗುತ್ತೆ.
ಏನು ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಮಾಡ್ಬೇಕ್ರೆ?
ಐಡೆಂಟಿಫಿಕೇಶನ್ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟಿ.
These people are not disputing the grant in favor of the plaintiff, but plaintiff claims he is in possession in respect of the property granted in his favor.
ಮಾಡಿ ಸ್ಕೆಚ್ ಮಾಡಿ ಟಿಪ್ಪಣಿ ಕೊಟ್ಟು ಅವ್ರಿಗೆ ಇಂಥ ಜಾಗದಲ್ಲಿ ಅವ್ರನ್ನ ನಾವು ಇರಿಸಿದೀವಿ ಅಥವಾ ಪುಟ್ ಇನ್ ಪೊಸಿಷನ್ ಅಂತ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡಿದವರು.
ಹೌದು.
ಸೊ ಎಂಟೈರ್ ಲ್ಯಾಂಡ್ ಅವ್ರಿಗೆ ಎಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ ಐಡೆಂಟಿಫೈ ಮಾಡಕ್ಕೆ.
ಸರಿ ರೀ, ನೀವೇ ಹೇಳಿದಿರಿ we are nothing to do with the property granted in favor of the plaintiff ಅಂತ. And then what is there to decide in this case?
ವಿಸಿ ಯೂನಿವರ್ಸಿಟಿ ಇದೆ ಅಲ್ಲಿ. ಸೊ
ಆಯ್ತು, ನೀವೆಲ್ಲ ಕೈ ಜೋಡಿಸ್ಕೊಂಡಿರ್ತೀರಲ್ಲ ಎಲ್ಲರೂ ಸೇರ್ ಜೊತೆಗೆ, ಅದನ್ನ ಹೇಳಿ.
ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಅಂದ್ರೆ
ಏನ್ ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಮಾಡ್ಬೇಕು? ಕನ್ಕರೆಂಟ್
ಯಾವ್ದು ಮ್ಯಾಟರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮೇಲೆ ಐ ವಿಲ್ ಸಬ್ಮಿಟ್.
The Tahsildar has prepared this sketch. According to the Tahsildar sketch, if they go to their spot, we have no objection.
The crux of the issue is you are not claiming any right in respect of the property granted in favor of the plaintiff. Plaintiff is also sought for the relief of permanent injunction in respect of this particular suit land. When the university is nothing to do with regard to the granting of property in favor of the plaintiff, how you can object for the relief of permanent injunction?
Humble services in this matter to avoid such complications and confusions. So record
ನಿಮಗೆ ಯಾವಾಗ 1965 ಲ್ಯಾಂಡ್ ಗ್ರಾಂಟ್ ಆಯ್ತಲ್ಲ, ಏನೋ ನಿಮಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರಲ್ಲ, ಅದ್ರದ್ದು ಐಡೆಂಟಿಫಿಕೇಶನ್ ಫಸ್ಟ್ ನೀವು ಮಾಡ್ಕೋಬೇಕು. ಅದು ಮಾಡಿಲ್ಲ. According to him, there is a direction to survey the land. That is also not yet done. How he can say that land comes within my land, the property of the plaintiff?
The principal issue illé settle agli so now I will get instructions and records records barli so
ಇಲ್ಲ, ತಹಸೀಲ್ದಾರ್ ಸ್ಕೆಚ್ ತರಿಸ್ಕೊಂಡ್ರೆ ಗೊತ್ತಾಗ್ಬಿಡ್ತದೆ.
ನಾನು ಕೂಡ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೋತೀನಿ.
ಎಲ್ರಿ ಇವರು SV ಪ್ರಕಾಶ್ ಇಲ್ವಾ? ತಗೊಳ್ಳಿ. Heard the appellant counsel and also the counsel appearing for R1 and R2 and counsel for R3 who appears for the plaintiff is not before the court. And in the meanwhile, counsel for the appellant and AGA seeks time to get the records and make submission in the next date of hearing. This is matter 42-7.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಹಾಕ್ಬೇಕು, ಬೇಕಾಗಿಲ್ಲ. ನೀವೇ ನಿಮ್ದೇನಿದೆ ಹೇಳಿ.
ಪ್ಲೀಸ್
Records ಏನು ಬಂದಿಲ್ಲ ಮೇಡಮ್, ಇದ್ರಲ್ಲಿ ಇಲ್ಲ ಅಲ್ಲ? In the meanwhile, registry is directed to get the records from the trial court.
ಈ ಕರುಂಬಯ್ಯ
ಕೊಡಿ, ಅದೇನು ಆರ್ಡರ್ ಇತ್ತಲ್ಲ? Heard the appellant counsel and also the counsel appearing for the respondent. The second appeal is filed against the concurrent finding of both the courts passed on IA number. The IA number ilva? IA filed under Order 7 Rule 11D of CPC, wherein prayer was sought to reject the plaint on the ground that suit appears is barred by law of limitation. The trial court, taking into consideration of material available on record, allowed the IA and rejected the plaint. Being agreed by the said order, appeal is filed before the appellate court, and appellate court also having reassessed the material available on record, confirmed the judgment of the trial court. Being agreed by the said order, the present second appeal is filed before the court, and counsel appearing for the appellant would vehemently contend that both the courts have committed an error in passing an order by allowing application of Order 7 Rule 11D of CPC on the ground that suit is barred by limitation. And question of limitation is also mixed fact and law when the parties have disputed the facts of cause of action. Under the circumstances, ought not to have dismissed the plaint. The counsel appearing for the appellant also reiterates the grounds urged in the second appeal. Per contra, the counsel appearing for the respondent would vehemently contend that this court already comes to a conclusion that no merit in the appeal in regular second appeal of 523 of 2020. Are they filed ಮಾಡಿದ್ದು? Same order mela? Is it on the same order?
Yes.
Innೊಂದು ಸೂಟು?
Same grounds.
Same grounds ಮೇಲೆ. And the similar order was passed in OS number 1360 of 2011, wherein also application filed under Order 7 Rule 7 was filed and allowed, and an appeal was also filed in RA number 72 of 2016, and the same also dismissed and confirmed and against the said order. RSA is filed in 523 of 2020, and this court, while considering the similar factual circumstances, comes to the conclusion that both the courts, having taken note of the fact that the Article 54 of the Limitation Act, that there was a sale agreement and there was a stipulation in the sale agreement that Fragmentation Act is prevailing, and hence plaintiff cannot execute the document, and the sale deed would be executed after the repealment of the Fragmentation Act. Full stop. Admittedly, Fragmentation Act repealed in the year 1991 itself, and suit was filed in the year 2011. All these factors have taken note of by the trial court as well as the first appellate court, and hence this court find that no grounds are made out. In the present facts of the case, also suit is filed in 2011. This is also based on sale agreement, and the same is also based on the sale agreement. And when this court already considered similar sets of facts and comes to the conclusion that suit is barred by limitation, in view of the Fragmentation Act was repealed in the year 1991 and suit is filed in 2011, the same is barred by limitation, and hence in this case also I do not find any ground to entertain the second appeal. In view of the discussions made above, I pass the following order. Second appeal is dismissed.
90. issue.
ಬಂದ್ರೇನ್ರಿ ಇವರು ಇಲ್ವಾ? ಸೇಮ್ ಆರ್ಡರ್ ಮೊದ್ಲೇ ಯಾವ್ದೋ ಒಂದು ಪುಂಡಿಕಾಯಿ ಅಂತ ಮಾಡಿದ್ವಲ್ಲ ನೋಡಿ, ಅದೇ ಆರ್ಡರ್ ಮಾಡಿ. 85 ಸಿಮಿಲರ್ ಆರ್ಡರ್. ನೆಕ್ಸ್ಟ್ 92 ಸೋಮಶೇಖರ KM.
ಅಲ್ಲ ಅದು RP
ಆ ಸೋಮಶೇಖರ್ ಬೇರೆ,
ಇದು
ಅವ್ರು RP
KM.
ಸೋಮಶೇಖರಯ್ಯ ಅವರು, ಇವ್ರು ಸೋಮಶೇಖರ KM. ಏನಾಯ್ತು ಬೆಳಗ್ಗೆ? Admission first time ಬರ್ತಾ ಇದೆಯಾ? ಆಯ್ತು. This matter is called twice and no representation, and this is the appeal of the year 2020. Twice in the morning, in the Akpodi. Earlier in the early morning and also in the afternoon, and no representation. Matter of the year 2020, and counsel for the appellant is also not pursuing the matter diligently. However, in the ends of justice, one more opportunity is given. If counsel doesn't appear in the next date of hearing, the same will be dismissed.
96.
This matter on 22/7. 96 ಹೇಳ್ರಿ.
1 ಬಂದಿದೆ ಸರ್.
91 ಇದೆಯಾ?
ಬೆಳಿಗ್ಗೆ ಅವ್ರು
ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅವ್ರೇನೋ ಹೇಳಿದ್ರಲ್ಲ ಬೆಳಗ್ಗೆ. ಒಂದೇ ನಿಮಿಷ ಹೇಳ್ಬಿಡಿ, ಏನ್ರಿ ಅದು?
Kindly appreciate.
ಹೇಳಿ.
The suit is for declaration filed by the respondent. Respondent is the mother of the appellant. The mother had executed the registered gift in favor of the son on 26/2/2009, Lordship. Subsequently, there was some differentiation between the plaintiff and defendant, son and mother and son. They filed a suit for declaration declaring that registered gift deed declared as null and void, Lordship. Now, Lordship, kindly appreciate, before the trial court, the plaintiff utterly failed to prove the case that the gift deed has been obtained by playing a fraud, misrepresentation and coercion. Therefore, the honorable trial court has dismissed the suit. Against to that, the plaintiff filed a appeal before the first appellate court. The honorable first appellate court taken a view that when the gift deed was executed, the defendant was a minor. Lordship, kindly appreciate, here the defendant is the son of the sole son of the plaintiff, Your Honor. When defendant was 2 months or 3 months, his father was died, Lordship. Therefore, no, regarding minor, document has been executed in respect of minor, does not take into consideration, as the mother herself had executed the gift deed in favor of the son, Lordship. Now, trial court, Your Honor, kindly appreciate, section 22 of the TP Act very clearly denotes that the gift deed can be accepted at any time during the lifetime of the donor. Now, here the honorable first appellate court questioned the acceptance of the gift, Lordship. Now, against that, I have filed the appeal.
Call for records issue notice.
Kindly, Lordship, illi mother are trying to alienate the property. The house construct mother, that is respondent, are trying to alienate the property. House is on the residential house. Kindly restrain her to alienate the property.
Mother.
How to say? Mother and that is respondent. Respondent is mother of the appellant. She is putting best effort to sold the property.
Heard on IA 1 of 19 and counsel would say, ಅಲ್ಲ ರೀ ಮದರ್ ಸೇಲ್ ಮಾಡ್ತಾರೆ ಅಂತ ನೀವು ಹಾಕಿರೋದು ಅರ್ಜಿ ಹಾಕಿರೋದು 2019
ಆಕ್ಚುಲಿ ನಾನು
24 ಏನ್ ಮಾಡ್ತಾ ಇಲ್ಲ?
ಇಲ್ಲ ಇಲ್ಲಿ ಏನಾಗಿದೆ, ನನಗೆ NOC ಬಂತು, ಹಂಗಾಗಿ ನನಗೆ NOC ಬಂದ್ಮೇಲೆ ಕಾಪಿ ಇಲ್ಲ ಆಲ್ರೆಡಿ ದೇರ್ ಇಸ್ ಥ್ರೆಟ್ ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ದಯವಿಟ್ಟು ಅಟ್ಲೀಸ್ಟ್ ನಾಟ್
ವರ್ಷದಿಂದ ಯಾವ ಎಲಿನೇಷನ್ ಥ್ರೆಟ್ ಇಲ್ಲ, ಈಗೇನ್ ಥ್ರೆಟ್
ನಾಟ್ ಎಲಿನೇಟ್ ಅಂತ ಆದ್ರೆ
ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. ಕೊಡಿ 1 ಮಂತ್ ಆದ್ಮೇಲೆ 5/8 ಈಗ ಥ್ರೆಟ್ ಅಂತ.
96.
Plaintiff second appeal. Suit is for declaration and permanent injunction. Suit schedule properties in agricultural land measuring 3 acres. That survey number 48 of Sanjaynahalli village, Kelur Obli Gubbi Taluk, was totally measuring 5 acres. It was purchased by husband of the plaintiff by name Chandranna. On 7/6/1960, Chandranna has sold 2 acres of land in survey number 48 to husband of the first defendant. He has remained with the retained 3 acres of land. 3 acres of land is the suit schedule property. Possession of the 3 acres of land still stands with the plaintiff. My lord, in 2007, the defendants have tried to make
Plaintiff husband purchased total extent of 5
acres.
5 acres. Only sold 2 acres.
2 acres is
Remaining
our
land
country
of
in the
3
year
acres.
1960.
Aito.
Remaining land 3 acres was retained by husband of the plaintiff and the plaintiff has succeeded and his children were in possession of the remaining 3 acres of land. My lord, in the 2007, my lord, Chandrana has died. The plaintiffs have succeeded over the property. Lord, on 11/11/2013, the present suit is filed for permanent injunction as the defendants have, after the death of Chandrana, have tried to make an attempt to interfere with the plaintiff's possession. My lord, contention of the defendant is, this Chandrana has sold remaining extent in the year 1969. That is the
Remaining 3 acres of land also.
was also sold by Chandrana in the year 1969. Issue number 2 at page number.
45.
Houdu. That is the second issue. Whether the defendant proved that the husband of the plaintiff had sold 3 acres of land in survey number 48 in favor of father of second defendant under the register sale deed dated so and so. Well, to prove the contention, they have produced the certified copy of the sale deed as exhibit D2. But they have not produced the original sale deed and no foundation was made to produce the secondary evidence. They have not stated what happens to original sale deed. Even the witnesses to sale deed has also not been examined by the defendant. Well, it is section 68 of the Indian Evidence Act, it has to be proved in accordance with law. Witness needs to be examined. In the absence of the evidence on record, both the courts have come to conclusion that the defendants have proved that the property of the remaining extent 3 acres was also sold by Chandrana in favor of the
From
defendant.
1969.
Yes.
Property stands in whose name?
My lord,
This 3 acres
my lord,
of
up to
land.
1983, Kata stands in the name of Chandrana.
Then
After 1983, it was Kata was changed in the name of the husband of the first
from
defendant.
that date till filing of suit, what you are doing?
Well,
2013.
possession remains with us, but we are not aware of the change of the Kata. But as per section 68 of the Indian Evidence Act is clear, my lord, it has to be proved in accordance with law. So original sale deed has not been produced.
Document of the year 1969. Sale deed of the year
My lord, if it is
1969.
original from the custody of the defendant is furnished,
Even if
then
original is
then
not
section
produced,
90 of the
registered document, certified copy is produced before the trial court.
my lord, foundation to lead secondary evidence has not been made by the
Property was
second
sold
defendant.
long back in the year 1969. Now you are questioning that the same was not sold by the father.
ಅಷ್ಟೇ 68 ಅಲ್ಲಿ ನಮ್ದು ಎರಡೇ ಗ್ರೌಂಡ್ ಅದು.
There is a sale deed in the 68 only.
Yes, my lord is right, my lord. As far as 90 is concerned, if it is from the proper custody, original document is produced.
Even if original is not there, secondary evidence.
Yes,
can be
to lead
produced.
secondary
The
evidence
Same is produced and marked before the trial court.
Yes, I am sailing with my lord, my
It
lord.
not
But
necessary
as
to
far as the
examine
secondary
the
evidence
evidence
is
of the
concerned,
sale deed of the year 1969.
foundation has not been given. There not explanation has not been given. What happens to the original sale deed?
That is the only ground.
ಅಷ್ಟೇ ಎರಡೇ ಗ್ರೌಂಡ್.
Lord, this matter is listed for admission and I heard the counsel for the appellant. The factual matters of case of plaintiff before the trial court that suit scheduled property belongs to the plaintiffs, contending that the plaintiff's husband Chandrana has purchased 5 acres of land in the land bearing serial number 48 of Sanganalli village, Chelur Hobli, Gubbi Taluk, and a registered sale deed dated 21/8/1959 from one Rangappa.
My lord,
Since the day
my presence may be exempted.
Since the day of purchase, the plaintiff's husband was in physical possession and enjoyment of the same as an absolute owner. The revenue records also changed in the name of the husband. It is also the case of the plaintiff that out of the said extent of land sold 2 acres of land under a registered sale deed dated 7/6/1960 to one Shivanna, that is husband of the first defendant. The said Chandrana retained 3 acres of land in his name, that is social property in the present case. The plaintiff's husband died on 27/5/2007, leaving behind his wife and children as his legal heirs. After the death of said Shivanna, the plaintiff and her children have been continuing in possession and enjoyment of the suit scheduled property as absolute owners. ಅದು ಶಿವಣ್ಣ ಅಲ್ಲ, after the death of ಚಂದ್ರಣ್ಣ ಇರ್ಬೋದು. ಶಿವಣ್ಣ ಅಲ್ಲ madam. After the death of ಚಂದ್ರಣ್ಣ, the plaintiff and children have been continuing in possession and enjoyment of the social property as absolute owners. It is also the contention that husband of the first defendant, that is Shivanna, by colluding with revenue officials, has created and concocted revenue documents, records, and transferred 5 acres of land into his name as per MR number 1/1988-89 instead of 2 acres. The defendants and the said Shivanna are only entitled for 2 acres of land under sale deed dated 16/4/1990 and not entire extent. But got it changed the property by MR number 22 of 2009 bar 9/10 dated 30/4/2010. And earlier to that MR number 6 of 6/1989-90 dated 16/4/1990. And when they came to know about the fraudulent act and concocted revenue records, plaintiff filed an appeal before the Assistant Commissioner. And also contend that the defendants are not having any right over the suitable property. In pursuance of the suit summons, defendants appeared and filed a written statement contending that not only they have purchased the 2 acres of land and remaining land was also sold in favor of the husband of the first defendant on 17/3/1969, and possession also delivered to the total extent, and consequently MR number 1 of 1989-90 came into existence. And the very claim made by the plaintiff is erroneous. Having considered the pleadings of the parties, the trial court framed the issues and allowed the parties to lead evidence by framing an issues. Whether the defendant proves with regard to the second sale, and whether the plaintiff proves that the second sale dated 17/3/1969 is fraudulent concocted. The trial court, having considered both oral and documentary evidence, answered the issue number 1 as negative, that plaintiffs are not the absolute owners. On the other hand, answered the issue number 2 as affirmative, that this property was sold in favor of the husband of the defendant to the extent of 3 acres of remaining land. And the very contention of the plaintiff that a fraudulent transfer was got is also answered as negative, and trial court dismissed the suit filed by the plaintiff, coming to the conclusion that the very contention of the plaintiff that fraudulently got it transferred the property is not accepted. Being agreed by the said judgment and decree of the trial court, an appeal is filed in RA number 92 of 2019, and appellate court also, having considered the grounds urged in the appeal memo, formulated the point whether the trial court committed an error in coming to the conclusion that husband of the defendant number 1 had purchased the property under the sale deed dated 17/3/1969, and whether the entombed judgment requires interference. The first appellate court also, having reassessed the material available on record and even taken note of the judgment of the apex court in 2006 within bracket 5 SEC 353 between Prem Singh and others versus Birbal and others, extracted with regard to the presumption that a registered document is validly executed. First of a registered document, therefore, prima facie would be valid in law. First of the onus of proof, thus, would be on a person who leads evidence to rebut the presumption. First of, in the instant case, respondent number 1 has not been able to rebut the said presumption. And having reassessed the material on record in the light of the principles laid down in the judgment, and considering both the oral and documentary evidence, the trial court, the first appellate court confirmed the judgment of the trial court. Being agreed by the said judgment and decree and confirmation, the present second appeal is filed. The main contention of the counsel appearing for the appellant that the sale deed which they rely upon, that is exhibit D2, is only a certified copy and original is not produced before the court, and no explanation is given for not furnishing the original document. And trial court and appellate court not to have accepted the document of exhibit D2 with regard to the sale is concerned. And hence court has to admit and frame substantive question of law. having heard the appellant counsel and also on perusal of the material available on record, no doubt the original sale deed is not produced, but certified copy of the sale deed is produced and marked as exhibit D2. And exhibit D1 is also in respect of the earlier sale deed of the year 1960 and subsequent sale deed is of the year 1969. And also admittedly, the husband of the plaintiff passed away in 2007, and during his lifetime from 1969 to 2007, he did not challenge the sale deed. And only after the death of the husband, the present suit is filed. That too in 2013, contending that fraudulently obtained the documents, even not pleaded with regard to the very existence of subsequent sale deed. And when the defendant raised the objection, when the defendant filed written statement contending that property was sold in the year 1969 itself, the issue also framed both whether the sale deed is fraudulent one or whether the sale deed was executed by the husband. And having considered the material on record, the trial court comes to the conclusion that fraud has not been proved as alleged. And at the first instance, only allegation of fraud in getting the transfer of 3 acres of land in collusion with the revenue officials, and material found that there was a sale deed in favor of the husband of the first defendant in the year 1969 itself. And I have already pointed out that during the lifetime of the husband of the plaintiff not challenged the said sale deed, and only after the death of the husband of the plaintiff only the sale is questioned, that too in 2013, and all revenue entries are also changed in the name of the plaintiff in the year 1989 itself onwards also. And when such being the case, the very contention of the appellant counsel that still they are in possession and the same has not been established, and the appellate court also having considered the judgment of the apex court, taken note of there is a presumption in respect of the registered document, and also taken note of section 31 of the specific relief act, which deals with the cancellation of written instrument by the competent civil court, if the plaintiff establishes the 3 ingredients contained under section 31 of the specific relief act, and the same has not been done. And only relief is sought for the declaration. When such being the material on record, I do not find any ground to interfere with the concurrent finding of the trial court as well as the first appellate court when the sale has not been proved as a fraudulent one, and the same is also not questioned seeking the relief of specific relief under section 31 of specific relief act. Under the circumstances, I do not find any ground to invoke section 100 of CPC. In view of the discussions made up, I pass the following order. Second appeal is dismissed.
101 RB Sadashivappa, PM Sidmalappa. Respond.
ಎಲ್ರಿ RBS ಬೆಳಗ್ಗೆಲ್ಲ ಇಲ್ಲ ಈಗಲೂ ಇಲ್ವಾ? ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾರು ಆಗಿದೆಯಾ ನೋಡಿ, ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ.
Appellant counsel is present ಅಂತ ಇದೆ.
ಲಾಸ್ಟ್ ಟೈಮ್
Respondent counsel 6 times.
ಲಾಸ್ಟ್ ಟೈಮ್
4:15 ಆಗಿತ್ತು.
ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ಕೇಳಿದ್ರ ಟೈಮ್
4:15 ಆಗ್ಬಿಟ್ಟಿತ್ತು. ತಾವು ನೀವು ಟೈರ್ ಆಗಿರ್ಲಿಲ್ಲ, ನಾವು ಟೈರ್ಡ್ ಆಗ್ಬಿಟ್ಟು ವೇಟ್. ಈಗ ಪಾಸ್ ಓವರ್ ಕೇಳಿದ್ರು ಆಗ್ಲಿಲ್ಲ, ಮತ್ತೆ ಇನ್ನೊಂದು
ಇವಾಗ ಪಾಸ್ ಅವ್ರು ಕೇಳಿಲ್ಲ, ಬೆಳಗ್ಗೆ ಅವ್ರು ಇರ್ಲಿಲ್ಲ.
ಬಂದಿದ್ರು
ಇಲ್ಲ?
ಪಾಸ್
ಅವ್ರು ಇದ್ರ ಬೆಳಗ್ಗೆ ಲೇಡಿಯರು
ಲೇಡಿ.
Appellant counsel is absent. This is the appeal of the year 2018 and counsel for the respondent is present. List this matter on 22/7.
104 BF Kumbar, BS Prasanna Kumar.
ಶಾರ್ಟ್ ಅಕಾಮಿಡೇಶನ್ ಫುಲ್ ರೆಡಿ ಆಗ್ಲಿಲ್ಲ ಇದು.
ರೆಡಿ ಆಗ್ಲಿಲ್ಲ. ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್ ಏನಿರುತ್ತೆ ರೆಡಿ ಆಗೋದು?
ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಸ್ವಲ್ಪ ದಟ್ ದೇ ಡಿನೈಡ್ ದಿ ರಿಲೇಶನ್ಶಿಪ್ ಸ್ವಲ್ಪ ಎಸ್ಟಾಬ್ಲಿಷ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ.
Appellant counsel 6 time. Counsel for R124 is also absent, and if respondent counsel doesn't appear in the next date of hearing, appeal will be heard in his absence. List this matter on 22/7.
Okay.
107
ಕೆಲಸ ಎಲ್ಲಿ ನೋಡ್ರಿ ಇವತ್ತು? ಎಲ್ಲ ಬರೀ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್.
Also pass over, seniors held up in.
Counsel 107. Why you want to pass over?
My lord, senior is held up in Court Hall 3, my lord.
Total 3. ನೀವು ರೆಡಿ ಇದೀರಾ? ಕಮೆಂಟ್ಸ್ ಮಾಡಿ. ಅವ್ರು ಬಂದು ಜಾಯ್ನ್ ಆಗ್ಲಿ.
The suit, my lords, was in respect of two sites. I am, my lords, the purchaser of site number 1. And site number 2, my lords, is purchased by respondent number 1, my lords.
Respondent number 1. ಇವರಲ್ಲಿ ಕೆ ವಿ ನರಸಿಂಹನ್ ಆಫೀಸ್ನವ್ರು ಇದ್ರಲ್ರಿ ಬೆಳಗ್ಗೆ? ಇವಾಗಿದ್ರ ಇಲ್ಲೇ?
ಯಾವ್ದೋ ಒಂದು
You are appearing for R3 or
R3, my lord.
R3? You are also
Site number 1, my lords.
site number 1.
Site number 1 is purchased by me.
Is this Manjunath for R2 A to E?
My lords, he is not concerned, my lord, for their no right in life. But however, he was arrayed as a defendant, my lords, in the suit. Both the courts have held, my lords, that there is no right claimed by him, or he does not have any right over the suit share property.
He is only a formal party now.
He is only a party.
Yes, counsel.
My lords.
Then you commence your argument in the absence of your senior.
My lords, I feel it's better if my senior would appreciate.
Why you feel? Court feels that you are capable to address the argument.
My lords, just a short pass over, my lords. I'll get senior, my lords. Apologies, my lords. Since it's a second appeal.
Have you read the papers or not?
My lords, I'm in the process of reading it, my lords.
In the process. Which year you have enrolled?
My lords, 21, my lords.
21.
Yes, my lords.
3 years.
Yes, my lords.
ಆಯ್ತು, ಇನ್ನೊಂದ್ ದಿವಸ ಕೊಡೋಣವಾ? Any chance of coming?
My lords, I've sent my colleague to ascertain, my lords.
ನೋಡೋಣ, ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ. ಪಾಸ್ ಓವರ್.
108.
Yes, T. Prakash, K. Shivashankar.
Kindly pass on. Senior is on there.
Morning also you sought for pass over. Where is he now?
Coming, ma'am.
Coming. Then let him commence if he is coming.
It's 2.
Let him commence. Let your senior come and join. You makes the notes.
Yes.
Sorry.
Bandra. Lord, this is the.
ಸರಿ, ಅವ್ರು ಕಮೆಂಟ್ಸ್ ಮಾಡ್ಲಿ ನೀವು.
ಮಾಡ್ಲಿ.
This is
ಸುಧಾರಿಸ್ಕೊಳ್ಳಿ ನೀವು. 1197.
Yes, my lord. My lord, this is the defendant's
for partition.
Yes, my lord. This is the defendant's appeal, my lord. An application was filed by the defendant before the trial court under order 7 rule 11 for rejection of the plaint. My lord, that was considered and the plaint was rejected.
Plaint was rejected.
Subsequently, they have taken it on an appeal. The appellate court has reversed it. Yes. Against which I am before this court.
Yes.
Now, main question is, my lord, they have filed a suit for declaration and also seek a declaration to the effect that the sale deeds executed during 1997 and also 2004 to be set aside and also for partition and also to set aside the compromise decree that has been entered into between the brothers. The sisters have filed this suit for partition. The foremost submission is all this transaction, the sale deeds and the compromise decree was entered into prior to amendment of the Hindu Succession Act. So therefore, whatever the transaction that have taken place are saved. On that, primarily on that ground, the plaint was rejected.
Yeah, that is the substantive question of
Yes,
framed by this
that
court.
was the main question.
The trial court erred in restoring the suit when admittedly in the plaintiffs have admitted that social properties were bequeathed by their grandfather.
Yes, my lord.
In favor of first defendant.
Yes, my lord.
And his brother Krishnappa.
Yes, my lord.
And a registered will dated 18 to 1951.
Yes, my lord.
And after the death of testator, the legatees, namely first defendant and his brother Krishnappa, have entered into a compromise.
Yes, sir.
Twice number 532 of 93, and therefore the present petition is not maintainable.
Well, after entering into the, there was a registered will.
Compromise in RA.
Compromise in OS. Between the
OS,
two brothers,
OS.
between the two brothers, two brothers. That the compromise has happened much prior to the amendment. That is on 18/10/1995. After the compromise, some of the properties were sold by the brothers.
By the brothers,
brothers. Those sale deeds are also questioned by the sisters now,
by the sisters.
sisters.
Hmm.
So whatever the transaction that has taken place, much prior to amendment, that cannot be questioned.
Hmm.
That is the primary
But
ground. that
property originally belongs to
belongs to one Kottnuru Muniappa.
Kottanuru Muniyappa.
Yes, my lord.
Ah.
He has executed a will in favor of his grandsons, particularly sons of the sons.
Hmm.
He has excluded the daughters
Will.
in the will. That was in the year 1951, my lord.
1951 in favor of
Grandchildren.
grandchildren.
Yes. Thereafter, my lord, in the year 2000,
Kottanuru Muniyappa executed will 1951 in grandchildren. That is who are all?
that defendant Krishnappa's son and first defendant Naranappa's son, Naranappa's children, first defendant Gopalappa's son Naranappa, who is the first defendant, and his deceased brother Krishna.
How many children he was having Kottanuru Muniyappa?
My lord, altogether he had 5 children, my lord.
5 children.
Yes, my lord. Krishnappa,
None of them have questioned this will.
no, my lord.
No one
Nobody,
have questioned.
nobody
this
has
will.
questioned. Only in the year 2004, they have filed this suit.
That's not Kottanuru Muniyappa. Kottanuru Muniyappa had a son by name, that is the plaintiff's father. Father was alive as on the date of execution of the will. In respect of ancestral properties, Kottanuru Muniyappa had executed the sale deed during the lifetime of his son in favor of grandchildren and surviving children. That is the condition mentioned in the will. Not in respect of, the properties are not the absolute properties of Kottanuru Muniyappa. Specifically as mentioned in the will, in respect of ancestral properties during his life, during the lifetime of his son, he executed the will in favor of the grandchildren and the remaining, the male children. That is the condition has been mentioned. In the year 1995, when Krishnappa, that is the brother of the plaintiff, has filed the suit in respect of all the items, only 2 items have been left out. The compromise was entered. Just filed the compromise petition without disclosing the scheduled properties, survey numbers, nothing has been mentioned in the compromise petition. Decree has not been drawn. Just 1 item, there are totally minutes as on the date of filing of the suit in the year 1995.
Sir, let me
There are totally.
Even accepting that property is an ancestral property.
Yes, minute.
Whether the plaintiffs who have filed the suit, whether they are having a right?
They are having a right in respect of the property which was allotted to the share of Krishnappa, Millards Krishnappa without issues, he was died.
Krishnappa no issues.
Krishnappa has no issues. Millard, the Krishnappa, Millard, in the suit, Millard, as on the date of filing of the suit, Millard, there are totally 13 items. Compromise petition has been filed, Millard, without disclosing all the survey numbers. Just in the compromise, Millard, records have been come. Millard, kindly see the compromise petition, what the brother has filed and cheated the other brother. The Krishnappa who has filed this suit. Just he has mentioned, Millard, 1 item of the property belongs to Krishnappa. In the compromise petition, he has not mentioned the survey numbers, he has not mentioned the schedule. Just he has mentioned item number 2, 3, 4 belongs to this, the other defendant. Compromise was entered. No decree has been drawn. Last prior to Lordship's predecessor, directed them to produce the decree. Whether if the decree has been drawn, then absolutely the plaintiffs have no right. Decree has not been drawn. We have verified and got the earlier the records. Decree has not been drawn. Just compromise petition has been filed, recorded. Thereafter, the appellant herein has sold most of the items. In respect of 1 item of the property, whatever Krishnappa has been allotted, he has sold 1 property.
In terms of the compromise, there is no decree.
No decree. No decree has not been drawn. Just compromise petition has been filed. Then the defendant has taken, that is brother of Krishnappa, has taken all properties. 1 property has been given to the Krishnappa. So then subsequently in the year 1990, in the 1990, he died. Krishnappa died on.
Without my completion, he suddenly interfered and he wanted to say something. This is not correct. You have your opportunity, sir.
Yes,
Wait for
yes,
your turn.
Krishnappa died
Let him not mislead the facts.
Yes, yes.
1990.
Not mislead.
Grandchildren, Krishnappa's children.
Krishnappa
Krishnappa had no children.
But ಈ ಗ್ರ್ಯಾಂಡ್ ಚಿಲ್ಡ್ರನ್ ಯಾರ ಮಕ್ಕಳು ಹಾಗಾದ್ರೆ?
ಅದು
ಕೊತ್ನೂರು ಮುನಿಯಪ್ಪನಿಗೆ 5 ಜನ ಮಕ್ಕಳು.
ಕೊತ್ನೂರು ಮುನಿಯಪ್ಪನಿಗೆ
ಎಲ್ಲಿದೆ ಹೋಗ್ಲಿ?
ಒಂದ್ ನಿಮಿಷ ಸರ್.
ಚೀಟ್ರಿ ಹಾಕಿದಿರೇನ?
ಒಂದೇ ಒಂದು ನಿಮಿಷ. ಕೊತ್ನೂರು
ಚೀಟ್ರಿ ಇದೆಯಾ?
ಇದೆ. ಕೊತ್ನೂರು ಮುನಿಯಪ್ಪ had only one son by name ಗೋಪಾಲಪ್ಪ.
ಓನ್ಲಿ ಒನ್ ಸನ್?
Yes.
ಈಗೇನ 5 ಚಿಲ್ಡ್ರನ್?
ಅದು ಏನಾಯ್ತು, ಅವ್ರ ಮಕ್ಕಳುಗಳು ನಾನು ಹೇಳಕ್ ಹೋದೆ. He was not mentally sound, therefore he has executed a will in favor of the grandchildren. I'm sorry, I will stand correct.
ಓನ್ಲಿ ಒನ್ ಸನ್?
Yes, my lord.
ಕೊತ್ತನೂರು ಮುನಿಯಪ್ಪ.
Yes, he had only one son by name Gopalappa.
ಗೋಪಾಲಪ್ಪ.
He was not mentally sound, and therefore he has executed a registered will in favor of Krishnappa and Narayanappa.
Krishnappa, Narayanappa are the sons of this Gopalappa.
Yes, my lord. Yes, my lord.
Hmm.
And so also the Gopalappa had 3 other the female children.
Female,
Jayalakshmamma.
Gopalappa.
Yes, my lord. Jayalakshmamma she is dead, no issues. Muniyamma and Akkayamma, they are the plaintiffs before the court.
Oh, these 2 plaintiffs are also the daughters of Gopalappa.
Gopalappa, please. Sisters have filed a suit against the brothers. In a nutshell. My question is, my lord, this will was
Earlier suit of the year in which between the earlier suit in favor of Krishna, between the Krishnappa and Narayanappa?
Yes, that is 352 of 1993.
Wherein compromise?
That was ended in compromise 20-10-1995. A compromise petition was filed before the court.
10-1995.
Yes, my lord. Compromise petition was filed before the court, and the court has accepted the compromise petition and directed the office to draw the decree. Though the decree was not drawn, but that compromise, whatever the order that has been passed by the court, that could be seen in the order sheet itself. My lord, it is clearly says that the compromise petition has been accepted. Case advanced. I am satisfied with the compromise petition, and compromise petition is accepted, and to draw the decree accordingly. That is the order that has been passed by the court. On the basis of the said judgment, the kata was affected too. Mutation entry was also affected too. And in the mutation clearly mentioned, as per the judgment, the revenue records have also been changed. In the year 1995 itself, 95 itself, and subsequently some of the properties were sold. But all these years, they kept quiet. They did not question it. Now only in the year 2004, they have questioned it. 2008.
Well, when there was already a will in favor of Krishnappa and Narayanappa.
Yes, my lord.
By the Kottanuru Muniyappa.
Yes, my lord.
What made them to file a suit inter-se between them?
In order to make a partition between them, because in the will, all the properties were given jointly to them. Therefore, they had a partition in between.
Joint.
Yes.
Jointly given all the properties.
Yes.
Among them.
Yes.
Them the suit is
Yes,
filed.
they wanted to partition among
Partition.
Now, my lord, by virtue of though the decree is not drawn, but still the judgment is there. On the basis of the judgment, mutation entry has been affected too. All the revenue records have also been changed. Just because decree is not drawn, it cannot be said that the Amendment Act cannot be applied to the present facts of the case. My submission to Your Honor is, Your Lordship is, the amendment is of the year 2012-2004. All these transactions have taken place much prior to it. Will is of the year 1990, will is of the year 1951. Compromise decree is of the year 2005. And the sale deed, the compromise is of the year.
Compromise 1995.
93, madam, 93.
95.
95 was decreed, 95.
95.
Yes, 2010-1995, more specifically. And the sale deed is of the year 1997, executed by Krishnappa. And one more sale deed executed by.
Sale deed of the year?
1987, sir.
1997.
97. Yes, please. And another sale deed executed by this B.G. Narayanappa in the year 25/11/2004. 25/11/2004.
By Narayanappa?
Yes, depend number 1, my lord. Pertaining to one portion of the property. All these three under question. Compromise decree is under question, will is under question, sale deeds are under question. All these transactions much prior to the amendment. So in order, that is the reason why the trial court has accepted that in view of the amendment, all the transactions are saved, therefore you cannot file a suit for partition. Another important aspect is, my lord, this compromise decree, how can you file a separate suit? There is a bar under order 24.
23 rule 2A.
Yes, there is a bar. You cannot file a separate suit questioning the compromise decree.
Recently, I held, if they are not the parties, if they are the third parties, they can question by an independent suit.
Then I will not press that point. If you lordship have already held, then I will not question. My lord, this they cannot overtake, my lord. So far as the will is concerned, even if I ignore that will, I rely upon the partition deed. That is interest between the brothers. Now sisters have no right to question that in view of the amendment. All the transactions much prior to the amendment are saved.
That's all.
That's my submission.
Yes, counsel.
And one more aspect is, my lord, Vinita Sharma's case, wherein it says, even if it is a oral partition, if that oral partition is affected to by virtue of the revenue entries, then that could be considered.
Yes.
My lord, may I just pass it on that?
Yes, yes, you can hand over.
Yes. Relevant page is 120, my lord.
Mark ಮಾಡ್ಬಿಟ್ಟು ಕೊಡಿ. I read that judgment. Whatever you are relying upon, you mark it.
Yes. Page number.
ಕೊಟ್ಬಿಡಿ ಅವರಿಗೆ mark ಮಾಡೋದು.
Yes.
ಕೊಡ್ಲಿ ಅವ್ರು ಯಾವ್ದು. Already I have read several occasions. You can also highlight it.
Madam, I will mark. 120 Roman 5.
Right.
Roman 5. In view of the rigor provisions of explanation to section 6.5 of the
That
Act.
is the question, substantive question of law framed by this court also.
Yes, my lord. A plea of the oral partition cannot be accepted.
However, in exceptional cases where plea of oral partition is supported by public documents.
Yes, my lord.
According to you, oral partition, after the partition also.
Not oral partition.
They have sold the properties.
Not oral partition.
Already a partition.
Yes, by the court compromise.
And then they have also sold the some of the properties.
Yes,
also.
and the revenue public documents have already been entered into by virtue of the judgment.
Yes.
It is a court judgment that has been passed.
Yes.
Though the decree is not run, still the judgment is there. On the basis of the court judgment, all the imitation entries are affected too. Therefore, by virtue of this, Vinita Sharma's case will also come to my rescue.
Yes.
That my learned friend's argument that decree is not run, therefore that cannot be applied, that cannot be considered in this particular case because it's a court judgment, my lord. On the basis of the judgment, revenue records are entered.
Yes, let him argue.
Yes,
He can give reply.
yes.
Plaintiffs filed the suit for partition and separate possession. They are claiming,
According to you.
they are the sisters of.
Kottanuru Muniyappa.
Yes, Milord. Kottanuru Muniyappa had a son by name Gopalappa. Gopalappa had
Adalla.
family tree lordship, there is no dispute.
Now your argument is Kottanuru Muniyappa was not having any absolute
Right to execute the will.
execute the will.
Yes.
That is first argument.
That is first submission. Let's read, let's lordship may kindly take up that will is very important. Because all the properties have been bequeathed by the Kottanuru Muniyappa.
Kottanuru Muniyappanige idu ancestral property anta ಏನಾದ್ರು ತೋರ್ಸಕ್ಕೆ ಏನಾದ್ರು ದಾಖಲೆ ಇದೆಯಾ?
Yes, even in the will itself he has written.
Will
Yes, trial court records minutes before this court.
ನೋಡ ಫಸ್ಟ್ ಪಾಯಿಂಟ್ ಹೇಳಿ.
Yes, may I read one sentence in the bill? Minutes the since
ಕೊಡಿ ಮೇಡಮ್.
bill it's
Will itself says
ಮರಣ ಶಾಸನದಾಗಿದೆ ನನಗೆ
ancestral property exhibit ಎಷ್ಟು ಅಂತ ಹೇಳಿ.
ಇನ್ನು ಮಾರ್ಕ್ ಆಗಿಲ್ಲ. We have produced before the trial court at the stage of evidence.
Evidence is not commenced.
ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ, the stage of evidence, after 10 years they filed the application to.
ಇದು ಅಪ್ಲಿಕೇಶನ್ ಅಂಡರ್ ಆರ್ಡರ್
11 to 11.
ಆಯ್ತು ಆಯ್ತು.
Here 16 minutes, 2016 they filed the application. 2008 suit came to be filed. But in the year 2016 they filed the application. So the will
suit in the year 2008.
8 minutes. 2016 they filed the application under order 711 to reject the plaintiff contended minutes various kind. Let's kindly see the will executed by this Kottanuru Muniyappa. May I read? Other document. There. First document. After immediately after the genealogical tree. second line onwards, notes. Kottnuru Gopalappanavar Muniyappanada Nanu, it's married, second line. Muniyappanada Nanu.
ಟೈಪ್ಡ್ ಕಾಪಿ ಇಲ್ವಾ? ಆಯ್ತು ಬರಲ್ಲ.
Please. ಮುನಿಯಪ್ಪನಾದ ನಾನು ಬರೆಸಿ ಇಡಲ್ಪಟ್ಟ ವಿಲ್ಯು ಮರಣಶಾಸನ ಅದಾಗಿ ನನಗೆ 60-70 ವರ್ಷ ವಯಸ್ಸಾಗಿರುವ ವೃದ್ಧಾಪದ ದಶೆಯಿಂದ ಮತ್ತು ದೇಹವು ಶಾಶ್ವತವಲ್ಲದರಿಂದ ಸಹ ಈಗಲೇ ನನಗೆ ಜ್ಞಾನ ಚೆನ್ನಾಗಿರುವಾಗಲೇ ಒಂದೇ ಸ್ಥಿರ ಮನಸ್ಸಿನಿಂದಲೂ ಆತ್ಮಸಂತೋಷದಿಂದಲೂ ಸಹ ನನ್ನ ಪಿತ್ರಾರ್ಜಿತವಾದ ಮತ್ತು ಸ್ವಯಾರ್ಜಿತವಾದ ಚರಸ್ಥಿರ ಸ್ವತ್ತುಗಳನ್ನು ಯಾವತ್ತೂ ಸಹ ಈ ದಿನ ಈ ಕೆಳಗೆ ಶೆಡ್ಯೂಲ್ ನಮೂದಿಸಿರುವ ಸ್ವತ್ತುಗಳನ್ನು ಪೂರ್ತ ನನ್ನ ಮಗ ಗೋಪಾಲಪ್ಪನಿಗೆ ಬುದ್ಧಿ ಸ್ವಾಧೀನವಿಲ್ಲದೆ ಚಪಲವಿರುವುದರಿಂದ ಈ ನನ್ನ ಮಗನ ಮಕ್ಕಳು ಆಲಿ 1ನೇ ಕೃಷ್ಣ.
ಬುದ್ಧಿ ಸ್ವಾಧೀನ ಇಲ್ಲ ಅಂದ್ರೆ ಚಪಲ ಹೆಂಗ್ ಬರ್ತದೆ?
ಅಂದ್ರೆ ಅದೊಂಥರ ಜ್ಞಾನ ಸರಿ ಇಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಒಂದು ವರ್ಡ್ ಎಕ್ಸ್ಟ್ರಾ. ಕೃಷ್ಣಪ್ಪ 2ನೇ ನಾರಾಯಣಪ್ಪ ಮತ್ತು ಮುಂದೆ ಆಗಬಹುದಾದ. ಫಾರ್ಚುನೇಟ್ಲಿ ಫಿಮೇಲ್ ಡಾಟರ್ ಚೈಲ್ಡ್ಸ್ ಹ್ಯಾವ್ ಬಾರ್ನ್, ನಾಟ್ ದಟ್ ಮೇಲ್. ಮುಂದೆ ಆಗಬಹುದಾದ ಇತರ ಗಂಡು ಮಕ್ಕಳಿಗೆ ಇತರ ಗಂಡು ಮಕ್ಕಳಿಗೂ ಸಹ ಸುಮಾರು
ಆಗಬಹುದಾದ ಇತರ ಗಂಡು
ಮಕ್ಕಳಿಗೂ ಸಹ ಸುಮಾರು 1,000
ಇನ್ನೂ ಆಸೆ ಇಟ್ಕೊಂಡಿರ್ತಾನೆ.
ಅಲ್ಲ ಇವರು ಗೋಪಾಲಪ್ಪನ ಮಕ್ಕಳಿಗೆ ಇವರು ಬರ್ದಿರೋದು ತಾತ ಅಲ್ಲ ಅವ್ರಿಬ್ರಿಗೆ. ಈ ಗೋಪಾಲಪ್ಪನ್ಗೆ ಇನ್ನ ಮಕ್ಳಾಗ್ಬೋದು ಗಂಡು ಮಕ್ಳು ಅಂತ ಹೇಳಿ ಇದ್ರಲ್ಲಿ ಇಂಟೆನ್ಷನಲಿ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್ ವಿಲ್ ಬಿಕಾಸ್ ಗೋಪಾಲಪ್ಪ ಮೈಂಡ್
ಮೇಜಸ್ಟ್ ಸ್ಟ್ಯಾಂಡ್ ಕರೆಕ್ಟ್ ಮಿಲಡ್. He refers to the children of these Krishnappa and Naranappa. He doesn't say that his ಮಕ್ಕಳು
ಗೋಪಾಲಪ್ಪನ ಮಕ್ಕಳಲ್ಲ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇವರಿಬ್ಬರು ಮಕ್ಕಳಿಗೆ
ಮಕ್ಕಳು ಆತರ ಬರ್ದಿಲ್ಲ ಸ್ವಾಮಿ. ನಾರಾಯಣ್ ಅಲ್ಲ, ಇಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ವರ್ಡ್ಸ್
ನಾರಾಯಣಪ್ಪ
ಮತ್ತು ಮುಂದೆ ಆಗಬಹುದಾದ ಇತರೆ ಗಂಡು ಮಕ್ಕಳಿಗೆ
ಇತರ
ಗಂಡು ಮಕ್ಕಳಿಗೆ
ಅಲ್ಲ, ಅಲ್ಲಿ ಹೇಳ್ತಾ ಇರೋದು
ನಾರಾಯಣಪ್ಪ ಕೃಷ್ಣಪ್ಪನ ಮಕ್ಕಳಿಗೆ ಅಂತ ಏನ್ ಬರ್ದಿಲ್ಲ ಅಲ್ಲಿ.
ಈ ನನ್ನ ಮಗ ಇಲ್ಲ, ಅಲ್ಲೋಡಿ ಸ್ವಾಮಿ, ಈ ನನ್ನ ಮಗನ ಮಕ್ಕಳಿಗೆ ಹಾಲು ಇರುವ 1ನೇ ಕೃಷ್ಣಪ್ಪ, 2ನೇ ನಾರಾಯಣಪ್ಪ ಮತ್ತು ಮುಂದೆ ಆಗಬಹುದಾದ ಇತರ ಗಂಡು ಮಕ್ಕಳಿಗೆ ಅಂತ ಹೇಳ್ಬಿಟ್ರು.
ಅಲ್ಲಿ 51ರಲ್ಲಿ ನಾರಾಯಣಪ್ಪ ಇಸ್ ಏಜ್ ಅಬೌಟ್ 1,500 ರೂಪಾಯಿ ಬೆಲೆ ಬಾಳದ ಅಂದಾಜು ಬೆಲೆ ಬಾಳತಕ್ಕಂತ ಸೇರತಕ್ಕಂತ ಇತರ ನನ್ನ ಅಣ್ಣ ತಮ್ಮಂದಿರಿಗೂ ಆಗಲಿ ಮತ್ತು ಇತರ ಜ್ಞಾನ ಆಗಲಿ
ಯಾವ್ದು ಸ್ವಯಾರ್ಜಿತ ಯಾವ್ದು ಪಿತ್ರಾರ್ಜಿತ ಅಂತ ಹೇಳಿ
ಇಲ್ಲ.
ಪಿತ್ರಾರ್ಜಿತವಾದ
ಸ್ವಯಾರ್ಜಿತ ಹೌದು. But some properties of
any material that some properties are his self-acquired property.
No documents, but all properties have been acquired by Kottnur Muniyappa and some properties have been jointly Swayarjita ಅಂತ ಹೇಳ್ತಾರೆ, but there are no documents. There are no sale deeds. Swayarjita document ಇಲ್ಲ, ಏನು ಇಲ್ಲ.
ಎರಡು ಪದ ಬಳಸ್ಬಿಟ್ಟಿದ್ದಾರೆ,
ಪ್ರಯಾರ್ಜಿತವಾದ ಮತ್ತು ಪಿತ್ರಾರ್ಜಿತ ಮತ್ತು ಸ್ವಯಾರ್ಜಿತ ಅಂತ. But there are no.
ಎರಡು ಇದೆ, ನಾನು ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಯಾವ್ದಾರು ಸ್ವಯಾರ್ಜಿತ ಯಾವ್ದಾರು ಆನ್ಸೆಸ್ಟ್ರಲ್ ಇದೆಯಾ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಯಾಕೆಂದ್ರೆ ಸ್ವಯಾರ್ಜಿತಕ್ಕೆ ಲಾ ಬೇರೆ ಅಪ್ಲೈ ಆಗ್ತದೆ, ಪಿತ್ರಾರ್ಜಿತಕ್ಕೆನೆ ಸೆಕ್ಷನ್ 6 ಸೆಕ್ಷನ್ 8 ಬರುತ್ತೆ. ಅದಕ್ಕೆ
my submission is if this will is also ignored, I am relying upon the partition deed itself.
But some properties are mentioned in the will. So totally whatever the scheduled properties have been mentioned in the will. Subsequently, the Krishnappa has filed the suit for partition. Same adralle
that is suit by Krishnappa
adralle ide records notes 352/1993. 352 of 1993. Krishnappa has filed the suit for partition and separate possession against his brother Narayanappa, but he has contended that he has not effected the partition and he is entitled for half share in the specific the contentions has been taken in the plaint and filed the suit in the year 1993. And he has mentioned, kindly see lordship, the schedules totally. 13 schedules he has mentioned in the plaint. 13th schedule is concerned 3 acres 16 guttas of land. That is the item number 1 of the schedule, but no survey number has been mentioned in the plaint.
Item number
13. That's in the old plaint.
13 schedule.
13 schedule, and also some movable properties also, but immovable properties are concerned totally.
Item number 13.
Item number 13. There is no survey number has been mentioned.
No survey number.
No survey number. 3 acres 16 guntas of land.
But 3 acres
16 guntas of land purchased by grandfather of the plaintiff and defendant from so and so, but no document. But survey number has not been mentioned. Not in the compromise petition, next document. the trial court records, my lords, this is very important. 23 Rule 3, my lords, all the schedules have been mentioned, specific boundaries have been mentioned in the plaint. In the compromise petition, my lords, at the intervention of elders and well-wishers, both the parties, they have settled their disputes regarding partition of the plaintiff's plaint A scheduled properties as under the compromise petition mentioned. Out of 13 items, my lord, Krishnappa is entitled for half share in respect of suit properties are concerned. 285/1 so and so measuring to an extent of 2 acres 9 guntas, including 2 guntas of put karab, and shall be the absolute owner of the said land with absolute rights to and so alienate in same in any manner he likes. Plaintiff has been put in perpetual possession of the said land, and the defendant shall not claim any manner of right, title, or interest in the said land henceforth. Next, plaintiff being a bachelor is permitted to reside and he is in possession of item number 1 of the plaintiff during his lifetime, and after his death, the said property shall absolutely belong to the defendant. The plaintiff shall not alienate the said property in any manner in favor of anyone during his lifetime. The only right to which the plaintiff shall be entitled in respect of item number 1 of plaintiff scheduled property, right of residence and nothing else. Then, my lord, next paragraph onwards, he has not mentioned survey numbers, schedules in the compromise petition. Defendant is given item number 2 to 10 and 12 to 13 of the plaintiff scheduled properties towards his share. Defendant shall be the absolute owner of said properties with absolute right to all, alienate all or any of the said properties in favor of any person or his choice. Defendant shall not be the absolute owner of item number 1 of the plaintiff schedule A, subject to right of residence of plaintiff as aforesaid. Defendant put in possession of item number 2 to 10 and 12 to 13 of the plaintiff scheduled property, and the plaintiff shall not have any manner of right, title, and interest in the said properties. Henceforth, the parties agree that items of the properties mentioned in the B schedule, C schedule, E does not exist. Properties agree that the present market value so and so equal to the market value so and so. Then parties hereby agree that the lands at item number 9 given to the share of the defendant who has agreed to take them towards his share subject to the result of the suit in OS number 85/19 on the file of the municip so and so. The parties so and so agreed above suit be decreed in terms of this compromise, directing each party to bear his own cost so and so. Decree emulates the compromise petition has been filed on 18/10/1995. No decree has been drawn. Then millards only compromise petition, just blind compromise petition has been filed. All the properties as taken by the defendant without millards giving even right to the defendant, the Krishnappa is concerned. Then subsequent
only the right of residence.
Yes, in respect of item number 1. Yes.
And
Millard,
Millard,
next document.
let him not mislead, Millard. One more property is given.
One more property,
One more property. That is item number 1, portion of the property.
That's what millards mentioned in the compromise petition. That is
be clear in the facts.
Sir, clear, this is there in the what is the meaning of misguiding?
It's the only right to which the plaintiff shall be entitled in respect of item number 1 of plaintiff scheduled property is right of residence and nothing else antide.
No, my lord. There is also one more property. The plaintiff
really the compromise.
Compromise petition ನೋಡಿ ಸ್ವಾಮಿ. Tara ಏನಲ್ಲಿ?
Tara ಏನ?
First page.
The plaintiff is allotted item number 11.
11 plaintiff scheduled property towards his share 285/1. That is a major property, 2 acre 9 guntas.
Including 2 guntas.
Let him not
Sir, ದಯವಿಟ್ಟು ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು. Absolute owner of the said land with absolute rights.
Item number 11 and item number 1. Item number 1 ಅಲ್ಲಿ right of residence. Item number 11 ಅಲ್ಲಿ 2 acres 9 guntas.
Continuation ಅಲ್ಲಿ the plaintiff has been put in separate possession of the said land, and the defendant shall not claim any manner of right, title, or interest in the said land henceforth. Plaintiff, so next paragraph, being the bachelor is permitted to reside to be in possession of item number 1 of the plaintiff scheduled property during his lifetime, and after his death, the said property shall be so and so absolute. Then, after the compromise petition has been filed, one of the property has been sold by Krishnappa on 4/12/1996.
On the basis of that, judgment is passed. You read that also.
Sir, one simple is sir, but let me complete first. Unnecessary. Why you are interfering, sir? I can't understand.
You can give reply, ಅಷ್ಟೇ.
ಅರ್ಧರ್ಧ ಮಾಡ್ಬಿಟ್ಟು ಮುಂದಕ್ಕೆ
ಅರ್ಧರ್ಧಲ್ಲ, sir.
Judgment, regarding judgment also he has to say. There is also a judgment on.
What judgment, sir?
On the basis of the compromise petition.
ಎಲ್ಲಿದೆ judgment?
ದಯವಿಟ್ಟು ನೋಡಿ. ಸ್ವಾಮಿ ದಯವಿಟ್ಟು
ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್
ಕಾಂಪ್ರಮೈಸ್ ಪೆಟಿಷನ್ ಹಾಕಿದ ತಕ್ಷಣ ಆರ್ಡರ್ ಶೀಟ್ ಸ್ವಾಮಿ
ಮೇಲೆ ಒಂದು ಆರ್ಡರ್ ಬರ್ತಿದ್ದೀರಾ?
ಹೌದೌದು. there is a judgment.
ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ
ಅದು ಒಂದ್ ನಿಮಿಷ ಸಾಹೇಬ್ರು ನೋಡಿ ಸ್ವಾಮಿ.
ಅಡ್ವೊಕೇಟ್
ಕೇಸ್ ಅಡ್ವಾನ್ಸ್ ಇಲ್ಲಿ ನೋಡಿ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ ಅದು? Page number?
Page number 20-1095 order sheet, Swami. OS 352 of 93.
OS?
352 of 1993.
ಅದರಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಇಲ್ಲ.
ಇನ್ನೊಂದು record ಇದೆ madam.
ಕೊಟ್ಟಿದ್ದೀನಿ. ಇನ್ನೊಂದು ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಚೆನ್ನಾಗಿ.
OS?
OS
Same
352 of
that suit
1993.
filed by Krishnappa.
OS,
House
order sheet.
352. ಅದರಲ್ಲಿ
2010-1995.
1995.
Twenty ten 95.
Awesome.
Case advance.
Case advanced and prayed in IA number 2, both the parties and defendant counsel are present. Plaintiff submitted that the parties, the
The presence
of his counsel
is
and
necessary.
not necessary for her to
Him to
enter into
compromise.
compromise. Both the parties filed the joint compromise petition under order 22 rules of CPC. And the contents of the compromise petition was read over to the parties. Both the parties admit the terms of the compromise and submit that have put their signature to the compromise petition heard on my
Verification.
verification
of the
of the parties. I have come to the conclusion that both the parties have entered into the compromise knowing fully well the terms and conditions. Hence, I pass the following order. The suit is hereby decreed in terms of the compromise. Draw a final decree regarding half of the court fee to the plaintiff.
And signatures of the
That draw a final decree.
Hmm.
Draw a final decree and
the
refund of the court fee to so and so.
signatures
Let's
of the-
next advocate for defendant filed an application so and so prays to direct the office to draw the final decree. Adadmele, that's on 14/1/2019.
signatures of the parties have also been taken.
Next continuation ಅಲ್ಲಿ, let's advocate for defendant file the application under 150 on CPC and affidavit prays to direct the office to draw the final decree as per the terms of the compromise dated 2011 in accepting the stamp so and so, but no decree has been drawn. For orders ಅಂತ ಹೋಯ್ತು, decree has not been drawn. The compromise petition has been filed. That too, my lords, this application has been filed. My lord, on 14/1/2019, after filing of the suit by the plaintiffs, he has the knowledge that the decree has not been drawn. Immediately, my lords, on 14/1/2019, this application has been filed. 14/1/19. 14/1/2019.
By ಯಾರ್ ನಾರಾಯಣಪ್ಪನ?
Yes, my lords, dependent.
ಈ ಕೃಷ್ಣಪ್ಪ ತೀರ್ಕೊಂಡಿದ್ದು ಯಾವಾಗ?
1998, my lords.
98.
1998. One to 1998. But sale deed I have produced.
ಕೃಷ್ಣಪ್ಪ ಏನ ಸೇಲ್ ಮಾಡದ ಅಂದ್ರಲ್ಲ, ಅದು ಯಾವ ಪ್ರಾಪರ್ಟಿ? ಅದು ಐಟಮ್
That is 285/1, one property.
Item number 11.
11. Adralli, let's, the witness is the defendant.
The entire sale?
Entire, the property has been sold.
That's incorrect. Portion of the property has been sold by.
Sorry, 2 acres, 9 guntas, out of flats, 35 guntas, sorry, 35 guntas.
Milord, remaining portion has been sold by us.
Sold?
Sold by us. That is
by
BG
you.
Naranappa.
Sold by you
Yes,
after
BG Naranappa.
after his death.
Yes, Milord.
After his death.
After his death. And
Then
yes,
subsequently,
and-
my lords,
sir,
after filing of the suit, my lords, the purchasers
Sir.
have entered into the compromise. We have executed, my lords, confirmation deed and we have compromised the matter insofar as whatever the property sold by Narayanappa is concerned.
Milord, they have
My
executed
lord,
a
the sale
confirmation
deed,
deed.
one second, sir, let
Let
me
me
first
clarify.
complete this.
Let me clarify, Milord. After we execute the portion of the sale deed, for the portion of the property, they have executed a confirmation deed in favor of the purchaser, agreeing
In respect of this
portion of the
portion of
property.
the item of
which
the
has been
property
sold by different number
sold
one.
by Narayanappa.
Narayan.
Yes, Milord.
That is in
that I
respect
have
of
produced that I have produced a confirmation deed.
Item number 11 ಗೆ.
11, 285/1, let's, the purchasers have come forward for settlement after filing up the suit by the plaintiffs. We have executed the confirmation deed, let's, only in respect of the property sold by Narayanappa. My lord, in so far as sale deed executed by Krishnappa is concerned on 4/12/1997, Narayanappa is the witness to the document.
ಕೃಷ್ಣಪ್ಪ ಮಾರಾಟ ಮಾಡಿದ್ ಬರೀ 35 ಗುಂಟೆನಾ?
35 ಗುಂಟೆ. ಅದರಲ್ಲಿ Narayanappa is one of the witness. Out of 2 acres, 9 guntas of land. 2 acres, 9 guntas of land.
ಆಯ್ತು.
Then, my lord, subsequently, the Narayanappa has sold some items. And I have produced, my lord, the remutation register extract, my lord, along with the plain, not on the basis of compromise petition, my lord, the kata has been affected. My lord, kindly, along with the trial court records, in respect of survey number 19/5, and in respect of survey number 27/1, kata has been transferred in favor of Narayanappa through inheritance on 2/11/2006.
Two?
2/11/2006. Lord, in respect of survey number 50/1. That is, my lord, item number 13 in the old plain. Earlier, kata was stood in the name of Muniappa, son of Gopalappa. Survey number that is 50/1 to the extent of 3 acres, 32 guntas of land. Through inheritance, kata has been transferred in favor of Narayanappa on 3/12/2003. And my lord, the survey number 19/5 is concerned. This property was not included in the earlier plaint. Earlier plaint. Filed by the Krishnappa in YS number. Compromise. Suit alle irlilla adu.
Which survey number?
19/5, 8 guntas of land. Last occasion I have.
Which item, sir? Survey number is, sir.
19/5, 8 guntas of land jointly stands in the name of Krishnappa and Gopalappa.
Last item,
19/5.
What is the extent?
8 guntas of land.
Plastic.
And insofar as 3 acres ad is concerned, survey number 50/1, 3 acres 16 guntas. In the old plaint, there is no mentioning of survey number.
Survey number mention ಮಾಡಿಲ್ಲ, but extent mention
Extent mention ಮಾಡಿದ್ದಾರೆ. But what is that extent ಅನ್ನೋದಕ್ಕೂ
May I clarify?
3 acre 22 guntas.
16 guntas.
My lord, may I clarify that portion right now, my lord? That is the very same property which has been shown by him in his plaint. As item number 1.
Yes.
Though the survey number is not mentioned, the description, schedule, everything tallies. That is shown in the will.
That is sold by whom?
That,
Krishnappa.
no, that is not sold. That is intact.
Sale ಆಗಿಲ್ಲ.
Sale ಆಗಿಲ್ಲ. Still it is there, my lords.
My lord, so far as the
Now
description
question
concerned,
is-
so far the description is concerned, my lord, it is shown in the will, so also the compromise petition, and so also in his plaint.
Lord,
Only
all
survey
the
number is not
properties, Lord, whatever the properties shown in the earlier plaint, we are not the parties to the earlier suit is concerned. Properties, my lords, admittedly ancestral and self-acquired property, that is the description has been shown, mentioned in the will. Lord, the burden is on the plaintiff to establish, my lords, it's a matter of trial whether the properties are, which properties are ancestral properties, which properties are self-acquired properties. Some properties have been left out and, my lords, the Narayanappa has taken the entire properties. Now, all these questions have to be adjudicated during the course of trial. Now, merely because of few proper compromise petition has been filed without, my lords, drawing the decree and the properties blindly mentioned with regard to just, my lords, item number 1 and 2 in the compromise petition. All the properties have taken by Narayanappa, that too, my lords, it is not the self-acquired properties of Narayanappa. Merely on the basis of the vague compromise petition, now he is claiming right over the property. That too, my lords, the decree has not been drawn. Now, my lords, the question is, all these questions are concerned with regard to ancestral, self-acquired, with regard to execution of the will is concerned, that is the prayer we have sought in the plaint. In order to adjudicate all these, my lords, tribal issues, the opportunity has to be given to the plaintiffs to prove their possession over the right over the properties, whether the plaintiffs are entitled for partition or not. Therefore, my lords, the order 7/11 is concerned, my lords, only the court has to look into the plaint governments, not the defense taken by the written statements. Lordship, number of judgments on this point is concerned. Therefore, my lords, at this stage, 7/11 is not applicable. My lords, the appellate court has rightly considered, my lords, its properties are ancestral properties. Therefore, it has to be proved during the course of trial Therefore, that's the trial court merely on the basis of the compromise was recorded in, and before the cutoff date is 2012-2004. That cannot be considered. It has to be, opportunity has to be given to the plaintiffs. That is the finding of the appellate court. Well, let's kindly the paragraph 16 of the appellate court judgment. Paragraph 16 of the appellate court judgment. Plaintiff has claimed that the suit-schedule properties, the remaining minutes prior to paragraphs 7 to 11 has been extracted, and that's the relevant starts from page para 16. Plaintiff has claimed that the suit-schedule properties are their ancestral properties of the will executed by their grandfather late Kwatnur Muniappa dated 18 to 1951. In respect of ancestral properties as invalid in the IF
15 or 16 either.
16 in the relevant. 18 to 1951 in respect of ancestral properties as invalid in the IF law, and it would not derive any right and title in favor of defendant number 1 and his brother deceased Krishnappa. Plaintiff has also sought for a declaration to declare that the compromise decree dated 18/10/1995 entered into between defendant number 1 and his brother deceased Krishnappa as null and void are not binding on the plaintiff's share, and to declare the sale deeds executed by them in favor of defendant number 2 to 4 as void are not binding on their right. Therefore, it is manifestly clear that the plaintiff has sought for multiple reliefs in the suit. Learned trial judge and rejecting the plaintiff has held that since the will, compromise decree and other sale deeds have been executed much prior to the Hindu Succession Act 2005, plaintiffs cannot question the legality of such a transaction since there is a clear bar under section 6 of the Hindu Succession Act 2005. Plaintiff has questioned the legality of the will dated 18 to 1951, though which grandfather had bequeathed the ancestral property in favor of his grandson, that too during the lifetime of his son, the father of the plaintiffs, who is a co-parsoner. Therefore, the first issue which required to be adjudicated by the trial court is the legality and validity of the will dated 18 to 1951, though which is the defendant number 1 and his brother Krishna but derived title over the suit-schedule property. In other words, the question of validity and legality of the will executed by the grandfather of the plaintiff in respect of ancestral property should be decided first, and immunity or vulnerability of all other events followed that will, including the compromise decree, arrived between defendant number 1 and his brother and subsequent sale transaction would depends upon the findings on that issue, which in my view the trial court has erroneously ignored while rejecting the plaintiff. Admittedly, there is no dispute in proviso to section 6 class 1 of the Hindu Succession Act 2005 provides that nothing contending this subsection shall affect or invalidate any disposition or alienation, including any partition or testamentary disposition for property which have taken place before 2012-2004. It does not mean that the transaction which per se illegal or invalid under the law is also excluded from questioning under the proviso. It is impermissible to take a plea that even if such transaction is invalid or against to the settled position of law, that cannot be questioned before any court of law if such transactions have been taken place before 2012. It is stated that mere fact that the plaintiffs may not succeed would not be a ground for rejecting the plaintiff. Apart from that, it is worthwhile to note that the brother of the plaintiff, late Krishnappa, had died as a bachelor and intestate, leaving behind his property, which according to Hindu Succession Act, to be divided among the reversioners. The learned trial judge has blindly ignored the fact also while rejecting the plaintiff. Learned counsel for the respondent has placed reliance on the decision of the Honorable High Court so-and-so, wherein the High Court so-and-so justified rejection of plaintiff on the ground that the suit is barred under section 6 of the Hindu section. Since the partition was effected in the joint family through a registered instrument, which prior to amendment section 6 of the Hindu Section Act 2000, therefore held such partition takes place before 2012, is saved. So absolutely, there is no dispute. If the plaintiffs have admitted the partition in the joint family property much prior to Amendment Act 2000, through a registered dated, in such event, the trial court can reject. In the instant case, the fact is entirely different and the plaintiff has filed a comprehensive suit for declaration and partition. Therefore, the above decision cannot be applied to the facts. Therefore, said reasons and discussions, I am doing that since there are several tribal issues involved in the suit, and when the plaintiff claimed that the suit-schedule property has their ancestral property and ignorance about the compromise decree, even it cannot be said that the suit is barred by time and all other matters involved in the dispute being question of facts required to be proved by the parties in the trial by leading evidence. Therefore, my consideration that the learned chair so-and-so access 7 to 11 is not rejected while rejecting the plaintiff. So and so. That's the matter has been remanded to the trial court.
Yes, my lord, by way of reply, my lord. My lord, so far as item number 13 is concerned, my lord, that is the only property which was not included in the will or in the.
Not included in the will.
Not included.
Item number 13 was not
Not
included.
included. That was the only property. So if at all, if any decision has to be taken, only with regard to item number 13, the trial has to take place.
Even in
Not-
respect of.
Not in respect of item number 1 to 12. All 1 to 12 are included in the will, included in the partition deed, and so also included in the suit. Only the last item is not included, it was not included. Except that,
It is not included in the will and also it is not included in the suit also. Suit,
yeah, in the compromise decree also it was not there.
compromise allo illa.
Illa.
Item number 13.
Only, that was the only item to be decided by the trial court. Rest of the other items are hit by section 6. Because all these transactions are prior to Amendment Act. And the compromise has taken place in the court. It is a judicial judgment that has been passed with regard to the partition. Though decree was not drawn, but still there is a judgment by the court itself, accepting the compromise and taking the signatures of the parties, and the court has passed an order. I am satisfied with the compromise. So in view of the compromise entered into between the party in the court, and that has been reflected in the revenue entries, therefore that partition has to be accepted. Even oral partition can also be accepted by virtue of the Vinita Sharma case.
Yes.
Therefore, 1 to 12, that has to be excluded. If at all, if the trial has to take place only in respect of item number 13 and nothing else. And further, my lord, what is the limitation point? The will is,
Whether this survey number 19/5.
yes, my lord,
According to him, not included in the
Yes, my lord.
compromise.
yes, my lord.
That is 8 guntas.
Yes, sir, that was not included.
Not
Not
included.
included.
Whether
Let
it
my
was-
learned friend
Whether
put
it
it.
was included in the will?
No, millets.
No.
No, not included in the will, even in the call, the earlier plaint also.
That was the only,
19/5.
Other,
As
that was the,
8 guntas.
8
yes,
guntas.
my lord.
In survey number, is list number 13, what is the extent? Item number 13?
3 acres,
No, that is not the
32
case.
guntas, millets.
No, that is not the case. 1
3
minute,
acres, 22 guntas.
32 guntas.
1 minute, my lord.
But plaint, they have mentioned 16,
Millard,
3 acres,
no,
16
Millard,
guntas.
May I just,
As per the mutation extract, 3 acres, 32
may
guntas.
I clarify? He is misleading again.
No, sir,
Item-
why, sir, unnecessary,
item
you are
number
using the
30.
word, I can't
You are
understand.
using the
My
word.
lord, item number 13, my lord.
Every time you are,
Total extent,
It is shown as, it is shown, my lord, it is shown as survey number 19/5. That client may kindly be gone through.
8 guntas ante.
8 guntas. Adonde property ne that is excluded in all the earlier transactions.
Is item number 13 mata?
3 acres,
One
32
nimsham.
guntas. millets.
That has been included as item number 1. That is 50, survey number 50/1. That has been shown as item number 1.
Item number 13 ಅಂತ ತೋರಿಸಿದೆ.
ಒಂದ್ ನಿಮಿಷ.
ಇವ್ರು ನಮ್ plaint ಅಲ್ಲಿ ರೆಫರ್ ಮಾಡ್ತಾ ಇದಾರೆ.
ಒಂದ್ ನಿಮಿಷ. ಇವ್ರ ಪ್ಲೈಂಟ್ ನೋಡ್ತೀನಿ ಸ್ವಾಮಿ.
Old plaint ಅಲ್ಲಿ.
ಓಲ್ಡ್ ಪ್ಲೈಂಟ್ ಅಲ್ಲಿ ಒಂದ್ ನಿಮಿಷ.
ಸರ್ವೆ ನಂಬರ್ ಇಲ್ಲ.
ಒಂದ್ ನಿಮಿಷ. ಸರ್, ಪ್ಲೀಸ್ ಡೋಂಟ್ ಕನ್ಫ್ಯೂಸ್ ದ ಕೋರ್ಟ್.
ಕನ್ಫ್ಯೂಸ್ ಅಲ್ಲಿ ನಿಮ್ಗೆ ಸರಿಯಾಗಿ ನೋಡ್ಕೊಂಡು ಹೇಳಿ ಅಂತ
ಇವ್ರು
ಹೇಳ್ತಾ ಇದೀನಿ ಅಷ್ಟೇ. ನೀವು ಸುಮ್ನೆ ಯಾಕೆ ಹೇಳ್ತೀರಿ ಅನ್ನೆಸೆಸರಿ ನೀವು? ಈಗ ಸರ್ವೆ ನಂಬರ್ ಇದ್ರೆ ಹೇಳಿ ನೀವು, ನಾನು ಬೇಡ ಅಂತ ಇರ್ತೀನಿ.
ವಿಚ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಈಸ್ ರೆಫರಿಂಗ್ ಟು ಐಟಮ್ ನಂಬರ್ 1 ಸ್ವಾಮಿ. ಕ್ಲೈಂಟ್ ಕೊಡು.
ಈಗ ಅರ್ಲಿಯರ್ ಸೂಟ್ ಇದೆಯಲ್ಲ, OS ನಂಬರ್ ಎಷ್ಟದು?
4025/352
ನಾ?
352/93.
ಒಂದ್ ನಿಮಿಷ, ಆ ಕ್ಲೈಂಟ್ ತಗೊಂತೀನಿ ಸ್ವಾಮಿ ನಾನು. 352 ನಲ್ಲಿ ಆ ಸರ್
ಪ್ರೆಸೆಂಟ್ ಸೂಟ್ ನಂಬರ್ ಏನು?
45/2008. ಅದರಲ್ಲಿ ಐಟಮ್ ನಂಬರ್ 8 ಮಾತ್ರ, ಒಂದೇ 8 ಐಟಮ್ಸ್ ಮಾತ್ರ ಹಾಕಿದ್ದಾರೆ ಇವ್ರು ಕೇಸ್. 45
ಇದರಲ್ಲಿ 8 ಐಟಮ್ಸ್ ಇದೆ.
ಓನ್ಲಿ 8 ಐಟಮ್ಸ್. ನಾನೊಂದು ಇದೇ ಕೊಟ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ, ಒಂದು ಟೇಬಲ್ ಕೊಡಪ್ಪ. ಮೇ ಜಸ್ಟ್ ಪಾಸ್ ಇಟ್ ಆನ್ ಪ್ಲೀಸ್.
10 ಐಟಮ್ಸ್ ಹಾಕಿದೀವಿ, 8 ಐಟಮ್ಸ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಕ್ಲೈಂಟ್ ಕಾಪಿ ಇದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ದಲ್ಲಿ. 10 ಐಟಮ್ಸ್ ವಿ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ದಿಸ್ ಸೂಟ್.
ಒಂದ್ ನಿಮಿಷ.
ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ 10 ಐಟಮ್ಸ್.
ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಏನಾದ್ರು ಆಡ್ ಮಾಡಿದ್ರಾ?
ಕ್ಲೈಂಟ್ ಇದೆ, ಕೆಳಗಡೆ ಕೋರ್ಟ್ ನಿಂದ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ. ಕ್ಲೈಂಟ್ 10 ಐಟಮ್ಸ್
ಎಲ್ಲ ಹೊಡೆದಾಕಿ ಆಮೇಲೆ ಡಿಲೀಟ್ ಮಾಡಿದಿರ ನೋಡಿ ನೀವೇ.
ನೀವು ಸರಿಯಾಗಿ ನೋಡ್ಕೊಂಡು ಹೇಳ್ದಿರ.
ನೋಡ್ಕೊಂಡಿದೆ, ಮಿಕ್ಕಿದೆಲ್ಲ ಡಿಲೀಟ್ ಮಾಡಿಸಿದಾರೆ ಸ್ವಾಮಿ ಇವ್ರೆ. ನೋಡಿ ದಯವಿಟ್ಟು ನೀವು.
ಅಲ್ಲ ಸರ್, ಡಿಲೀಟ್ ಮಾಡಿರೋದು ಬೇರೆ ಪ್ರಶ್ನೆ. ಎಷ್ಟು ಐಟಮ್ ಹಾಕಿದೀವಿ ಅನ್ನೋ ದಟ್ ಇಸ್ ಟು ಬಿ ಕ್ಲಾರಿಫೈಡ್.
8 ಐಟಮ್
10 ಐಟಮ್ಸ್ ಇದೆ ಕ್ಲೈಂಟ್ ಅಲ್ಲಿ.
ಒಂದ್ ನಿಮಿಷ. ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ 3 ಐಟಮ್ ನ ಡಿಲೀಟ್ ಮಾಡಿಸಿದ್ದಾರೆ. 1 ರಿಂದ 8 ಮಾತ್ರ ಇದೆ ಸ್ವಾಮಿ.
ಒಂದರಿಂದ 8 ಎಂಟನೇ ಐಟಮ್ 19/5 ಇದೆಯಲ್ಲ ಸ್ವಾಮಿ, ಅದೊಂದು ಮಾತ್ರ ಯಾವ್ದ್ರಲ್ಲೂ ಇಲ್ಲ. If at all, if the trial has to take place only in respect of this particular survey number.
ಅಂದ್ರೆ 8 ಗುಂಟಾಸಿಗ್ ಮಾತ್ರ ಅಂತ
ಅಷ್ಟಕ್ಕೆ ಮಾತ್ರ ಸ್ವಾಮಿ.
ನಿಮ್ಮ ಪ್ರಕಾರ?
ಹೌದು. ಇವ್ರು ಹೇಳೋ ಪ್ರಕಾರ ಸರ್ವೆ ನಂಬರ್ ಇಲ್ಲ ಅಂತ ಏನ್ ಹೇಳ್ತಾರೆ, ಅದು 50/1. ಇವರು ಐಟಮ್ ನಂಬರ್ 1 ಅಂತ ತೋರಿಸ್ತಾ ಇದಾರೆ. ನಾನು ಟೇಬಲ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಒಂದು ಟೇಬಲ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ನೋಡ್ಬಿಟ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ.
50/1 3 acres
ಹೌದು
16 ಗುಂಟಾಸ್ ಅಂತ.
ಹೌದು, ಅದನ್ನ ನಾವು ಕ್ಲಾಸ್ ಇದು ಎಲ್ಲದ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದೀನಿ. 50/1 ಅಲ್ಲಿ ವಿಲ್ಲಲ್ಲಿ ಐಟಮ್ ನಂಬರ್ 1, ಕಾಂಪ್ರಮೈಸ್ ಪೆಟಿಷನ್ ಐಟಮ್ ನಂಬರ್ 13, OS ಐಟಮ್ ನಂಬರ್ 1. ಇವ್ರು ಹಾಕೊಂಡಿರೋ 45/2008 ಅಲ್ಲಿ ಆ 3 ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಕೊಡ್ತಾ ಬರ್ತಾ ಇದ್ದೀನಿ. ಅದರಲ್ಲಿ 3 ಐಟಮು ಎಕ್ಸಿಸ್ಟೆನ್ಸೇ ಇಲ್ಲ. 8, 9, 11 ಬೋಲ್ಡ್ ಮಾಡಿದ್ದೀನಿ ನೋಡಿ ಸರ್. ಆ 3 ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ಅಲ್ಲಿ ಇಲ್ಲ. ಮಿಕ್ಕಿದೆಲ್ಲ ಪ್ರಾಪರ್ಟಿಗಳು ಇಲ್ಲಿ ಪ್ರತಿಯೊಂದು ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಕೊಡ್ತಾ ಬರ್ತಾ ಇದ್ದೀನಿ. ಇವರು ಕೋರ್ಟ್ಗೆ ಮಿಸ್ಲೀಡ್ ಮಾಡೋ ಪ್ರಯತ್ನ, ಇವ್ರೇನು ಅಂದ್ರೆ ಸರ್ವೆ ನಂಬರ್ 50/1 ಏನಿದೆ ಅದನ್ನ ತೋರ್ಸೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ದಟ್ ಈಸ್ ಇನ್ಕರೆಕ್ಟ್. ಮೆಜರ್ಮೆಂಟು ಶೆಡ್ಯೂಲು ಎಲ್ಲ ಟ್ಯಾಲಿ ಆಗ್ತಾ ಇದೆ. ತ್ರೀ ಎಕರ್ 33 ಗುಂಟಾಸ್ ಏನಿದೆ ಸರ್ವೆ ನಂಬರ್ 50/1 ಅಲ್ಲಿ, ಅದು ವಿಲ್ಲಲ್ಲೂ ಇದೆ, ಕಾಂಪ್ರಮೈಸ್ ಪೆಟಿಷನ್ ಅಲ್ಲೂ ಇದೆ, OS ಐಟಮ್ ನಂಬರ್ 1 ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ. ಎಕ್ಸೆಪ್ಟ್ ಇವ್ರು ತೋರಿಸೋ 8ನೇ ಐಟಮ್ ಬಿಟ್ರೆ ಮಿಕ್ಕಿದ ಯಾವ ಪ್ರಾಪರ್ಟಿನೂ ಅಲ್ಲಿಲ್ಲ ಸರ್. ಆಲ್ ಅದರ್ ಪ್ರಾಪರ್ಟೀಸ್ ಆರ್ ಹಿಟ್ ಬೈ Section 6 of the Hindu Succession Act.
That's one more submission. With regard to this item is concerned.
Let me complete. ಒಂದೇ ಒಂದು ನಿಮಿಷ. ಅವರು ಪ್ಲೈಂಟ್ ಅಲ್ಲಿ they have admitted everything. Even execution of the will, execution of the compromise petition, everything is admitted. May I request your lordship to kindly have a look at that plaint for a while, please. 2-3 paragraphs. Plaint 45. Para 3. It is submitted that original propositor 1 Patnuru Muniappa had a son by name Gopalappa, and he had 2 sons and 3 daughters, namely Krishnappa, Naranappa, first dependent, and Jayalakshmamma, Muniamma, and Akkayamma. Dependent number 2 to 4 are the purchasers. Plaintiff and the first dependent are belongs to the one genealogical tree, and that is governed by Hindu law. It is submitted that this para said Kotnur Muniappa has possessed several ancestral described in the schedule under all the properties are situated at Bagluru, Bayappanalli, and Chalgatte comes within the jurisdiction of Jalahobli. The said properties which are more particularly described in the schedule hereunder and here. This paragraph is important. It is submitted that father of the plaintiff is mentally not good. Because of the above said reason, the grandfather of the plaintiff said Kotnur Muniappa during his lifetime he had executed a registered will in respect of the ancestral properties in favor of his grandchildren, that is first dependent, and his brother Krishnappa, jointly dated 18/2/1951. After the death of plaintiff's grandfather and father, the first dependent and his brother Krishnappa, including plaintiffs, were enjoying all the suited properties jointly, and they are all constituted Hindu joint family. Thereafter, due to misunderstanding arises between first dependent and his brother Krishnappa in respect of suited properties, said Krishnappa had no marriage. Subsequently, due to misunderstanding, he had filed a suit in OS 352 of 93 before the civil judge. Thereafter, both the parties were agreed by the compromise and accordingly filed the compromise petition dated 18/10/1985. In the said compromise, the property allotted in favor of said Krishnappa is survey number 285/1, measuring to an extent of 2 acres 9 guntas, and the house property. After his death, house property was transferred to the first dependent, and the remaining suited properties are mentioned in the plaint are given to the first dependent. This is the admissions. Will ಬಗ್ಗೆ knowledge ಇದೆ, partition deed ಬಗ್ಗೆ knowledge ಇದೆ. Then when they filed it in the year 2008, what should happen to the limitation, please? All registered deeds have to be questioned within 3 years from the date of the execution of the deeds. Will is of the 51, the sale deeds of the year 1987, and they are questioned in the year 2008. They have the knowledge of execution of the will. They have the knowledge of the execution of the compromise decree. And when they have questioned it? In the year 2008. Observation of the appellate court, my lord. The appellate court has gone to the extent of saying that by virtue of the amendment of section 6,
all the transactions which have taken place much prior to that particular date of amendment can be questioned if there is illegality. Where is that classification that has been made in the Amendment Act, my lord? It has not been said if it is illegal and if it is invalid, that can be questioned. That is not the section. It only says if the transaction has happened much prior to amendment, then that has to be saved. That's it. This section has made no classification, but the appellate court has made such a classification which cannot be acceptable. My lord, may just pass it on this mutation entry, my lord, because after the passing of the judgment, these revenue entries have been entered into.
judgment admel.
Also,
Just I'll clarify with regard to
Yes,
my
counsel.
pleadings are concerned, just few minutes. What my learned friend has, the plaintiff governments are concerned. That plaintiffs came to the knowledge of all these documents prior to filing of the suit in the year 2007. Not that in the year 1951, we came to the knowledge that prior to filing of the suit, I have stated in the plaint, the cause of action accrued to the plaintiffs are concerned. In the first week of December 2007, they came to the knowledge of all these documents, that the will and the subsequent transaction, that the first defendant, that is the appellant herein, is trying to alienate the properties immediately when they have demanded for partition. Then they came to the knowledge of all these will and subsequent documents. Then they have pleaded that these are the will and subsequent documents. Then the suit came to be filed by the plaintiffs for the trial court. Not that 1951 they came to the knowledge and the limitation is concerned. Now the other the question is, Lordship, my learned friend, as with regard to survey number 50 is concerned, 3/60. Lord, kindly, this old plaint is in the trial court record. There is no mentioning of survey number 50/1, even in their own plaint.
But whether extent is mentioned?
Extent 3 acres, 16 guntas has been mentioned. But there is no survey number.
3 acres?
16 guntas has been mentioned, but no survey number. And in the compromise petition, there is no survey number, just item number has been mentioned. In the mutation extract, I have produced, the extent is 3 acres, 32 guntas of land. That is along with the trial court, I have produced the mutation extract. The 50/1, the extent shown is 3 acres, 32 guntas of land. Transferred through inheritance in favor of this Narayanappa is considered. Friends, now the question is, plaint can't be rejected partly or plaint cannot be rejected. The few items. The plaintiffs have made out a case to go on with the trial, and they have to establish before the case, before the trial court, whether they are entitled for partition. Now the subject matter in all the the entire cases with regard to the execution of the will by the Muniappa. Now that will, how this Muniappa has right to alienate the property, that is, that has to be proved during the course of trial. Therefore, order 7 to 11 is concerned. The appellate court has rightly held that the properties are ancestral properties.
Yes,
And we have a right over the properties.
only one line, my lord, only one line.
No reply to reply, counsel? Heard, reserved. ಎಲ್ಲ ಆಯ್ತಾ ಮೇಡಮ್ ರಿಮೈನಿಂಗ್ ಎಲ್ಲ
107.
107 ಬರ್ತಾರೆ ಅಂದ್ರೆ
I'm sorry, my lord, I was not present because
ಯಾವಾಗ ಬೇಕು ಹೇಳಿ 4:45
tomorrow, my lord.
No tomorrow. For want of time, list this matter on 22/7.
Interim order of status court.
Interim order ಇದೆಯಾ?
ಇದೆ.
Interim order is extended till next date of hearing.
Please.
Both counsels are present ಅಂತ ಹಾಕ್ಬಿಡಿ. ಅದಾರ KV ನರಸಿಂಹನ್ ಮತ್ತೆ
Please, my
ಇನ್ನಾರು
lord. Yes, my lord, I am there, my lord, on the.
ಇದು ಅದರೊಳಗಡೆ ಸೈಟೇಷನ್ಸ್ ಗಿರೀಶ್ ಶರ್ಮಾ.
We don't count, that's the reason. It is there, we all have to start.
66 and 71. 66 and 71. ಹಾ 71. ಏನು ಕಾಸ್ಟ್ ಏನಾದ್ರು ಹಾಕಿದಾರ? ಕಾಸ್ಟ್ ಏನಾದ್ರು? ಹಾ ಓಕೆ. ಥ್ಯಾಂಕ್ ಯು.
ಸರ್ ಏನು ಆನ್ ಆಗ್ತಾ ಇಲ್ಲ ಇದು ಎಲ್ಲ ಆಫ್ ಮಾಡಿದ್ರಾ ಪ್ರಿಂಟರ್ ಕನೆಕ್ಟ್ ನಾ
ಅಳ್ತಾ ಇದ್ಲ ಕೊಂಡಿದ್ದಪ್ಪ ನೀರು ತಿನ್ಕೊಳ್ತು
ಏನಕ್ಕೆ ಸರ್
ಫೋನ್ ಬಂದಿತ್ತು.